The acting attorney general of the United States is scheduled to testify before Congress this morning and defend his role in the Trump administration. Matthew Whitaker is expected to appear before the House Judiciary Committee in a half hour at 9:30 Eastern Time. This is live coverage from the Washington Post. I'm Libby Casey. House Democrats are using their new power in Congress to grill the acting attorney general. They want answers about Whitaker's decisions and conversations he may have had with the president about the special counsel investigation. I'm joined in our studio by Matt Zapotosky, national security reporter covering the Justice Department, and Aaron Blake, senior political reporter and writer for The Fix. We'll bring you this morning's hearing live and uninterrupted. So first of all, 15 hours ago, we weren't even sure if we were going to be having a hearing this morning because Matthew Whitaker said he didn't plan to show up. This is a battle over just how far Democrats can push their power and get answers. So why is Matthew Whitaker deciding to come today, as far as we know at this point, Matt?
Well, he didn't exactly say, I'm not going to show up, period, end of story. Democrats were holding this threat of a subpoena over him to answer questions about his conversations with the president. And Whitaker is concerned that could implicate concerns about executive privilege. Essentially, he can't say what the commander-in-chief told him privately. So he, at the 11th hour yesterday, says, look, as long as this threat is over my head that you could subpoena me if I won't answer questions about my conversation with the president, then I'm probably not going to come.
Democrats have pushed this because the chairman of this committee had a vote yesterday and said, we're going to issue a subpoena if tomorrow the acting attorney general shows up here and won't answer questions, we're going to be able to use our subpoena power. So
they were very transparent.
Yeah, that then pushed the acting attorney general to say, that's not, I don't feel comfortable with that scenario. So we understand they were able to hash things out last night.
Right. Essentially, the acting attorney general was saying, this is bad faith. You don't do this to cabinet secretaries, and under this threat, I'm not appearing. So then the Dems responded and said, look, we won't issue a subpoena essentially today or tomorrow, because that's what Whitaker was asking. He wasn't saying you can never subpoena me. It was like, don't hit me with a subpoena right at this hearing or the day after. We can talk about it. I mean, the cynical view of why he would be doing that is he's not going to be the attorney general next week. And once he's out, who cares about him? But so the Democrats took that off the table. There was kind of negotiations into the night, and at least as of 9:02, he is set to show up.
And it's worth emphasizing that this set of circumstances is unusual. The fact that the House Judiciary Committee chairman would be threatening a subpoena before somebody who has voluntarily agreed to come testify, hanging that subpoena over them before the hearing is unusual. Generally speaking, this has been something that has been part of negotiations beforehand, but it's not saying I am going to subpoena you if you don't say certain things. That said, the Judiciary Committee chairman, Jerry Nadler, has said basically during the Trump administration, we had a series of cabinet officials come to Capitol Hill and testify and not invoke executive privilege, but not answer questions by saying the president might invoke executive privilege. So he's basically saying, given that, what's happened the last 2 years with that, this was a step that was required, and really he's setting the stage for what could be a whole series of subpoena fights, a whole series of fights over exactly what these cabinet secretaries can say in these hearings now that the Democrats control the House.
Obviously, Democrats on this committee want answers to very specific questions. Republicans may want some answers to questions, too, about lines of investigation they want to pursue. But let's take it out of their hands for a moment and look at big picture in terms of this being a litmus test or a first run out of the gate for Democrats to flex their muscles as the new power in the House. Aaron, how symbolic and how significant is this hearing?
It's going to set the tone. They have a series of committees that are going to be handling various investigations of the Trump administration: House Intelligence Committee, Oversight Committee, Judiciary Committee. Judiciary, by the way, is the one that would be charged with impeachment if it ever did come about. And Jerry Nadler is going to be a very significant figure in this. He is a guy who has credibility with leadership. He's also been very tough on Trump in a way that maybe some other Democrats have been a little bit reluctant to. And I think that the machinations over the past couple weeks here, which began with him sending Whitaker a letter saying, basically giving him the questions and saying, do you want to invoke executive privilege on any of these things? He's been very carefully setting the stage for this, preparing for a subpoena fight that might come out of this hearing, preparing for basically something that could set the precedent for what might happen in these future situations in which cabinet secretaries have to testify.
Our reporter Rhonda Colvin is live on Capitol Hill. Let's go to Rhonda. Rhonda.
Thanks, Libby. Yes, I am here in the Rayburn House building. This is where the committee will hear from Acting AG Whitaker soon, in less than a half an hour. As you guys mentioned on the set, there has been a lot of suspense building since last night when he said he will not testify if that subpoena threat isn't taken away. And of course, the chairman of this committee, Jerry Nadler of New York, sent him a note, a letter in response saying, you know, if you answer these questions tomorrow, there will be no need to have a subpoena. So we are expecting House members of the committee to pass by us shortly to get into the hearing room. We've also been struck too to see that there are members of the public who are here. They're interested. They're curious to see how this is going to go down today. We were here around 6:30, 7 a.m. today, and we met a woman at the front door waiting to get in saying she just wants to see what happens. So there is a lot of suspense. If he's going to show up, it's likely that he will. There's also suspense in what he might say, what he might reveal that we don't know yet, and that's what's happening here on Capitol Hill right now. As you see, people behind me are lined up. There's a security presence as well, so we will stick here until we see what's going on. So back to you, Libby.
Thanks, Rhonda. Let's talk about subpoena power. Okay, so Matthew Whitaker can say, I'm not going to answer that question because of executive privilege. He doesn't have the executive privilege, right? This is the president's privilege.
Right.
So he can say, kind of shut down the line of inquiry by saying that's a conversation I had with the President of the United States.
This is a super complicated issue, and it's why Nadler was trying to get ahead of it. Essentially, yes, the President of the United States can say, I don't want you to answer that question because of executive privilege.
Or I might not want you to answer that
Well,
question.
that is what Nadler wanted to get around. Jeff Sessions kind of did the same thing. The President might want to invoke executive privilege on this topic, so I want to sort of preemptively not answer that. And then the issue just kind of goes away because Congress doesn't pursue a subpoena. You never sort of force him to answer. Nadler wanted to get ahead of that. Hey, these are the questions I'm going to ask. So you go to the President, you figure out which of these he wants to invoke executive privilege on. That's fine. We can then maybe fight about those, and we'll ask the others in public. Whitaker kind of dodged that by waiting until the last minute and saying, hey, I'm not going to show up with this subpoena threat. Now he is showing up. His opening statement is out now, and he's sort of reiterating there are going to be topics that are covered by executive privilege. I'm not going to be talking about my conversations with the President. It could spawn a fight later. What Democrats could do is say, look, we want you to get a specific determination from the President. You can't answer that question. You can't sort of just invoke this general notion, and that would require a subpoena that could be tied up in court for a long time. I'm not so sure it would much matter once Whitaker is gone, or what the appetite would be for Democrats to force the issue, but that's why Nadler was trying to get ahead of things. He wanted Whitaker to say in advance, yes, this question, no, this question, no, this question, because the President has stopped me, and then they could litigate those.
And that could, interestingly, the fact that Nadler gave him those questions 2 weeks beforehand, and the fact that Whitaker actually didn't respond by the deadline 2 days ago, that could potentially play into a court fight over the subpoena. Basically, Nadler can say, look, I gave him every opportunity in the world to tell me what he was not going to be able to talk about, and then he didn't tell me, so I had to do this subpoena when he clammed up at this hearing.
This letter that you're both talking about, we have it here. The copies have been distributed. This is dated January 22nd, and it was sent to the Acting Attorney General from Chairman Nadler, outlining a list of questions he had, very specific to some degree, questions he had about conversations that he might have had with the President or the President's private attorneys, some of the backstory of how they were treating the special counsel investigation. And as you both point out, he asked that if Whitaker planned to invoke executive privilege, he had to give the committee 48 hours notice. We were all watching this week to see if that deadline would be met in some way. It came and went, and so that then seemed to escalate things as Chairman Nadler decided to push for subpoena power yesterday, Matt.
Yeah, that's right. I mean, and Chairman Nadler didn't seek a subpoena. He just sort of got the ability to seek a subpoena. But Matt Whitaker was saying, even operating under the threat of that is bad faith. You don't do that to cabinet secretaries. Let's have the hearing. If I can't answer questions, we can, after the fact, kind of litigate, hey, and I don't mean litigate in court, but like negotiate between the two of them. Hey, I can answer this, I can't answer this, we could go to the President. But Whitaker knows he's going to be out of the job. I mean, that's sort of the important factor here. Whitaker knows very likely next week William Barr is going to be confirmed as the next Attorney General, and it won't be his problem anymore.
So Barr cleared the Senate Judiciary Committee yesterday along a party line vote, and we do expect his nomination to go before the Senate next week, Aaron.
Right.
It doesn't seem to be any hiccups. We already see at least one Democrat, Doug Jones, willing to support him.
Yep.
So how relevant is Matthew Whitaker?
I think he's most relevant in potentially two ways. One is what we've been talking about, the precedent that this is going to set for future subpoenas, future cabinet secretaries who are going to be testifying. I think they keep pursuing this after the hearing if they need to, just to set that precedent, figure out exactly what the courts are going to say about what they can compel these cabinet secretaries to say. The other thing is, I think that this is a situation in which Matthew Whitaker, we don't really know a whole lot about him because he doesn't speak publicly very often. He hasn't, he was a cable pundit, and we were talking about this before. He was a cable pundit on CNN, but he hasn't been giving interviews. He gave a press conference a couple weeks ago in which he kind of stumbled into talking about how the Mueller probe was almost over. He gave a very uncertain answer about that. This is not the guy with your traditional pedigree for an attorney general. There's a real question about whether he brings the gravitas, whether he is going to be prepared for this hearing. This could be big if he winds up stumbling, if he shows kind of some of the uncertainty that we've seen in that appearance from a couple weeks ago and that some people expect based upon his background.
Let's show a clip from that very interaction, that press briefing that he gave, because it ended up revealing quite a bit about both his ability to sort of face the press and also about some of his thoughts on the Mueller investigation. Watch this.
I've been fully briefed on the investigation, and I look forward to Director Mueller delivering the final report. And I really am not going to talk about open and ongoing investigation otherwise, but sort of the statements that I made were as a private citizen, only with publicly available information. And I am comfortable that the decisions that were made are going to be reviewed, either through the various means we have. But right now, the investigation is, I think, close to being completed, and I hope that we can get the report from Director Mueller as soon as possible.
You can almost imagine some of the other members of his team saying, "Stop talking, because a lot of maybe perhaps more seasoned people would have said, "I'm not going to comment on that," and then shut down the conversation. But he kept talking, Aaron. He didn't. It's not like he said a lot, but he did say some important things.
Sometimes you can see somebody in the middle of an answer, and you can see them pausing just for a second and saying, "Should I say this next thing I'm about to say?" And then they say it. That's what it looked like when he was saying this Mueller probe is almost over. He had said just 30 seconds before, "I can't talk about the Mueller probe," and then he said he thinks it's almost over.
And why is that significant?
Well, I mean, it could be guesswork on his part. He could actually know something. I don't know how significant it is beyond the fact that it seemed like he just kind of stumbled through that answer and didn't really seem to know exactly what he was going to say. It's very important for him today to know exactly what he wants to say when he's asked a bunch of questions, because he's going to be up there for a while. These Democrats are going to want to make a point. They're going to want to make this a show. They're going to want to try and break him down and get him to say something that he shouldn't say. And I'm not so certain that that was the biggest gaffe in the world, but if he is not going to be studied, if he is not going to be consistent and stick to the script that he has been apparently practicing behind closed doors for this hearing, that's where he could wander into some trouble.
Why was it so significant that he said that the probe was coming to a conclusion?
Look, he's the Attorney General of the United States. He is in charge of that probe. Now, in the beginning of that answer, he said, "I've been fully briefed," so he certainly knows. Now, what exactly close means? Is that weeks? Is that months? Is that a year? That's unclear. Is that his impression, or did someone actually use that word with him? In other words, like when he was briefed, did he kind of just get the sense we're nearing the end? But knowing that we're near the end of the Mueller investigation is a significant thing, and this is a guy who would know, who has been fully briefed on the case and is supervising the case because he's declined to recuse himself despite his sort of past public criticism of the probe. So I thought it was really significant. I know from reporting that he didn't mean to say that. It's not as if he set out in this press conference about a totally unrelated thing to say, you know what, I'm going to overshadow this criminal indictment we have that's major in a different way by revealing that we're near the end of the Mueller probe. I do know that he didn't mean to say that. I sort of agree with Aaron, though. I don't know that it's the biggest gaffe in the world, because what does close mean?
It did, I think, whet Democrats' appetite, though, to get him before a committee so they can ask him questions and see if they can extract any more information from him. Let's talk about who sits on this Judiciary Committee, and it's a sprawling committee. We've got about 40 people who sit on this committee, more Democrats than Republicans, because Democrats hold the majority in the House. Who stands out to you, Aaron, as you look at this list of members, people that you'll be watching?
Well, we talked about Jerry Nadler, the chairman, who is going to be guiding this whole thing. This is really going to be his big public debut. I think that he is going to be a very significant figure moving forward, not just in this hearing, but in general. Ted Lieu of California, Eric Swalwell of California, people who are very much pursuing bigger profiles, are very sharp on issues. Hakeem Jeffries could be, is moving up the ladder in the House Democratic Party, will be somebody I'm looking at. Ted Deutsch, Democrat from Florida, will also be significant. On the Republican side, the ranking member, Doug Collins, interestingly this week, has been pushing back publicly against this subpoena effort that Nadler is pursuing here. It's interesting to see the two, respective leaders of this committee clashing so early in their new reality in a Democratic-controlled Washington. So I would imagine that Doug Collins, the ranking member, is going to be ready to push back if and when Nadler does, and I expect at some point it'll happen, when Whitaker says, I'm not going to answer that question, and Nadler says, okay, we're going to maybe subpoena you later, Collins could, maybe jump in and push back on that.
What will you be watching for, Matt, from
So
this committee?
it's the Democrats, I think you covered pretty well. I think one interesting Republican here is Jim Jordan. This is a guy who wanted to subpoena Rod Rosenstein, and now he's kind of on the other side of the aisle. I think as a part of this subpoena fight, some Republicans here thought, well, maybe we can get Rosenstein while we're at it, too. They have all these qualms about the way he's handled the Mueller probe in a totally different way than the Democrats have qualms about Matt Whitaker's supervision of the Mueller probe. So I'll be curious to see, how he walks this line. This is a guy who he says he wants to hold Justice Department officials' feet to the fire, but this is a guy who's much more aligned with the president. Matt Whitaker is. What does he do with Matt Whitaker?
And Jordan and others were bringing that up yesterday, saying, all right, you want to start the subpoena game? Like, we'll rope in even more people.
And they've long been wanting to subpoena Rod Rosenstein. They see that as a way of exposing great Mueller wrongdoing, in a different way the Democrats see protecting Mueller and forcing Whitaker to answer questions about what the president has said to him about Mueller.
You mentioned that we've gotten a sense of what Matthew Whitaker plans to say in his opening statement. Here's an excerpt from this. He's going to say that, and we're anticipating that he says that, although I can't speak about my communications with the president, I do want to make clear that I am personally committed to the integrity of the Department of Justice, and there has been no change in the overall management of the special counsel investigation.
So I think what he's referring to there is that Rod Rosenstein is still around. Rod Rosenstein is the Deputy Attorney General, the number 2 official in the Justice Department. Because Jeff Sessions, the former Attorney General, was recused, he's the guy who appointed Mueller, and he's the guy who supervised Mueller for the whole time Jeff Sessions was the Attorney General. Then Matt Whitaker steps up, and there's this great question. What becomes of Rod Rosenstein? Does he kind of stay in his supervisory role? The Deputy Attorney General kind of runs the day-to-day of the department, so that would make sense. Or does Matt Whitaker totally take that over? This is a sensitive investigation. You don't want too many cooks in the kitchen. And that would have alarmed Democrats, I think, a little bit more because Matt Whitaker had been publicly critical of the probe. He's much more sort of closely aligned with Trump, even though Rosenstein is a Trump appointee, too. So I think that's what he's referring to when he says the management hasn't changed. And also, he hasn't taken any steps to impede Mueller's work, I think, is what he's getting at. The Democrats had great fear about that. They had great fear that him being kind of Trump's guy Trump really likes, Trump would say, hey, get in his way, and Matt Whitaker is trying to say in that opening statement. That didn't happen. I don't think that's going to satisfy Democrats because that's so vague. They want to know, did the president tell you to do anything? What was your response to that? And clearly he's not going to get into answering that.
We did get a sense from the letter that Chairman Nadler sent a couple of weeks ago to Matthew Whitaker, what's on his mind. And a lot of it has to do with conversations that Whitaker may have had with the president, members of the White House staff, or the president's private legal counsel. Aaron, can you point out some of the questions that you found to be particularly striking, whether it comes to digging into the Mueller probe or whether it comes to, he was even bringing up the BuzzFeed News story about the Cohen case and about whether the president asked Cohen not to tell the truth to Congress. So it doesn't like we're getting a sense of what's on his mind.
Yeah, I think if I look at those questions, they kind of ran the gamut of all the different things that might be of interest here. I think one of the big things is going to be the recusal decision. Whitaker has talked about this to some degree, said, I believe, and Matt could correct me if I'm wrong, he said that there was not, Trump has said rather that he was unaware of what Matt Whitaker had said before. Were there conversations? Trump has kind of played off the idea that he even knew Matthew Whitaker before he appointed him to this job. I think there's going to be, it's not just going to be about what Matthew Whitaker says, it's going to be about whether what Matthew Whitaker says squares with what the president said about his elevation to the acting attorney general. And also, by the way, an interesting comment speaking of interesting comments from the president, what he said a couple days ago in an interview about how he likes having acting cabinet officials because it allows him to move people in and out more quickly. I think that's Democrats are going to try and drive that point home in some fashion because Whitaker is maybe the emblem of the idea of appointing unqualified or unsavory acting cabinet officials to fill these jobs for a few months.
Yeah, it's such an interesting point that you make. This question of recusal, a DOJ ethics official recommended that Whitaker recuse himself from overseeing the Russia probe. He elected not to. Do you expect that to be a big line of inquiry today?
I certainly hope it is. I mean, I think all of these questions about conversations with the president, Whitaker is going to deflect, but this is one he said he's willing to answer questions about. And there's so many questions I have. I mean, the actual ethics officials in the department said, hey, just because of the appearance here, we would probably advise that Matt Whitaker, you step aside. They were never asked, though. He did this very weird thing that's outside of anything I've ever seen in the Justice Department, and some of my colleagues who are more veteran at covering the Justice Department have ever seen. He assembled like a personal team of ethics advisors to advise him on this question. They interfaced with kind of the actual ethics officials, and they came to the conclusion, nah, you don't need to step aside. It's just such a weird process that's outside of Justice Department norms. I think he really has some tough questions to answer, and unlike with his conversations with the president, he's indicated he is willing to answer those. I'll be curious how he kind of explains that in a way that's satisfactory to Democrats.
Following up on that, the letter from Chairman Nadler also gets at when Whitaker decided not to recuse himself, did he consult with the White House as he made that decision? Did this team of advisors consult with the White House or have conversations with the White House?
And remember, the big source of President Trump's frustration with Jeff Sessions was the recusal, the fact that Jeff Sessions recused himself from the Russia investigation. We saw in William Barr's confirmation hearings a few weeks ago that he said that he made no promises, nor did the president ask for anything as far as assurances. That would, we would assume that would include potential recusal demands. I think with Whitaker, the Democrats are going to try and figure out whether there was any conversation about that beforehand, and two, whether there was anything maybe unspoken about that, or whether he even just kind of proactively offered some kind of an assurance about recusal. Because obviously this is something, if Matthew Whitaker comes into this job and he recuses himself right away, he's lining himself up for a lot of heat from the president, and if there's anything the last year has shown us, it's that.
And also it would have been like a guarantee that he wouldn't have been chosen as the Attorney General. He wasn't chosen as the Attorney General. Talk to us about Matthew Whitaker and how did he get to where he is, and why was he not chosen for that job?
Yeah, Matthew Whitaker is a former U.S. attorney in Iowa before he kind of came into the Justice Department space most recently as Jeff Sessions' chief of staff. He was a CNN pundit, commented on legal issues, kind of a conservative commentator, said a lot of things that are right in line with what President Trump would want, particularly on the Mueller probe. He was super critical of the Mueller probe. At one point suggested that an acting attorney general, which he would later become, could choke off Mueller's funding source and just like grind the investigation to a halt that way. So he's in conservative legal circles. Jeff Sessions is losing a chief of staff. There's some internal Justice Department drama, but also the guy is just wanting to go lead the civil division, which is maybe a more high-profile job than being the Attorney General's chief of staff. He's recommended to Sessions by Leonard Leo, maybe some others. Leonard Leo is a kind of Washington power broker who is super close to the White House. Interviews with Sessions. Sessions likes him. He becomes Sessions' chief of staff. He actually, as Sessions' chief of staff, staff kind of ends up getting closer to the White House than even Sessions, because President Trump hates Jeff Sessions. He hates that he recused. He doesn't want to see Jeff Sessions. He doesn't want to talk to Jeff Sessions, but he likes Matt Whitaker. Matt Whitaker is a big hulking guy, former football player. President Trump likes people who look the part. This guy looks like a big cop, you know? So President Trump approaches him late in Jeff Sessions' life as the Attorney General and says, hey, would you want to take over as Attorney General? Which is such a humiliating thing for Jeff Sessions, for the president to be asking his top aide, hey, would you potentially like to take your boss's job? Now, Whitaker would say, I didn't backstab anyone. What am I going to do? The president is approaching me. He gets along well with the president. When Jeff Sessions is fired after the most recent midterms, he taps Matt Whitaker to be the acting Attorney General.
And Chairman Nadler and Democrats are going to have questions about just what those conversations were like before Sessions left the job, was pushed out of the job, left the job as a much more graceful way. I mean, his time was essentially over at the White House.
Yeah,
the president had made his position clear.
I'd be curious to know, and Matt would know this a lot better, so maybe you can even answer the question. Would those conversations that took place before he was actually acting Attorney General be protected by, or could they attempt to assert executive privilege for them before he was actually in the job?
I think he could, because it's still, President Trump is still the president, right? And he's still a Justice Department official. I suspect he will too, mainly because those are awkward. Is there a legitimate executive privilege grounds on there? All that, like the others, I think is a legal
This is
question.
such a nuanced but really important question. Does your ability to claim executive privilege change when you're elevated from like the chief of staff or essentially the assistant to the Attorney General? When you go from that job to being the acting Attorney General, your position is elevating and changing, but there's still conversations with the president. So this is a legal question we're still trying to untangle.
Yeah, and Bill Barr was willing to talk about his conversations with Trump about the Attorney General job, and you could kind of view this in a similar way. The difference being Barr was outside of government, but Matt Whitaker inside of government, the Attorney General Chief of Staff, is having conversations with the president about becoming the Attorney General. Well, if Bill Barr can detail his conversations about becoming the Attorney General, why can't you? There's this added awkward dynamic that, he's Jeff Sessions' Chief of Staff, and, I'm just astounded that the president would go around his Attorney General to talk to his top aide about replacing him, but that's just how bad their relationship was at that time.
There are other questions that Chairman Nadler laid out in this letter he sent a couple of weeks ago that are about whether or not President Trump discussed firing or reassigning people who work for the Southern District of New York, the office of the U.S. Attorney for the Southern District of New York, someplace else that he has tangled with, obviously, that's been investigating Trump family businesses and such. So there are tentacles that are reaching out beyond just the Mueller probe, Matt. Other questions, whether or not Jeff Sessions had tasked another U.S. attorney to review Hillary Clinton's issues. So we may see other parts of this bear hug of investigations come up.
Yeah, I mean, being the Attorney General, you supervise a lot. The Southern District of New York thing, I think, is probably the most interesting thing here. CNN has some reporting that Trump upset over the Southern District of New York's investigations into the Trump world. We know they're sort of investigating things related to the inauguration. Recently, there was reporting on a subpoena for some of those, for some data related to some of those topics. CNN has reported that President Trump raged at Whitaker over that. Now, I don't think we've been able to confirm that, but I'll be curious, does he answer whether that's true or not? Does that covered by executive privilege because it's a conversation between Trump and Whitaker on these investigations of Clinton? We know that Jeff Sessions tapped this U.S. attorney out west to supervise reinvestigating a whole bunch of things that conservatives are irked about. Matt Whitaker indicated in his letter yesterday he might be willing to actually talk about some of those things. Now, if they're ongoing investigations, I'm sure he's going to say it's an ongoing investigation. I can't say much about that, but he might reveal something about those, and those are politically charged topics. People see those as like politically vindictive investigations, so I will be very curious what he says about those.
You see members of the committee, they're gathering. We just saw Congresswoman Lucy McBath. So many freshman rising stars in the Democratic Party are on this committee, just like all the other committees are sort of sprinkled throughout, and so we'll be seeing people like Congresswoman Veronica Escobar of Texas, Congresswoman Debbie Mucarsel-Powell of Florida. There's Matthew Whitaker, so many cameras waiting to take his image and capture this moment. And the dais, it's like a twofold dais full because there are about 40 members of this House committee. Matthew Whitaker, the acting attorney general, taking his seat now, and you can see Jerry Nadler, the chairman, there in the background of that shot. Let's go now live to the hearing of the House Judiciary Committee. We'll bring you live, uninterrupted coverage here from the Washington Post. I'm Libby Casey with Matt Zapotosky and Aaron Blake. Thank you. Appreciate both of your time. Let's go to the hearing room now.
The Judiciary Committee will come to order. Without objection, the chair is authorized to declare recesses of the committee at any time. We welcome everyone to this morning's hearing on oversight of the Department of Justice, and we welcome our witness, the Acting Attorney General of the United States, Matthew Whitaker. Before we turn to the business at hand, I want to take a moment to comment on the passing of our friend and former colleague, Chairman John Dingell of Michigan. Representative Dingell was elected to Congress in 1955 and went on to become the longest-serving member of Congress in the history of the United States, and by virtue of enduring accomplishment, one of the greatest. He was a presence in the hearing room, a determined investigator, and a true believer in congressional oversight. He loved the House of Representatives. We remember him for his humor, his charm, his unshakable integrity, and of course, his fantastic Twitter account. Our thoughts are with our colleague Debbie Dingell and the entire Dingell family. Chairman Dingell will be missed.
Mr. Chairman, could I just echo that as well, and for the, Mr. Dingell's service, and also with our colleague Debbie during this time, where our thoughts and prayers are with them and the service that he rendered. I'll agree with you on that.
Thank you. I will now recognize myself for an opening statement. Mr. Whitaker, I want to begin my remarks by commending the tradition of independent law enforcement at the Department of Justice. As you and I both know, it is the career officials at the Department, the FBI, and the U.S. Attorney's offices whose commitment to the rule of law protects our democracy. Given the focus of this hearing, I therefore feel compelled to single out for praise the career ethics officials who helped you transition into your role as Acting Attorney General. On December 20th, in a letter from the Department meant to justify some of the decisions we will examine here today, Congress learned the following, quote, "In a meeting with the Acting Attorney General's senior staff, ethics officials concluded that if a recommendation were sought, they would advise that the Acting Attorney General should recuse himself from supervision of the special counsel investigation, because it was their view that a reasonable person with knowledge of the relevant facts likely would question the impartiality of the Acting Attorney General," close quote. In other words, even though you apparently did not ask for their advice on this topic, these career officials went out of their way to tell you that your many public past criticisms of the special counsel's investigation were grounds for you to step aside. They insisted that your recusal would have been right for the department and good for the country. They gave you this advice with no guarantee that their jobs would be protected, 2 years into an administration distinguished for firing officials at the department and the FBI who offended the president. They did so knowing that Attorney General Sessions had just been removed for no reason other than following their guidance 2 years earlier. Their advice to you is an act of bravery. It is worthy of the best tradition of independence and integrity at the Department of Justice. But in my view, your conduct, including your decision to ignore important ethics advice when you became Acting Attorney General, no matter the consequences, falls well short of the mark. Before you joined the Department of Justice as Chief of Staff to former Attorney General Sessions, you were the sole full-time employee of the Foundation for Accountability and Civic Trust. The organization has been described by Republicans as, quote, a chop shop for fake ethics complaints, unquote, against Democratic politicians. FACT, as it is called, also funded your appearances in print and on cable television in the years leading up to your tenure at DOJ. These media appearances, and this is why this is relevant, have become the cause of much concern. 1 month before you joined the administration, you wrote a column titled, quote, "Mueller's investigation of Trump is going too far," unquote. You stated that the investigation was, quote, a lynch mob. You warned of serious consequences if the special counsel were to examine the president's personal finances. You suggested that the special counsel's budget should be squeezed until his investigation, quote, grinds to almost a halt, unquote. Like everyone else at the Department of Justice, you are entitled to your own political opinions. This committee should not be in the business of vilifying government personnel for their private views, particularly when the department takes steps to mitigate even the appearance of a conflict of interest in an ongoing investigation. But when career officials at the department recommended that you take steps to mitigate your apparent conflicts of interest, when they told you that your public criticism of the special counsel was bad for the department and bad for the administration of justice, you ignored them. You decided that your private interest in overseeing this particular investigation, and perhaps others from which you should have been recused, was more important than the integrity of the department. The question that this committee must now ask is, why? Why did President Trump choose to replace Attorney General Sessions with an outspoken critic of the special counsel instead of with any number of qualified individuals who had already received Senate confirmation? Why did you ignore the career officials who went to extraordinary lengths to tell you that your continued involvement in the special counsel's work would undermine the credibility of the Department of Justice? Why did you choose to comment at length on the substance of the special counsel's investigation at a January 29th press conference? Is it true that you have been fully briefed, unquote, on the investigation and that the special counsel's work is, quote, close to being completed, unquote? And why did President Trump leave you running the department in an acting capacity as long as he did? What did he hope to get out of it? What did you provide? The committee is determined to find the answers to these questions today. To that end, we have taken certain steps to ensure your cooperation with members on both sides of the aisle. First, although I am pleased that you eventually agreed to appear here voluntarily, the committee has authorized me to issue a subpoena to compel your testimony if necessary. The ranking member will no doubt argue that the subpoena threat was a mistake, but as you know, I gave you no assurances until after you had agreed to appear today. Given our concerns about your attendance until late last night, I'm taking steps to ensure your appearance seems perfectly appropriate. Now that you are here and prepared to testify, I agree there's no need for us to resort to that measure for now. I am nonetheless concerned by some of the arguments the department raised in the lengthy letter we received late yesterday. I very much doubt, for example, that any privilege attaches to communications about criminal investigations where the president, his campaign, his business, and his close associates are subjects and in some cases targets of the investigation. I also take issue with your written testimony, which we did not receive until almost midnight last night, when you suggest that you, quote, will continue the longstanding executive branch policy and practice of not disclosing information that may be subject to executive privilege, close quote. In other words, you reserve the right to refuse to answer the question forever. That's not how it works. Nearly 3 weeks ago, I provided you with a list of questions related to communications you may have had with the White House about the circumstances of your hiring, the termination of Mr. Sessions, and any insight you may have into the special counsel's investigation, among other topics. I gave you those questions in advance so that you would have time to consult with the White House on any possible question of executive privilege. I understand that you may disagree with the committee about your responsibility to undertake that review, and as a consequence, you may not fully respond to every question we ask today. As we discussed, I am willing to work with the department on those disagreements on a case-by-case basis. But I take your reluctance to answer questions about these communications as a deeply troubling sign. When our members ask if you conveyed sensitive information to the president, or ignored ethics advice at the direction of the president, or worked with the White House to orchestrate the firing of your predecessor, the answer should be no. Your failure to respond fully to our questions here today in no way limits the ability of this committee to get the answers in the longer run, even if you are a private citizen when we finally learn the truth. And although I am willing to work with the department to obtain this information, I will not allow that process to drag out for weeks and months. The time for this administration to postpone accountability is over. It is my intent that there be no surprises today. We have laid all of the groundwork for this hearing out in the open. We have given you months to prepare. We have publicly documented every request we have made. We have provided our Republican colleagues with a meaningful opportunity to weigh in on the process. We have nothing to hide from you or anyone else. We hope you have nothing to hide from us. Despite the ethics advice you were given, Mr. Whitaker, you insisted on remaining in charge of the special counsel's investigation. a job that comes with the responsibility to protect the special counsel until his work is complete. Your testimony here today is vital to that responsibility and to our shared responsibility to find the truth, to protect the department, and to follow the facts and the law to their conclusion. Thank you. It is now my pleasure to recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. Thank you, Acting Attorney General, for being here. But I would like to thank, I'll start off with this way, and I also want to thank the chairman for a show of honesty. We now have the reason for this hearing. It has nothing to do with the oversight of DOJ. It has everything to do, as we found out this morning in a document dump from the Democratic side of this committee and also another committee, that this is nothing more than a character assassination. And we're going to also decide to see if we can just do something and get at the president while we had the chance. Yesterday, I want to tell you a story. My kids are now grown. They're 26 and down to 20. And I used to always love the Easter season and the time of especially hide and seek and going to find, eggs. And that look on their face when they found that last egg they were looking for. And that look of surprise. And yesterday was that for me again. I was back being a father again. Because yesterday was nothing but pure political theater. It was wonderful. It was a time for hide and seek. The chairman had a hearing. Let's do a subpoena. We're going to stand tough. And let's just do the timeline real quick. We get through with it, and as I had warned this committee, a preemptive subpoena was not a good idea. It chills all other witnesses coming before this committee and would probably have a detrimental effect to the acting attorney general. But, hey, I'm the minority. Who cares? So we do it. And the acting attorney general's office responded. At about 5 o'clock, the chairman sent a letter saying, we know we'll examine it on a case-by-case basis. The acting attorney general said, no, we need assurances that you're not going to issue a subpoena today or yesterday or today. So, okay, we're back and forth. DOJ, as I understand, he said, no, that's not enough assurance. And we were informed around a certain time last night, about 7 o'clock last night, that an agreement had been made, and it was a full cave by the committee chairman. No subpoenas today. So everything that we did earlier in the day was a complete waste of time. Now, what was even worse about this, and let's talk about, Twitter accounts. Last night around 8 o'clock, the chairman's Twitter account said acting attorney general was going to show up today at 9:30. The interesting thing about that is they linked to the 5 o'clock letter, not this letter, which I asked now to be admitted to the record, which, by the way, I was CC'd on, but never, I guess this is it. But we're going to put this into the record now. The letter to the acting attorney general in which the chairman of this committee says there will be no subpoena tomorrow and any differences we have we'll work on later. And I ask unanimous consent that be entered into the record.
Without objection.
So at 8 o'clock, we decided to send out a tweet to the world, which many in the media, by the way, picked up on and have run stories today saying the reason the judiciary chairman wins, the attorney general's coming, he doesn't have assurances. No, he does, right here. There's going to be no subpoena today. So when we talk about transparency, which was so evident yesterday, now we get to the real meat of the issue. It is also amazing to me, as I said yesterday, when you come here and you put an issue of this hearing, yes, on Thursday, Bill Barr was approved out of the Senate Judiciary Committee. By next Thursday, he will be the Attorney General. This gentleman right here is finishing up the last term of acting attorney general. He was willing to come, but yet we had the charade yesterday. This hearing is pointless, and basically it was made even more pointless by the chairman's opening statement. This is not about what the good men and women at the Department of Justice are doing. This is not about FBI agents who are doing their job. It could be about the FBI agents that we on our side have talked about that didn't do their job, and we'll probably hear a lot about that today. There's plenty of frustration of issues of DOJ oversight. But, sir, I'm not sure, frankly, that the oversight of your financial situation from 2014 to 2016 has anything to do with this hearing. It's beyond the scope of this hearing. So if this is what we're going to do, if this is where we're going, then I want to remind everyone that this is not the Senate. If my friends on the other side of the aisle of this committee wanted to do a confirmation hearing, they just ought to set it up front. And if they want to do a confirmation hearing on senators, run for Senate. This is not a confirmation hearing. This is a Department of Justice oversight hearing. Supposedly, oops, I'm sorry. Back to theatrics again. The curtain opened up and we found out what was really going on. No, we want to damage the president. We want to talk about your private conversations. We want to talk about what you did and why the president, a most amazing quote I just heard a moment ago. We want to know why the president may have put you there for what he got. That's offensive. When we look at this and we go through this, Mr. Whitaker, there are a lot of issues that we've discussed personally, and as also as far as knowing this and discussing things that we could do at oversight that frankly on our side, we're frustrated with. And that's going to come out today. But for the chairman to do what we did yesterday, to have this hide and seek game, to play it all along, and then to willingly mislead the press and everybody else to think you're coming here today because of a partial assurance, not a full-blown cave, which is exactly what happened in this letter, is a travesty not only to this committee, but to the people watching and the reporters who thought it was real. When we look forward into this hearing today, it's time on this one, if this is the way we're going to go, then we'll have plenty of stunts. We're going to have plenty of theatrics. Bring your popcorn. I'm thinking about maybe we just set up a popcorn machine in the back because that's what this is becoming. It's becoming a show. When your presence was here, you were coming voluntarily. You've always said you're coming voluntarily. So we had the show yesterday. We now have had the curtain drop down, and Mr. Whitaker, I guess your confirmation hearing's here. You only got 5 days left on the job or 6 days left on the job. We could join together with the chairman and say, Mr. Barr, come in here because you've been actually the Attorney General. Mr. Barr has been the Attorney General. He's been before this committee before. We could have had substantive hearings, but no, we're going to have a show. Dog and pony show. Let's get it out. This is the most amazing thing when but I go back to something. Sometimes as a father, I started this as a father, I'm going to end it as a father. I give my kids advice and they look at me like, Dad, I love you. But then they give me that sort of dog look. I don't believe you. You know the sad part about this is? We predicted it all yesterday. We knew what was coming. The sad part about it is the chairman chose to play hide and seek. He chose to cave at the end, and by the way, still not have open and transparency. I'm glad we did. Glad we got it now. But this is no way to run the railroad, and it's definitely no way to run one of the most prestigious committees in this House. And this is something that everyone should be concerned about. There's enough at DOJ for us to do oversight on. But Mr. Whitaker, this is your life. Like the old TV show, they just want a piece of you. And with that, Mr. Chairman, pursuant to Clause 4, Rule 16I, I do now move to adjourn.
Mr. Chairman. A motion to adjourn has been made. Motions to adjourn are not debatable. All in favor of the motion to adjourn, say aye. Aye. Opposed, nay? No. The noes have it.
Roll call.
Roll call has been requested. Where's the clerk? The clerk will, if the clerk is here, she will call the roll. We'll wait a moment for the clerk.
No, we'll help the clerk.
Oh, where is the clerk?
The clerk's better.
They're coming.
Mr. Chair,
No, the roll call is in progress.
Mr. Chairman,
The clerk is prepared. The clerk will call the roll.
Mr. Chairman.
Motion to, no.
Mr. Chairman votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Mr. Cohen? Mr. Cohen votes no. Mr. Johnson? Mr. Johnson votes no. Mr. Deutsch? Mr. Deutsch votes no. Ms. Bass? Ms. Bass votes no. Mr. Richmond? Mr. Richmond votes no. Mr. Jeffries?
No.
Mr. Jeffries votes no. Mr. Cicilline?
So we may continue to pursue the truth, I vote no.
Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu? Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Demmings? Ms. Demmings votes no. Mr. Correa? No. Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath? No. Ms. McBath votes no. Mr. Staunton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. Murkosel-Powell?
No.
Ms. Murkosel-Powell votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins? Mr. Collins votes yes. Mr. Sensenbrenner? Mr. Chabot? Mr. Chabot votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Jordan votes yes. Mr. Buck? Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Johnson? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Ms. Lesko votes aye. Mr. Rentschler? Mr. Klein? Mr. Klein votes aye. Ms. Armstrong? Ms. Armstrong votes aye. Mr. Stube? Are there any other members wishing to vote?
Haven't voted. Gentleman from Texas? Yes. Are there any other members who wish to vote who haven't voted?
Mr. Ratcliffe votes aye. Yep.
Clerk will report.
Mr. Chairman, there are 24 noes and 10 ayes.
The motion to adjourn is not approved. I will now introduce today's witness. Matthew G. Whitaker is the Acting Attorney General of the United States. Previously, Mr. Whitaker served as Chief of Staff to Attorney General Jeff Sessions. He was appointed as the U.S. Attorney for the Southern District of Iowa on June 15, 2004 by President George W. Bush. Before that, he was a managing partner of the Des Moines-based law firm Whitaker, Hagenau, and Gustav, LLP. He was also the executive director for FACT, the Foundation for Accountability and Civic Trust, between 2014 and 2017. Mr. Whitaker graduated with a Master of Business Administration, Juris Doctor, and Bachelor of Arts from the University of Iowa. We welcome Mr. Whitaker and we thank him for participating in today's hearing. Now, if you would please rise, I'll begin by swearing you in. Raise your right arm. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Thank you. Let the record show that the witness answered in the affirmative. Thank you, and please be seated. Please note that your written testimony will be entered into the record in its entirety. Accordingly, that I ask that you summarize your testimony in 5 minutes. To help you stay within that time, there is a timing light on your table. When the light switches from green to yellow, you will have 1 minute to conclude your testimony. When the light turns red, it signals the time is expired. Mr. Whitaker.
Thank you, Mr. Chairman and Ranking Member Collins, for the opportunity to testify before the committee today. I am looking forward to discussing with you some of the accomplishments and priorities of the Department of Justice. Before I start, I would also like to acknowledge the passing of former Chairman Dingell. He was a statesman and a leader, and it is a sad day in this committee, I'm certain. First of all, let me say that it's an honor to represent the 115,000 men and women of the Department of Justice. The department is blessed with extremely talented, highly principled public servants who are dedicated to upholding our great Constitution and the laws of the United States. I saw that up close during my 5.5 years as United States Attorney for the Southern District of Iowa. Our office put criminals behind bars, and we kept the people of Iowa safe. I personally prosecuted several important criminal cases and worked with the men and women of the ATF, DEA, FBI, and U.S. Marshals Service, and our state, local, and federal partners. It was a privilege. In 2017, I returned to the department and served for 13 months as Chief of Staff to former Attorney General Jeff Sessions, a man for whom I have great respect. He led the department with integrity, with dedication to the rule of law, and with a commitment to carrying out the policies of the President of the United States. I am deeply honored that the President selected me to continue this work at the department. The Senate will soon consider President's nomination for our next Attorney General. And let me just say this, no one is more qualified than Bill Barr. I am working to ensure that he will inherit a strong, confident, and effective Department of Justice, and I believe that he will. For the last 3 months, I have had the privilege of serving as Acting Attorney General, and I am impressed every single day by the dedication and hard work of our agents, our attorneys, and our support staff. Over this time, I have visited a number of our offices and met with federal prosecutors from across the country. For example, in December, we held our Project Safe Neighborhoods Conference, where employees from nearly every U.S. Attorney's Office and hundreds of our state and local partners celebrated our successes and reductions in violent crime. Our hard work is paying off. I firmly believe that your constituents are safer because of the work that we have done over the past 2 years. Under this administration, crime is down and police morale is up. In fiscal year 2017, the Justice Department charged the largest number of violent crime defendants since we started to track this category back when Bill Barr was Attorney General the last time. And then in fiscal year 2018, we broke that record again by a margin of nearly 15%. We also charged more defendants with gun crimes than ever before. In fact, we broke that record by a margin of 17%. The department has also banned bump stocks, improved the background check system, and prosecuted those who lied to get a gun. Our work is having an impact. In 2017, after 2 years of increases under the previous administration, violent crime and homicide rates went down nationwide. We do not have official numbers yet for 2018, but one estimate projected that the murder rate in our 29 biggest cities would drop by 7.6%. Those are real lives being saved. Much of the crime in this country is related to drug abuse and drug trafficking. But under this administration, prescriptions for the 7 most frequently abused prescription drugs are down more than 21%, to the lowest level in at least a decade. At the same time, the DEA has lowered the legal limits on production of the active ingredients in these prescription opioids by 47% since 2016. And there is no doubt in the law enforcement community that the vast majority of the illegal drugs in this country are coming through our southern border. There is also no doubt that criminals and cartels seek to exploit weaknesses in our southern border for their own profits and purposes, including by subjecting women and children to dangerous and unspeakable conditions in an attempt to smuggle them into the United States. And of course, the dangers of our porous southern border become all more apparent every time an illegal alien causes harm or death to an innocent American across this country, such as what happened to an outstanding young woman from my home state, Sarah Root. For this reason and for others, we continue our efforts to restore the rule of law at the border and in our immigration system. In fiscal year 2018, we charged more defendants with illegal entry than in any other year in American history. In fact, we charged 85% more defendants with illegally entering America than we did the previous year. At the same time, we increased the number of felony illegal re-entry prosecutions by more than 38%. Whatever our views on immigration policy, we should all be opposed to illegal immigration, and we should support these efforts. The department is also taking decisive action against human trafficking, both domestically and internationally. Human traffickers, like other criminal enterprises, take advantage of our southern porous border to smuggle women and children into the United States to exploit them. We are bringing prosecutions to dismantle transnational trafficking networks that lure victims across our borders and traffic them for profits. Last year, the Department of Justice secured a record of 526 human trafficking convictions, a 5% increase from the previous year. The department is also doing its part to aggressively prosecute hate crimes. Under this administration, we indicted 50 hate crime defendants and obtained 30 hate crime convictions in fiscal year 2018. In November, the department provided election monitoring at polling places around the country. Our Civil Rights Division deployed personnel to 35 districts in 19 states to monitor for compliance with federal voting rights laws. Our Public Integrity Section prosecutors served as subject matter experts for federal prosecutors and investigators nationwide, working with the FBI at the Strategic Information and Operations Center. Over my time as Acting Attorney General, I have done everything in my power to continue regular order at the Department of Justice. The department has continued to make its law enforcement decisions based upon the facts and the law of each individual case in accordance with established department practices and independent of any outside interference. At no time has the White House asked for, nor have I provided, any promises or commitments concerning the special counsel's investigation or any other investigation. Since becoming Acting Attorney General, I have run the Department of Justice with fidelity to the law and to the Constitution. During my time as the leader of the Department of Justice, the department has complied with the special counsel regulations, and there has been no change in how the department has worked with the special counsel's office. Over the past day, the department and the committee have exchanged letters concerning the respective prerogatives of the legislative and executive branches. I am pleased that we are able to reach an agreement that allows me to appear here voluntarily. I am pleased also that we agreed that each branch would seek to accommodate each other, and that if we have differences, we will try to work them out in good faith before resorting to subpoenas or other formal legal processes. I will answer the committee's questions as best I can, but I will continue the long-standing executive branch practice of not disclosing information that may be subject to executive privilege, such as the contents of conversations with the President. As the Supreme Court has recognized, this executive privilege is fundamental to the operation of government and inextricably rooted in the separation of powers under the Constitution. I have spent nearly 1/3 of my professional career at the Department of Justice, and I am personally committed to its success and integrity. I hope that today's hearing will be constructive and help us partner together to address the priorities of the American people. The men and women of this department are proud of our accomplishments, but we know that Congress can help us to achieve even more. And as our agents and our prosecutors have shown you again and again, they deserve your support. Thank you once again for the opportunity to testify today and for your attention to the matters facing the Department of Justice.
Thank you for your testimony. We will now proceed under the 5-minute rule with questions. I will begin by recognizing myself for 5 minutes. Now, we fully intend to examine substantive questions of the department policy, but part of our job is to make sure that core investigations at the department have not been compromised. So, at a press conference last week, sir, you said that you have been fully briefed on the special counsel's investigation. I would like to better understand that comment. Yes or no, since your appointment as Acting Attorney General, have you been briefed on criminal or counterintelligence matters within the special counsel's purview?
Chairman, thank you for that question. As you know, I cannot talk about ongoing investigations.
But you can say whether you've been briefed or not.
And as you commented about my recent press conference, as it relates to the special counsel's investigation, I have been briefed on it.
So the answer is yes, thank you. Were you briefed on those matters at any point while you were serving as Chief of Staff to Attorney General Sessions?
Chairman, I know you're very interested in the special counsel's investigation, and so I want to be very clear about this. Because General Sessions was recused from the special counsel's investigation, I had no involvement in the special counsel's investigation.
So the answer is no. So the answer is no. Thank you. How many times were you briefed about the special counsel's work, and when did the briefings take place?
Mr. Chairman, I've said all that I'm planning on saying about the number of times or the briefings that I've received on the special counsel's investigation. It is the subject matter of an ongoing investigation, I think it would be very improper for me, as I sit here today,
Wait a
to
minute,
talk anything more about it.
whether you were briefed is the subject of an ongoing investigation? I didn't follow that.
No, the number of times I've been briefed in my involvement in the investigation, sir.
Well, it's our understanding that at least one briefing occurred in December before your decision not to recuse yourself on December 19th and Christmas Day. Is that correct?
What's the basis for that question, sir?
Yes or no? Is it
Well,
correct? It is our understanding that at least one briefing occurred between your decision not to recuse yourself on December 19th and 6 days later, Christmas Day. Is that correct? Simple enough question. Yes or no?
Mr. Chairman, again, what is the basis for your question? You're saying that it is your
Sir,
understanding.
I'm asking the questions. I only have 5 minutes. So please answer yes or no.
No, Mr. Chairman, I'm going to, you were asking me a question. It is your understanding. Can you tell me where you get the basis?
No, I'm not going to
for
tell
your
you that. I don't have
understanding?
time to get into that. I'm just asking you if that's correct or not. Is it correct? Were you briefed in that time period between December 19th and Christmas Day? Simple question, yes or no?
Congressman, if every member here today asks questions based on their mere speculation.
All right, never
and
mind.
I
At any
don't have a
point,
factual basis
yes
for
or
questions,
no,
it's very difficult
at
for
any,
me to answer the
yes or no, at any point since that briefing, have you communicated any information you learned in that briefing to President Trump?
Mr. Chairman, I know that there is a unique and
yes or no
special
question,
interest
sir.
in this. I'm
It's
sorry.
a yes or no question. Have you communicated anything you learned in that briefing about the investigation to President Trump? Yes or no?
Mr. Chairman, as I've said earlier today in my opening remarks, I do not intend today to talk about my private conversations with the President of the United States. But to answer your question, I have not talked to the President of the United States about the special counsel's investigation.
So the answer is no. Thank you. To any other White House official?
Again, Mr. Chairman, as I mentioned in my opening statement, I do not intend today to talk about my private conversations with the President nor White House officials. But I will tell you, consistent with what I've already said, I have not talked about the special counsel's investigation with senior White House officials.
Okay. To any third party not already briefed about the special counsel's investigation who might have conveyed that information to the President or his legal team?
Who do you consider third-party
Well,
individuals?
it's really for your consideration. To any third party not already briefed about that investigation who might have conveyed, who you think might have conveyed that information to President Trump or his legal team?
Third persons who I think may have conveyed that
Yes.
information?
Yes.
You know, as I sit here in this chair right now, Mr. Chairman, you know, that's an impossible question for me to ask. I mean, I do not believe that I have briefed third-party individuals outside of the Department of Justice. I have received the briefings myself, and I am usually the endpoint of that information.
But you won't answer the question.
I just did answer your question.
I don't think you did, but let me just say this. Your iteration of the department's longstanding policy appears designed to delay answering these questions as long as possible. I find that unacceptable. I understand the role of executive privilege and respect its value in our system of governance. However, Congress is a co-equal branch of government. We have a responsibility to conduct oversight. This is a responsibility we take very seriously. I've repeatedly tried to work with your office, first in delaying the hearing until February, and then in providing you our questions in advance. I did this because the executive branch's own rules governing assertion of privilege, which were issued by President Reagan and have been followed ever since, say that ultimately it is up to the President to decide whether or not he wants to assert executive privilege. You cannot repeat forever that the President might want to assert privilege. I've given you a fair opportunity to prepare for the hearing and to speak with the White House in advance so that we could avoid this fight in the first place, but you don't appear to have done any of that. The department's failure to do its due diligence here, to me, is deeply troubling. I do not believe that issuing a subpoena here would correct the problem, but I'm going to give you the opportunity to rectify the situation. After today's hearing, we will attempt to reach an accommodation with the department to obtain answers to these questions. As part of that process, I ask for your commitment to return for a deposition before this committee in the coming weeks, under oath, with an understanding that the transcript will be released to the public as soon as practicable thereafter. Any questions that are unanswered today or require consultation with the White House will be asked again at that proceeding, and I expect either a clean answer or a proper assertion of privilege claimed by the President. I would ask members on both sides of the aisle to make those questions clear for the record so we know what must be addressed at the future proceeding. Now, in your capacity as Acting Attorney General, have you ever been asked to approve any request or action to be taken by the Special Counsel?
Mr. Chairman, I see that your 5 minutes is up, and so I'm here voluntarily. We have agreed to 5-minute rounds, and
The committee,
I think that's a fine place to end the 5-minute rule.
the committee will end. Will come to order. I will point out that we didn't enforce the 5-minute rule on Acting Attorney General Whitaker. We will.
I understand, Mr. Chairman. I was just saying that might be a good breaking point at that point for you.
No, the Attorney General was in the middle of saying something. Answer the question, please.
Regular order.
Should I ask the question? Okay.
Yeah,
In your
could you
capacity
please
as
ask the
acting.
question? I just
Let
wanna
me
make
just repeat the question so people remember what we're talking about. In your capacity as Acting Attorney General, have you ever been asked to approve any request or action to be taken by the Special Counsel?
Mr. Chairman, I, as the Acting Attorney General, I am, under the Special Counsel's rules, I am the person that is ultimately in charge of the investigation, and I have exercised that authority under the Special Counsel's regulations of the Department of Justice.
So I assume the answer is yes.
Regular order, Mr.
You have, I assume the answer is yes. You have been asked to approve a request or action, and you've said yes or no? In other words,
Mr. Chairman, I want to be very clear about what you're asking me. Are you asking me if I have asked the Special Counsel to do something?
Regular order, Mr. Chairman.
is this whole thing? Well, I'm asking if I think my words were clear enough. Have you ever been asked to approve any request or action to be taken by the Special Counsel? Last week, you commented on the status of the investigation, stating it was close to being completed, unquote. This was said despite the fact you recognized just moments before that it was ongoing, stating, quote, I really am not going to talk about an open and ongoing investigation otherwise, close quote. So all I'm asking you is, have you been asked to approve or disapprove a request or action to be taken by the Special Counsel?
Point of order, Mr. Chairman.
I've asked the question.
Point of order, Mr. Chairman.
Point of order is not in order until the question is answered.
We're not operating under the 5-minute rule anymore then?
Point of order, the witness will answer the question.
I want to be very specific about this, Mr. Chairman, because I think it's going to allay a lot of fears that have existed among this committee, among the legislative branch largely, and maybe among some American people. We have followed the Special Counsel's regulations to a T. There has been no event, no decision that has required me to take any action, and I have not interfered in any way with the Special Counsel's investigation.
Very good. Thank you. My time has expired. I now recognize the ranking member, the gentleman from Georgia, Mr. Collins.
Thank you, Mr. Chairman. Again, it is
I know.
playing out exactly as we thought. This is my colleagues across the aisle. When we had questions about the FBI's operation and investigations, it was, oh, stay away. We don't want to get close to Mueller. In fact, the chairman even said, you know, is it no longer okay to wait for Robert Mueller? Well, it's no longer right. They got you in front of them right now, so get ready. This is all this is going to be, DOJ oversight. And it is. I'm just going to say it for a second. There is some things interesting here that you did point out in your opening statement that do need addressing. I think there's a lot of things, whether it be voting rights issues, whether it be civil rights issues and other things, and I get that. But I'm also going to deal with something that is directly under your oversight provision, Mr. Acting Attorney General, and we're going to talk about something I've written a letter about. And I believe that lying before this body or anybody is wrong, especially under oath, and that's not the issue, but the issue is tactics. And a question is, were you aware of Roger Stone's indictment before it became public?
Congressman, that's as you know, an important question. It is also, Mr. Stone is part of an ongoing investigation, but I have, again, been briefed on the Special Counsel's investigation. That would have been you know, that would have been considered a development that I would have been briefed on, and I was briefed on that.
Are you familiar from public reports or otherwise that a CNN reporter was camped out outside of Stone's house when the FBI arrested him? This wouldn't be part of the investigation.
I am aware of that, and it was deeply concerning to me as to how CNN found out about that.
Well, that is I'm glad we're going down that road, Mr. Attorney General, because this is did somebody at the Department of Justice seemingly share a draft indictment with CNN prior to Stone's arrest? Prior to a grand jury's finding of a true bill?
Ranking Member Collins, the court had a sealed indictment that after Mr. Stone's arrest was unsealed. Consistent with all its prior indictments, the DOJ's basic policy for transparency in criminal cases is that the indictment is posted on the DOJ webpage promptly after it's unsealed, and then media outlets were notified. We do not know of any, and I do not know of any other special counsel's office notice or DOJ notice to media outlets regarding Mr. Stone's indictment or his arrest. And otherwise, you know, I really, as I sit here today, don't have any other information that I can talk about regarding Mr. Stone.
Well, given your answer even just then, it does seem concerning given the timing of this reporter's knowledge and other things that there seems to have been a gap in that discovery. And just another question is if anybody would outside this, would you view this as a problem? Because this looks like this is something, I'm just asking, in your final days here, would this be a problem with DOJ if we're looking at the timing doesn't match up, that somebody it seems to appear that this was given pre or prior knowledge, not going through the normal channels? Because if it was given through normal channels, every media outlet would have been there, but only one was.
Mr. Collins, I share your concern with the possibility that a media outlet was tipped off to Mr. Stone's either indictment or arrest before it was made, that information was available to the public.
One of the other issues, and this is, you know, since we're going to go down this, the chairman wanted to have this, this is a question that's not unfamiliar, and it should be. Is Bruce Ohr still employed with the Department of Justice?
To answer your question directly, Mr. Collins, Bruce Ohr is currently employed with the Department of Justice.
Okay. Is there any process at this point, or that you could comment? I understand personnel issues, but are you aware of the discussions and also the implication investigations from Congress and from others surrounding Bruce Ohr's involvement in many of the investigation problems that we have seen over the past few years at DOJ?
Mr. Collins, I am generally aware of Mr. Ohr being questions being raised about his behavior at the Department of Justice.
Let me tell you it a different way. Knowing what you know and seeing what you have seen and using your past experience and prior knowledge, do you believe that Mr. Ohr was operating outside normal channels and appropriate channels in which he was operating under, which has been publicly reported?
Mr. Collins, this is a very important question for many people, both in this body and in the general public. The Office of Inspector General is currently looking at the Carter Page FISA application,
which is very much of a concern.
And it is also being reviewed at the same time and simultaneously by Mr. John Huber, who's the U.S. Attorney from Utah, who was asked by Attorney General Sessions to conduct a review of certain matters at the Department of Justice. And so, together with the fact that any situation regarding Mr. Ohr's employment would be part of a confidential human resources process, I just am unable to talk any more about Mr. Ohr, his involvement in any matters that could be subject to either an Inspector General's investigation or a human resource matter.
Well, Attorney General Whitaker, barring the now again, as we had another part to our play this morning, we are now finding out that you may be subpoenaed to come back and do a deposition, which again, as we continue down this line, is any way around this to continue to attack it at the investigation of the president. This is again, is just an amazing. I just want to say one, in your last few days, you know, do your best, do your job, and continue to do that part. But also at a certain point in time, there's many on this committee, many on our side of the aisle, as well as the other side of the aisle, that have been very concerned with what we have seen at the Department of Justice, especially in the FBI, and especially over the last few years, that should turn every citizen, whether they're Republican, Democrat, Independent, could care less about politics. when there's ever a perception, and I've shared this with others that have came before you to testify, whenever there is a perception that there is not an equal treatment on either side, that is a problem. It needs to be addressed. I'm hoping that when Bill Barr comes in, this will be one of his first steps that we can continue with. I know you've attempted to do that, but this is going to be a long day, and it's going to be a day in which we chase a lot of rabbits. Unfortunately, when we get to the end of the day, the good men and women in the department side of the Department of Justice, which is what you were pitched with back before the chairman was the chairman, this is not going to be an oversight hearing. It's going to be more of a rabbit chase down a lot of holes. With that, I yield back.
Mr. Collins, if you don't, Mr. Chairman, may I answer his
You may.
question? Yeah, I think it's important as we sit here today that we understand that this is not a confirmation hearing, that I am probably going to be replaced by Bill Barr in the next week. This is an oversight hearing for the Department of Justice. And I'm surprised, as we've both had the chairman and the ranking member talk about what they want to talk about, that we haven't talked anything about the work regarding violent crime. We haven't talked about the opioid crisis. We haven't talked about religious liberty. We haven't talked about free speech on our college campuses and a whole host of other issues that I know are very important to you. And I look forward to talking about the substance of the work at the Department of Justice. But if this, I mean, it is your 5 minutes, and you can ask the questions that are of most interest to you. But as I sit here today, I would like to talk about the incredible work that we have been doing at the Department of Justice since I was Chief of Staff and now Acting Attorney General. So,
I appreciate that, but if you'd have watched if you'd have been glued to a TV yesterday morning, you'd have found out this wasn't what this was going to be about. Thank you, Mr. Attorney.
Ladies and gentlemen, there are votes on the floor. There are 11 minutes left. We're informed they're going to strictly enforce the 15-minute rule. We'll see if that's true, but we will not risk it. So the committee will...
Sorry, 15-minute rule, is that changed now?
The committee will stand in recess until immediately after the last in this series of votes.
A brief pause here in this hearing. The House Judiciary Committee meeting with the Acting Attorney General, Matthew Whitaker, in what has already become a contentious exchange. The Acting Attorney General clearly prepped and seeming to struggle at times with starting off answers, saying, I'm not going to answer that, or that's outside of the line of things I can talk about, but then ultimately answering many of the questions that are put to him. The most significant saying that he basically has not changed the course of the direction of the special counsel investigation, the Mueller investigation. One of the most shocking moments of the hearing that led to a lot of guffaws and surprise there in the chamber was when the Acting Attorney General told the chairman, Jerry Nadler, that his 5 minutes were up. Now, this committee has agreed that each member gets about 5 minutes to ask questions, but the chairman has the say. The chairman can go on as long as he wishes. He can also allow other people to go on longer. And so I've never personally heard anyone in the witness seat telling a member of Congress that their time was up. That's why you heard a lot of people in the room expressing a bit of shock and surprise there. The chairman continuing on with his line of questioning nonetheless. You can hear already, though, this setup happening here where Chairman Nadler is teeing up for some sort of subpoena or some sort of effort to try to get more questions answered on the record, asking the Acting Attorney General if he would come back for a deposition that would then later be released to the public and address some of these very specific questions about executive privilege and conversations with the President of the United States. Now, as you're hearing, the Acting Attorney General is saying he's not going to answer questions because of the potential breach of executive privilege. Perhaps these are conversations the President doesn't want him talking about publicly, but Chairman Nadler would like it to go much more specific than that. He wants to know specifically, does the President not want this conversation released? And so you can already see this push-pull. The top Republican on the committee, Doug Collins, saying that this is a sideshow essentially, and that this is not about getting to the heart of issues. You're watching live coverage from the Washington Post. I'm Libby Casey, and I'm joined here by Matt Zapotosky in the studio. Matt, are we getting any answers yet?
Well, we have some answers. He said that he was never asked by President Trump to do anything with respect to the Mueller probe. In fact, he never had any conversations at all with President Trump about the Mueller probe. I thought that was interesting. I thought the most interesting thing, though, was just the chippiness of the whole deal. At one point, he, as I'm sure everybody saw, reminds the committee of their own rule about how long you can ask questions. I've never seen anything like that. I heard people in our newsroom sort of
I
laughing
gasped out
about
loud.
it
Yeah,
and,
I
and in
actually
the
gasped
hearing.
out loud. Yeah. You know, it's interesting because the way the acting attorney general begins answering a question is, I've said that I'm not going to answer questions about conversations I've had with the president. I've said I'm not going to answer questions about conversations I've had with White House staff, but I didn't talk about that.
Yeah, but then he does.
So it's almost like he's going through a rehearsed line that he was prepped to say, but then he sort of realizes, well, if I didn't talk about it, I guess I can say I didn't talk about it.
Yeah, I mean, I suppose if it's favorable to him, then he can say, no, I didn't talk about that, and that's what he's done so far. The risk of that, of course, is if there comes a question that he won't answer, people will assume the worst. You know, they will assume there was some direction. I don't think, I missed parts of it because I was running back from the studio here, but I don't think they asked him anything about conversations about the SDNY investigation, which I'm
Not
still
yet.
curious to hear about. But with Mueller, he was pretty clear that he had had no conversations with the president.
You know, you raise a really good point. So if he says, I can't talk about this, but I didn't have that conversation. I can't talk about this, but I didn't have that conversation. The implication will be when he says, I can't talk about that full stop, that the conversation did happen or did exist, basically.
Right. We, of course, won't know that for sure, but if lawmakers go in when he comes back and says, so we've addressed Mueller, you never talked with the president about Mueller. Have you talked with the president about the investigations in the Southern District of New York? And he says, I can't answer that, and doesn't add anything more. What are we to infer from that? Well, you were willing to say you didn't have any conversations about Mueller. Why aren't you willing to say that in this case?
We've also only heard two people ask questions so far, the Chairman Nadler, and the top Republican, Doug Collins. And in the Doug Collins line of questioning, obviously a friendly line of questioning to the acting attorney general, you heard Whitaker give a bit of a speech saying, I am not here for a confirmation hearing. I'm not going to be the next AG. The other guy is basically going to be the next AG in like a week. And why aren't you asking me these oversight questions about, you know, criminal justice and all these other big weighty topics? I mean, they haven't even had a minute to dig into it yet. But that's sort of the direction he's already trying to go. This is supposed to be an oversight hearing. This isn't all about me.
Right, and he's right that this is an oversight hearing. I mean, in more boring times, the acting attorney general would come in and talk about what are they doing on violent crime and talk about what are they doing on threats abroad, what are they doing on terror. We don't live in that world anymore, and he's not the first top law enforcement official, whether it's the FBI director or the attorney general, to come in a particularly politically charged time and be forced to address the politically charged topics of the day. That is also a part of the oversight function. He did say, look, it's your 5 minutes, you can ask what you want, but you know, clearly he doesn't like the way this is going.
Matt Zapotowski, national security reporter who covers the Justice Department. We're also joined by Rosalind Helderman, who is a reporter focused on political enterprise stories and investigations. You've been watching the Mueller probe, Roz. You've been following a lot of the Russia investigation as it unfolds. What have you been expecting from Matthew Whitaker today going into this? As someone who's watched his career at the Justice Department, watched his relationship with the special counsel, do you expect to get anything out of this today?
I think he's going to try hard to ensure that we get nothing from it. I mean, I think it's been a little unpredictable because he has not worked at this level for very long. And we have seen him just in the recent past sort of give off-the-cuff remarks that seemed potentially unplanned. There was this press conference that I believe Matt covered a couple of weeks ago where he was sort of just asked a question by a reporter that would have been very easy to kind of slap down, and instead he kind of mumbled something about how he's been told the special counsel investigation is wrapping up. That was pretty much the most substantive thing we've been told publicly by anyone from the Justice Department about the Mueller investigation, you know, since it began in May of 2017, and it did not appear planned or like something he really wanted to be doing. And so I think our expectation has been that kind of who knows what he might say under tough questioning. You know, I think Matt has some reporting about how much prep he's been doing in advance of this to try to ensure that doesn't happen.
And you can tell that the prep went into this, although I will say at times and I say this in a non-judgmental way, but there is a bit of a word salad that's been coming out of his mouth where he sort of stumbles through what seems to be a prepared answer of I'm not going to talk about that, or I can't comment on, but actually here's my answer. So it already has seemed to be a little bit convoluted in how he's trying to both shut down some questions and yet ultimately answer them at the same time.
Yeah, look, you can prep all you want, but he is who he is, and he's a pretty rookie attorney general. I guess he probably had a confirmation hearing, or at least went through the confirmation process when he was U.S. attorney, but he's never been on this sort of stage is what I'm driving at. This isn't a confirmation hearing, but he's never been on this stage. He hasn't even really done interviews with big mainstream outlets. He had that press conference, and that was really the first time he spoke publicly. He appears at events where he doesn't take questions and gives prepared speeches, but this is a different environment for him, so you can only sort of prep so much, and you can already see he's coming out fiery. I would have thought his preppers would have said, be calm, answer the questions very coolly. The Democrats are trying to get you riled up, because you can see he is sort of getting riled up. I mean, the 5-minute thing was just remarkable to me.
I was struck by the thing he said at the very end about how he's so surprised they haven't asked questions about criminal justice or opioid. I mean, that feels like an attack that he had planned to undercut the Democrats sort of insisting on talking about the things that are most difficult for him to answer, but something you might have expected him to pull out a little
like
later.
an hour from now.
I mean,
it's a little premature.
No one's asked any questions. What do you mean you aren't surprised you haven't gotten questions?
Only 2 people have asked questions so far. Yeah, it did seem a little bit like a Hail Mary getting thrown in. Our colleague Rhonda Colvin is live on Capitol Hill. Rhonda.
Thanks, Libby. Yes, as you guys are mentioning, we haven't gotten that far yet. We've only been in this hearing for about an hour now, and we haven't heard much. Of course, the moment that stood out to me, I've been sitting in the hearing room, the moment that stood out to me was when the acting AG reminded the chair of the committee, Representative Nadler, that your 5 minutes are up. So that in the room, I looked at the faces of some of the representatives who are on this committee. They were kind of shocked. Everybody kind of laughed it off. But that certainly was a shocking moment for him to remind the chair of the committee that he only had 5 minutes to question him. So this might be what sets the tone for the rest of this afternoon. And I think it was Ross who mentioned this, that he did, toward the end before the break, mention that we haven't gone over some of the great things that the DOJ has done, and I want to talk about those things. Well, also in his opening statement, he also spent a little time talking about border security and that our borders are porous. That's certainly not what this hearing is about, so it does show that he is certainly keeping in step with the Trump administration and trying to put the DOJ in a great light and trying to change this hearing around from what the purpose is today for it. So we are still here outside of the hearing room, and we will report back with what we hear next. Back to you, Libby.
Rhonda Colvin, live on Capitol Hill. You really get the sense of how the House operates differently than the Senate. As soon as Congressman Doug Collins began speaking, the top Republican, he was telling a story about Easter egg hunting with his kids, and the House has more of like a freewheeling, local, tell some stories feel to it, and it's like, oh yes, the House is relevant again. Not just for Democrats, but also for Republicans who want to be able to throw some firebombs and push back against the new Democratic control of the House of Representatives. But it really is different than the feel of the Senate, where there is a bit more sort of decorum, less personal storytelling perhaps. And when someone like Lindsey Graham sort of lets loose and gets angry and yells, it's almost shocking. It makes news, as he did in the Kavanaugh hearings. This is a little more standard operating procedure for the House, Matt.
It's a bigger committee, too, than like the Senate Judiciary Committee, and there's more young members. We haven't really even gotten to them yet, but it does feel like it has more of a kind of circus feel with that many people crowded into the room.
It's about 40 members on this committee, more Democrats than Republicans, but the goal is for all of them to get a chance to ask questions today.
And you saw Republicans trying to make their points, too. I was struck that I think it was Representative Collins who was raising questions about the arrest of Roger Stone. So he starts with, well, were you briefed on the arrest of Roger Stone? And Matt Whitaker says, sure I was. And then he says, well, were you aware that a CNN reporter was staked out outside Roger Stone's house? Republicans have this view that law enforcement kind of leaked this in advance to CNN, so they were ready. I've seen some reporters on CNN disputing that occurred. They said, look, we knew there was grand jury activity the day before. Roger Stone was such an obvious person who was probably going to be indicted and arrested, so we just guest and showed up there at the time the FBI would be there. But Collins is pressing this point, like, was there wrongdoing? And Whitaker, who's friendly to Republicans, says, well, I'm concerned about that too. Now, he didn't say, and we've determined there was a leak. He sort of pushed back on that notion, but even saying, well, I'm concerned about that too, is sort of a boon for Republicans.
That question about CNN was really leading, Roz, and obviously Congressman Collins was trying to make a point. But CNN has said that they did reporting that led them to stake out Roger Stone's house.
Yeah, and if I remember correctly, there were also news crews outside Paul Manafort's house on the day that he was indicted, though there was no public indictment before then. Because what happens in these situations, and what very much happened in the Roger Stone situation, is you know, people have been staking out the grand jury, and there's a lot of public attention on what might occur. And big news organizations like CNN will often stake things out. I mean, I wouldn't be surprised if they've been outside Roger Stone's house for some previous Fridays, which is the day that we expect grand jury action in the Mueller probe. So, you know, there's really been no evidence thus far that CNN had advanced knowledge. And I agree with Matt that it was very striking that he kind of just let that conspiracy theory hang out there, which is helpful to Republicans, but certainly not helpful to the Department of Justice, which he currently leads.
That's such an interesting point. If he's no longer going to be the Attorney General in about a week's time, which is expected because Barr made it through his initial process with the Judiciary Committee yesterday, he's expected to be passed by the full Senate next week. How relevant do you see this figure, Roz? I mean, is the line of questioning today, is it important what members of Congress are able to pin him down on, or is this a bigger harbinger of what's to come as Democrats try to pull members of the Trump team in to these hearings and get some answers from them?
I mean, my sense, I'd be curious to hear Matt's. My sense is that this is very much a blip, and it's part of why you can already feel this going kind of in the circus direction, because both parties feel this as a moment to score some political points rather than exercise true oversight over the Department of Justice. You know, he is not going to be the person who's in charge as the Mueller probe comes to a close here. His views on that matter will not ultimately be terribly important. I do think there is one broader point that Democrats probably want to make, which is you have all of these cabinet secretary positions now being held by acting appointments, as opposed to permanent appointments where people have gone through a confirmation process. So Matt Whitaker keeps saying this is not a confirmation hearing, and he's right. And I think, though, for the Democrats, they kind of want to point out the dangers of having people serve in these important roles who have not, in fact, gone through a confirmation hearing to hold those roles. They haven't had an opportunity to ask Matt Whitaker these questions, despite the fact that he has led the Department of Justice, one of the most important jobs in our country, for quite some time now.
Matt, you pointed out earlier, you and Aaron Blake, when he was in our studio, that the president has said that he essentially likes to have this control and authority. I think this is something that Aaron said, to the degree that if someone is acting, the president ultimately retains a lot of control and power because he can move people around, he can shift people out of the job. Also, people he's appointed, his team members, don't have to have their feet held to the fire by a Senate committee.
Yeah, I mean, confirmation can be an issue. It probably would have been a big issue for Matt Whitaker if you look at his past. Roz has done some great reporting on this patent company that he was involved in. It was accused of fraud, and he was like way more intimately involved than he let on. There would have been a lot of issues at his confirmation here, but he never had one. Trump was just able to put him right in the job. I think there are potentially some longer-term repercussions out of this hearing for him. President Trump still really likes him, and I think he just interviewed with some Heritage Foundation publication, I want to say, that suggested maybe later on he would come back for a White House job or come back for a Justice Department job. His performance today could certainly affect that. And I think the one lasting way Democrats could score points here is to get at Trump through Whitaker. If he does slip up and detail something Trump said to him about affecting the investigation, and so far he's denied that anything like that happened, but if he said something that was damaging to Trump, that could have lasting implications, even if, you know, Whitaker himself can't sort of affect the investigation after next week.
Roz, was there a moment, a window, when we could have seen Matthew Whitaker named as the permanent Attorney General, or did the stories just sort of start tumbling out too quickly during his tenure to make that a potential reality?
I think that was a possibility. I would defer a little bit to Matt, who covers the Department of Justice, but I do believe that because of President Trump's personal affection for him, that there was a time when it appeared as though he might indeed be appointed to serve in this job in a permanent capacity. It did seem like that idea faded fairly quickly. I think both in response to some of the coverage of his past that was coming out, and also, frankly, the fact that the soon-to-be Attorney General, Bill Barr, agreed. I mean, he is an extremely respected figure in the legal community. He had a much more robust resume for this job, and once he sort of quietly sent word that he would be willing to do this job, I think Matt Whitaker's days in it were obviously numbered.
Let's talk more about Chairman Nadler's questioning of Matthew Whitaker and what's happened so far. He's been asking him about whether or not he was briefed, obviously, on the special counsel's investigation, but he was clear to ask a question of, were you briefed on that when you were still serving as the chief of staff to Jeff Sessions? So not the acting attorney general, but back when you were working for Jeff Sessions was still the attorney general, were you briefed on that? And Whitaker sort of did a, I'm not going to answer, but no, I had no involvement in the special counsel's investigation. So the answer is no. Right. And so then Nadler says to him, so the answer is no. Like, so what you're saying in that, all those words is no. Why is that a question that Jerry Nadler wants to get at? The idea of being briefed as the acting attorney general versus being briefed way before when you were the chief of staff to the attorney general?
Well, I think a couple of reasons. The most important one is Sessions was supposed to have been recused. So if his chief of staff is getting briefings, does that implicate Sessions' recusal? There was also some reporting, and I don't think we've confirmed this, that Whitaker might have been chatting with the White House at that time about the special counsel's investigation. So if he was somehow getting information, actual information from law enforcement about it, as opposed to like somebody in the White House says, oh, this thing is really irritating us, that could be significant. He said no, and again, I don't think we've been able to confirm this reporting that he was doing something or getting information about the special counsel's investigation, but I think that's why he wants to know about it. I was more confused about him asking about this later time period, like a specific time period, and there was a chippy exchange on that.
Yeah, so it's like the time period between December 19th and Christmas. So whether or not he was briefed on the Mueller probe during that window, it seems like the time that he was deciding perhaps whether to recuse himself from the investigation?
I guess potentially, and are they saying like, were you briefed before? But
before
ethics officials
yourself,
wanted him to recuse
before you didn't
anyway,
recuse
so
yourself,
sort of what does
right,
it matter?
right.
I was confused by that line of questioning. He sort of very testily responded, why does that matter? Why are you asking that question? Which is a weird way. It's a way to gin up the circus atmosphere, but it was an odd exchange.
Ross, why are these timelines important? I mean, just sort of big picture, as we hear Democrats, and they'll continue to ask questions about sort of decisions that Matthew Whitaker made, information that was shared with him, information that was perhaps kept from him when he was still on Team Jeff Sessions. Why does all that matter?
Yeah, I mean, I think one of the big questions from the minute that Bob Mueller was appointed was, has the President of the United States been interfering into this investigation that ultimately is of his closest associates, his campaign, his transition, and of himself? And so, there has been a longstanding feeling from Democrats that his public action has served to obstruct the investigation, and a lot of questions about what he's also doing privately. And so I think that's what they're ultimately trying to drive at is, did President Trump interfere in the investigation by exercising pressure on people at the Department of Justice, pressure on Jeff Sessions, pressure on Rod Rosenstein, and now, of course, pressure on Matt Whitaker. And that's really what they're trying to ask. Has there been inappropriate political pressure brought to bear on this extremely important investigation?
If Chairman Nadler holds this threat of bringing back Matthew Whitaker for a deposition, which then Nadler said would then be released public, How much power do we really know that the chairman has to do that? Obviously, the subpoena is the big thing that's been hanging in the air, the question mark of the subpoena.
Yeah, it would be a fight, and truth be told, I don't know, particularly after Matt Whitaker leaves the department, how much authority he had. Matt Whitaker would be way more comfortable resisting. I mean, when you're the Attorney General, it is politically uncomfortable to resist answering questions, oversight questions. When you're just a man out there commenting on CNN or whatever he chooses to do afterwards, it'd be much more comfortable for him to resist. Theoretically, though, the House could subpoena him. He could then talk to the president about, are you invoking executive privilege on this? Could I talk about this, as we discussed earlier? They presumably would negotiate in most situations like that. They just come to an agreement. If they don't, it would be tied up in court. These battles between the executive branch and Congress about how much the executive branch should reveal generally don't get tied up for weeks. They get tied up for years. If you think about the Fast and Furious case, that would be something that would proceed for a long, long time. And with Matt Whitaker outside of government, I'm not sure how much anyone's appetite would be to fight out something like that.
You're watching live coverage from the Washington Post of this House Judiciary Committee hearing where they're asking questions of the acting Attorney General, Matthew Whitaker. I'm Libby Casey. I'm joined by Matt Zapotosky and Rosalind Helderman here, Washington Post reporters. And this hearing only got underway about an hour and 15 minutes ago. They're taking a break right now, though. They'll come back soon. But there are 40 committee members that all want to have their turn to ask a question of the acting AG, some of whom this will be their first big moment in the spotlight as new members of Congress. So there are people chomping at the bit to get their opportunity to ask a question of a member of the Trump administration. It's already been full of fireworks, so as soon as it resumes, you can certainly expect more. A procedural matter, right as things started, the top Republican, Doug Collins, asked for it to adjourn. And so you saw them call for the clerk. They had to sort of scramble around, find the clerk, and then she did a roll call on what she was asking for. They did first a yay or nay, and then the Republicans said, well, we want to get the names on the record here. So you saw them go down the line and have everyone sort of say, yes, I think we should still keep going, or, yes, I think we should adjourn. Obviously, Democrats have the win on this because they have the majority. But all that does slow down the process, and it does sort of draw out the hearing. It should be pointed out that Democrats did similar things when they were in the minority. So this is nothing new for how Congress works.
Yeah, I'm always, and Roz covered Congress, so she could probably comment more about this, but I'm always amazed by the stunts that get pulled at the beginning. Even with Barr's Senate Judiciary kind of advancement hearing yesterday, Democrats voted against scheduling a time for the vote. And it's like, what is the purpose of that? You're never going to win. Do you really think Republicans are just going to say, yeah, if we can't agree on a time, we'll let it pass? And then today, you're never actually going to successfully adjourn the hearing. It felt like a stunt to me. I'm confused on what the political calculus is there, maybe.
Yeah, I mean, I covered Congress, and you see stuff like that all the time, and it's not always clear what exactly they think they're getting out of it. I think what they think they're getting out of it, frankly, is a press release, ability to go on media for one side or the other and talk about what they had done. Obviously things like that are everyone understands to be losing propositions, but it's just another way to make the point. So Collins wanted to make the point that he thinks this hearing is not truly oversight, which I think that's going to be the Republican theme. Democrats, and it's going to set the stage for a lot of what we're going to see from Congress over the next 2 years. Democrats are going to say, this is oversight. This is what Congress is supposed to do. It is our role in a constitutional democracy is to explore what the executive branch is doing and make sure that it's working properly. And Republicans are going to try to say, this isn't really oversight. All this is a vendetta against the president. And so, it is setting a tone for what's to come.
Let's go back to our reporter, Rhonda Colvin, who's live on Capitol Hill. Rhonda.
Libby, yes, we're still here in front of Rayburn 2141 where the hearing is taking place. The committee is still on a break for votes. And in terms of the mood in the room when we were in there earlier, it is a packed room. There not a lot of seats are left, and a lot of members of the public are there. I saw a line coming in early this morning. I mentioned it earlier in the show that we saw people as early as around 7 o'clock this morning just wanting to be here, wanting to hear what he has to say. I can't discern whether or not not they are supporters of him or just curious spectators, but the room is full of members of the public. Of course, this could go on for a while now, especially how we've seen the first part of it go along, and we'll stay here and see how things turn out. But as far as that mood in the room, everybody's just waiting and listening and anticipating something. So back to you, Libby, in the studio.
Let's talk more about what Republicans can get out of this hearing. Obviously, they can have some moments of publicity, and like we saw with Congressman Collins bringing up the question of how did CNN find out about the Roger Stone indictment, so they can sort of use that in their own social media feeds and to promote things that they care about. But are there lines of questioning that you expect to hear from them? If they're not focused on the Mueller probe, will they be asking about Hillary Clinton issues? Will they be asking about some of these questions of leaks?
I think so, and I think one of their big aims before Democrats sort of took the House was the issue of a second special counsel. And you've seen them ask questions around the edges of that, you know, about what John Huber, this U.S. attorney out west, who is like looking into a lot of Republican concerns about the Inspector General investigation of the Carter Page FISA warrant. I think that's where they're going to try to make their bones at this hearing. What Matt Whitaker is going on with those investigations. Now, he signaled he might not be able to talk a lot about them because they're ongoing, but even him saying, yes, we're still looking at Uranium One is going to like drive Republicans, you know, crazy in a good way. You know, they're going to be happy to hear that.
Yeah, I was just going to add, you know, we've seen, I think, the CNN question and then another one already so far about this guy, Bruce Orr. I mean, he gets such in the weeds of the beginnings of the Russia investigation. And, you know, the traditional response to that question from a leader of the Department of Justice would be what he kind of came to at the end, which is that this is a personnel matter and I can't comment on it. But you know, that's not all we heard from him, and you can sort of feel this tag team between him and the Republicans on this. So, you know, he had a whole lead up before he said he couldn't comment on this personnel matter, which was, I think this is a desperately important issue. I know that the public is very concerned about it. I'm very concerned about it. There's an Inspector General looking at this. John Huber, the U.S. Attorney, is looking at it. But I can't say anything.
But I can't say anything.
So I think that's going to be, you know, I think when we see the coverage of this hearing tonight on Fox and then the Daily Caller and some of the other conservative outlets, I suspect there's going to be a lot about those issues, everything that John Huber is doing and the Inspector General, and a lot less on some of the other matters.
What does all this mean for Bill Barr as he prepares to come into the role of Attorney General? We expect the Senate to confirm him as early as next week. Does this leave a lot of baggage on the table for him, or are Department of Justice employees as well as sort of the machinery of the government seeing this as a side road that's being taken?
I think it is a little bit of a sideshow in terms of Barr. I mean, I don't think he's going to be held to account for anything Whitaker says about what Whitaker did, except things that he might need to clean up.
Right.
You know, if Whitaker mismanaged the department in some way, and now that falls to Barr.
Or could Whitaker say things that would then leave lingering questions that Barr would have to answer, like, no, we're not doing X, Y, and Z. No, we're not. I mean, is that a possibility?
That certainly could be the case. And I think one issue that could come up for Barr that Whitaker is going to be pressed on, I think has been pressed on a little bit, is the issue of recusal. So Matt Whitaker did not recuse from the Mueller probe, even though he had given extensive public comments critical of the Mueller probe. Bill Barr, sort of similarly, had commented publicly on the Mueller probe, not quite as critically as Matt Whitaker did, but still sort of skeptically. And most importantly, he had written this memo, an 18-page memo that he sent to the Justice Department, really lambasting what he viewed as the theory that the president obstructed justice. I think the precedents that Matt Whitaker set on recusal will come into play for Bill Barr. Now, so far they would be very helpful to Bill Barr. He could say, well, Matt Whitaker didn't recuse and he had an appearance, so I'm following the same precedent. But I think the answers he gives to questions about how that process laid out, that could have an impact for Bill Barr, who will himself have to go through some ethics review when he steps into the job.
We're already seeing questions about the timeline of decisions on recusal, but we do expect questions to come up very directly about why Whitaker chose not to recuse himself from the investigation. Is there anything there yet to be learned, Roz?
I think that there is. Matt covered that issue quite closely. you know, it was this very unusual process where you've got career ethics people who are supposed to look at this, and then Matt Whitaker asked this sort of separate group of people to kind of serve as a go-between, and they gave him different advice. So I think there's a lot about that process that was unusual, and hence will allow room for questions about how exactly it unfolded.
Yeah, sort of why did you assemble your own personal ethics squad? Why didn't you use the career people? You know, what precisely did the career people say? Did you ever talk to them directly? What did they say to your own ethics squad? Who even is on your own personal ethics squad? They haven't identified those people by name. So there are a lot of questions that we have about that whole issue. And he has indicated in his letters that he's willing to answer them. So I hope we get more into detail than just timeline issues.
Something that Chairman Nadler also laid out as a line of questioning is if those people had conversations with the White House team members. And there are also a lot of questions that the chairman wrote out in a letter a couple of weeks ago about conversations that Whitaker may have had with not just the president, but other White House staffers, and then also the president's private counsel, the president's lawyers. Do we have a sense of how far the blanket of executive privilege extends when you're talking about conversations that an acting attorney general might have with staffers or might have with attorneys?
I mean, the issue of executive privilege is very complicated and hasn't been fully tested in court. And so it's going to be interesting to see, you know, as he is asked more questions, in what cases he chooses to exert it. I wouldn't imagine that executive privilege would cover the president's personal attorneys, but when it comes to the White House counsel's office, that's an entirely different matter. I mean, you have this issue of the memo that Matt was referring to that Barr wrote as a private citizen, sort of a scathing memo of the notion that the president could be guilty of obstruction of justice for exercising his constitutional powers, in this case to fire the FBI director, firing James Comey. And it's a long sort of scholarly memo, and we know that ultimately what he did with it was he submitted it to Rod Rosenstein, sort of one former attorney general to another acting attorney general, in this case of the Mueller probe, sort of explaining his legal view. But we also know that before that happened, he consulted with quite a few people about his ideas on this matter, including people in the White House and including people in the president and other sort of personal legal defense attorneys. And you know, why he did that, whether that was appropriate, there's certainly questions about that. And I think he will continue to face those questions going forward.
And yet he was able to get through his confirmation hearing process with the Judiciary Committee over on the Senate side without having to reckon with some of that.
Yeah, he, you know, I think some of that comes from his longstanding reputation. He is a very well-respected lawyer. He's also very good at this. Unlike Matt Whitaker, the rookie, he has done this a lot. And I think you could really see it in his hearing, that he was very comfortable in the setting of answering even difficult questions from Congress. And you know, he had that quality that so far we've not seen from Matt Whitaker that I think is very common from people who successfully navigate congressional hearings, which was sort of a calmness, sort of a, you're not going to rattle me. I'm going to listen to every question and very reasonably answer, and you know, respectfully, apologetically not answer when I can't. But I know that your job is important. You know, that is sort of the attitude you see from a lot of witnesses that really survive congressional hearings without getting bloodied.
You almost don't realize what a skill and an art that is until you see someone like Matthew Whitaker, who is not as used to doing it, have to face this panel of 40 people who are asking him questions, Matt.
Yeah. He's more combative, and I mean, it's easy to be more combative too when you're going to be out of the job.
Very
next
true.
Week.
He
Bill
doesn't
Barr is
need
coming
anything
into
from
the
these
Justice
people.
Department. He's
Yeah.
going to have a lot of these hearings. You don't want to have all this bad blood between you and a committee that oversees the department you lead. I would say, to your earlier point, Bill Barr had to reckon with that memo a little bit. In the middle of his confirmation hearing, Dianne Feinstein, the chair or the ranking member of the Judiciary Committee, comes out and says, "Oh, I think he's doing a great job. He's going to be confirmed easily." But then when there's this hearing to advance his nomination, she says she feels that memo is disqualifying. So he's almost certainly going to get confirmed. But I think there was a world in which he got a significant number of Democratic votes, and now he goes in like almost all of these Trump cabinet secretary goes in, which is totally, almost completely along partisan lines and with a little bit of rancor there. So the memo has has caused him a headache. It's likely not going to affect his ability to get the job, but certainly he would prefer to go in there with like 80, 90 votes, and that seems like totally out of the question.
Yeah, at this point, certainly. This comment that Matthew Whitaker made at a press conference a couple of weeks ago that raised so many eyebrows because he said that he was briefed in the special counsel investigation and that it was close to wrapping up. It got a lot of attention because we just have not seen chatter about timelines, about where the process is at. Roz, can you update us on what we do know about the special counsel's investigation? Give us the big picture of what we're waiting to learn.
You know, what was partly so interesting about that moment was it has become kind of conventional wisdom amongst the kind of pundits that you see on TV every night that the probe is wrapping up. There's going to be a big, detailed, meaty report from Bob Mueller, and it's going to be made public at the conclusion of the investigation, which is just around the corner. And you could almost see, I felt like in that moment with Whitaker, you know, he used to be a CNN analyst. You could almost see that he kind of for a brief moment forgot his role and kind of thought he was just sort of commenting on the news like he used to do. But of course he's not. He is the head of the Department of Justice. And so, you know, when you talk about what we know officially about where things are headed, that's really the one thing we know. It's the only thing anyone has said publicly. So, you know, I think we have every reason to believe that whether he intended to say that or not, it was accurate. The probe is wrapping up. Bob Mueller is required under the regulations at the close of the investigation to submit to the Attorney General a confidential report that will describe who was charged and who was not charged. And beyond that, we don't actually know about. We don't know when that's going to happen. We don't know what that report is going to look like. There's certainly scenarios where it is extraordinarily bare bones. There are other scenarios where it is much more detailed. And we don't know what happens to it after Mueller submits it to the Attorney General, who, you know, in a week we assume will be Attorney General Barr. The best we know about that is what Barr has said publicly, where he has offered some real cautions about you know, assuming that that report just becomes public upon submission in full.
Do we have more of a sense or insight in how a Barr Attorney General might handle the Mueller report and releasing it publicly versus a Whitaker Attorney General handling it and revealing it publicly?
I wonder if they'll ask him what he would do, what Whitaker would do. I don't think we know if Whitaker thinks, hey, we can release this publicly. We know that Barr thinks that that the regulations don't call for him to do that, but he has also said, I'm going to be as transparent as possible. I don't think we have a good sense of how Barr and Whitaker would differ.
But Whitaker has not really, you know, because he didn't have a confirmation hearing, Whitaker has not really addressed those questions publicly. And of course, the strong sense from everyone is kind of doesn't entirely matter since he's not going to be the one making the decision. I mean, the regulations also require that the Attorney General make some kind of report on the conclusion of the investigation to Congress. So, you know, one option is Bill Barr basically takes the Mueller report that he receives, slaps a cover letter on it, and ships it up to the Hill. But I would not guess that that is automatic by any stretch of the imagination based off of what Barr has so far said about this.
Let's head back to Capitol Hill and our reporter, Rhonda Colvin. Rhonda.
That's right, Libby. You know, one of the things that has affected the mood in the room is the recent passing of Representative Dingell. Of course, we learned of that passing last night, and that is on the minds of this committee. Of course, Representative Nadler did begin this hearing discussing and giving a tribute to Mr. Dingell and the service that he had to this body. So that is sort of also affecting the mood in there today. Even though this has been a bit of a contentious hearing at the start of it, that is part of the mood here as well. Members, of course, that's a time, a bipartisan time, when members do come together honoring one of their colleagues. And I do think that you might see that later on in the hearing as well, mentions of him, mentions of his service. He is, of course, the longest, or was the longest serving member in U.S. history. So again, that also affects the mood up here on the Hill. Back to you.
All right, yeah, it's such a big news cycle in the last 24 hours alone. And we sort of wondered, Matt, this morning, like how much attention and airtime would this get? Because there's so many news stories going on right now. The passing of John Dingell, just one of them, and certainly hanging a huge cloud over Capitol Hill as people reflect on his legacy, his life story, his time in Congress, and all of the legislation he contributed to. But Democrats and Republicans want this to hit the airwaves to some degree, as long as they can come at it with their own control over it and get their own political points out of it.
I think Democrats in particular,
Yeah.
it feels to me like it would be a win for Republicans if this was
If
just
it
kind
just
of
went
a
away.
boring oversight hearing.
Well, I did wonder if that was part of the idea of like Matthew Whitaker not testifying today, because the White House has a couple potential wins in the bag, right? They got William Barr through his process of getting through the Senate Judiciary Committee yesterday. There is talk of a potential deal on avoiding another government shutdown, perhaps some sort of border funding bill that the committee's trying to craft, that bipartisan, bicameral committee. So there are some things that the White House could make a lot of hay out of. It seemed like it might be in their best interest to keep this below the radar. But yet you see Republicans already with Doug Collins trying to totally upend the direction of this hearing by getting at his own questions.
Of course, and I think Roz made the great point earlier that they're setting the stage for probably what a lot of these hearings are going to look like going forward. You know, they're going to say, you're asking all these irrelevant questions to personally embarrass Trump or personally embarrass one of his nominees or cabinet secretary. We're supposed to oversee the government. That's not what we're doing here. That's what Matt Whitaker drove at in sort of spontaneously answering a question from Collins there at the end. That's certainly what Collins is driving at every time he says, well, this is going to be a rabbit hunt with a lot of holes or something. You know, I think that's what Republicans are going to drive at. I do think that they would prefer it not make big news. I've always thought it was going to be a big newsy hearing because Matt Whitaker just doesn't do this. You know, as I keep saying, he doesn't give interviews to people and kind of slip out little bits of news. He's done that one press conference and it didn't go all that great for him. He kind of slipped up and revealed more information than we've ever learned about the Mueller probe in 2 years. So he doesn't do this when he's going to be grilled for hours and hours by angry congressmen of the political party opposite his. That's going to make a lot of news. So I always expected, provided this happened, which seemed touch and go there for a while, was going to be a newsy thing.
Yeah, CNN came out with a poll this week saying that 87% of people polled want the Mueller investigation to create a public report, for that process to generate a public report. And it just got me wondering how influential that is in the minds of Department of Justice officials versus lawmakers generally. How important is the public's hunger and appetite for some results here as everyone makes decisions about just what we learn, Roz?
Yeah, I do think that is actually fairly important. I mean, I've always believed, as you know, you have these conversations about does the Mueller report become public. You know, it's one thing to focus on the wording of the regulations, but I've always believed that the political complications of there being a report, the people knowing that there is a report and not making it public will at the end of the day be sort of overpowering, that it just is not politically tenable to keep that report secret, given how much attention this investigation has gotten over nearly 2 years, how much public attention there has been on it. That said, I also think it's very important to understand that the wishes and interests of one person, Bob Mueller, are really critical here. You know, there are ways he could write that report that would make it easier to make it public. There are ways he could write that report to make it harder to make it public. Does it include grand jury material, which is generally illegal to be made public? Does it include classified material, which has its own complications? Does it include a lot of material about people who weren't charged? There's also ways he could write that report that would be very educating, that would help people understand everything he learned in the course of his investigation. There are ways he could write that report that frankly would tell us very little new, that would basically just say, we charged Paul Manafort, we charged Michael Flynn, we charged Michael Cohen, all these things we already knew. And the truth is that he is such a disciplined and silent figure in this matter that we actually don't know how he views his own role. Has he viewed his role as a pure prosecutor to find crimes and prosecute them, in which case we know everything that he has done, or does he view his role as being, to educate the public about what Russia did during the election and any interactions they had with the Trump campaign?
Matt, thoughts on that?
Well, look, I think we had some precedent for this in the most politically charged investigation in history before this one, which was the investigation into Hillary Clinton's private email server. And James Comey, then the FBI director, kind of went the transparent route when he announced they weren't charging Hillary Clinton. He had a big press conference where he read a detailed recitation of the facts that they found, many of which were unflattering to Hillary Clinton. Unfortunately, that precedent went extremely poorly. Everyone on both sides of the aisle sort of agreed that was the wrong thing to do. So if you look at that in the context of Mueller, and I'm sure Mueller followed that very closely. Recall Rod Rosenstein, who appointed Mueller, wrote a memo saying, essentially, James Comey has to leave the FBI because of that decision. If you look at it from that lens, maybe Mueller will decide, look, we can't reveal all sorts of interesting to the public but not relevant to a crime that we charged information because we'll have the Comey issue. So I deeply worry. We have all sorts of questions. We don't really know what's on Mueller's mind. He's such an enigma. Does he see himself as answerable to the public? Is he reading that CNN poll thinking, geez, I really need to provide some answers? Or does he feel like he has provided what he needs to provide just in the people he's indicted and the details he's laid out in an indictment? I could certainly see a world where his report is one page. We decided to charge the following 34 individuals. We declined to charge anyone else. We appreciate your time, and that's it. And that would be very disappointing to the public. Now, I think you would get some transparency no matter what, because as in the Hillary Clinton case, Congress is going to go after this. They're going to be looking for 302s, which were released in the Hillary Clinton case. They're going to be looking for an investigative summary, which was released in the Hillary Clinton case. So I think even if he doesn't want to, Congress is going to doggedly pursue this, and I do think we will learn more, at least than what we know right now.
Mm-hmm.
Is there a world in which we would see Bob Mueller come before Congress?
Yeah, absolutely, I think. Yes.
And what's the timeline? Like, could that happen very quickly after a report is released?
Potentially, yes. As I recall, I mean, James Comey, which, as Matt noted, is widely seen as a not great precedent, but he was on the Hill repeatedly talking about the steps that his FBI undertook in that investigation. I think there is a world where the report is very bare bones, but the intention actually is to provide some more detail through a congressional process, with the understanding that he's a prosecutor. His job is to prosecute crimes, but Congress has a different role in our system, an oversight role. It's really Congress's job to kind of find answers about what happened that's not criminal behavior. And it may be that there's some kind of purposeful effort to have the special counsel's office assist Congress in that job by testifying, by providing some documents beyond the final report. But I mean, the truth is that for all that this gets discussed, we just don't really know it all, which is kind of unusual in Washington and maybe a little fun.
Well, if you contrast it with the Starr report, I mean, there were so many leaks, there were so many ways that the public was learning about it, that reporters were learning about it, lurid details coming out constantly. It's such a different scenario.
And that's actually a great contrast, because I think a lot of people are really expecting that this will wrap up as that did, with a report, a very thick report that goes to Congress and is immediately made public. But what some people may not know is that Ken Starr worked under this independent counsel law. That law expired. It was not replaced because of the feeling that that process had not worked well. And so Bob Mueller instead works under these regulations, which are just Department of Justice guidelines about how things should operate for a special prosecutor. And those guidelines were written very purposefully to correct what were seen as the errors of the Starr era. And the Starr report and how much detail it contained about people who were not charged with crimes was considered a real misstep. And so when that language was written about what the special counsel is supposed to do at the end of a probe, write a confidential report to the Attorney General, merely say who was charged and who was not, that was intended to prevent a Starr report, not to facilitate one. And so I would not expect we're going to get something that looks quite like that again.
I'm Libby Casey, and I'm with Rosalind Helderman, who's a reporter here at the Washington Post, focused on political enterprise stories and investigations. Also, Matt Zapotosky, national security reporter who focuses on the Justice Department. We're standing by for this hearing to resume, the House Judiciary Committee hearing to resume. The acting Attorney General, Matthew Whitaker, is facing the music today in some of his last days as the acting Attorney General. That's the anticipation, because Bill Barr got through a big process yesterday, getting pushed through the Judiciary Committee over in the Senate, and we do expect him to go through the entire Senate successfully next week. The House went to take some votes, and so that's why you're seeing this holdup here. We only got through 2 people asking questions. We've still got nearly 40 more to go, so I'm not sure if it's going to require a lot of caffeine, or if what they're going to do exactly, how long this Friday may go for some of these members of the hearing. It's all by seniority, so if you're a brand new freshman eager to have your moment, to ask your questions, you're at the back of the line, really, because that's the way these committees work, and that's the way the process works. The goal is for each member to ask just 5 minutes of questions. But it's really up to the chairman to enforce that rule. Contrary to what the acting Attorney General thought, it's not up to him to enforce it. If you were watching earlier, you would have seen a surprise moment when Mr. Whitaker told the committee chairman that his 5 minutes to ask questions were up, which got a lot of sort of shocked, audible gasps, because it's usually not the witness who dictates the time schedule. We can look at some of the greatest hits here of the moment of the hearing so far. Let's take a look at what we've seen at this point in the hearing.
Now, in your capacity as acting Attorney General, have you ever been asked to approve any request or action to be taken by the special counsel?
Mr. Chairman, I see that your 5 minutes is up, and so I'm here voluntarily. We have agreed to 5-minute rounds, and
The committee,
I think that's a fine place to end the 5-minute rule.
the committee will come to order. I will point out that we didn't enforce the 5-minute rule on acting Attorney General Whitaker. We will.
I understand, Mr. Chairman. I was just saying that might be a good breaking point at that point for you.
No, the Attorney General was in the middle of saying something. Answer the question, please.
Regular order.
Should I ask the question? Okay.
Yeah,
In your
could you
capacity
please
as
ask the
acting.
question?
Let me just repeat the question so people remember what we're talking about. In your capacity as acting Attorney General, have you ever been asked to approve any request or action to be taken by the special counsel?
Mr. Chairman, I, as the acting Attorney General, I am under the special counsel's rules. I am the person that is ultimately in charge of the investigation, and I have exercised that authority under the special counsel's regulations of the Department of Justice.
So I assume the answer is yes.
Regular order, Mr. Chairman.
I assume the answer is yes. You have been asked to approve a request or action, and you've said yes or no? In other words,
Mr. Chairman, I want to be very clear about what you're asking me. Are you asking me if I have asked the special counsel to do something?
Regular order, Mr. Chairman.
is this whole thing? Well, I'm asking if I think my words were clear enough. Have you ever been asked to approve any request or action to be taken by the special counsel? Last week, you commented on the status of the investigation, stating it was close to being completed, unquote. This was said despite the fact you recognized just moments before that it was ongoing, stating, quote, I really am not going to talk about an open and ongoing investigation otherwise, close quote. So all I'm asking you is, have you been asked to approve or disapprove a request or action to be taken by the special counsel?
Point of order, Mr. Chairman.
I've asked the question.
Point of order, Mr. Chairman.
Point of order is not in order until the question is answered.
We're not operating under the 5-minute rule anymore then?
Point of order, the witness will answer the question.
I want to be very specific about this, Mr. Chairman, because I think it's going to allay a lot of fears that have existed among this committee, among the legislative branch largely, and maybe among some American people. We have followed the special counsel's regulations to a T. There has been no event, no decision that has required me to take any action, and I have not interfered in any way with the special counsel's investigation.
Testimony earlier by the acting Attorney General, Matthew Whitaker, perhaps the most important thing to come out of this hearing so far, what he said at the very end.
Look, we're so early in the hearing. I feel like we've analyzed at length what he said, and there's only been 2 questioners. But I think, saying that there was no conversation with with President Trump, with any White House officials. To me, that was a standout moment. The chippiness was a standout moment, which you saw at the beginning there. You know, your 5 minutes is up. He's a former football player. You know, I'm very mindful of the clock, I guess. He's used to enforcing the laws as the Attorney General. But, you know, I guess we'll wait and see what's to come.
So far, we've had House votes. So if you're wondering why this pause so early in the process, this isn't because of things happening behind the scenes related to the acting AG and the committee. This is just protocol, getting business done in the House of Representatives. They were doing a series of votes, also taking a moment of silence to acknowledge and honor the passing of John Dingell, the congressman from Michigan, who was the longest serving member of Congress. So that's what's happening simultaneously. And as those votes are open, House members go over, they pause the hearing, and then everyone is expected back quite shortly. So stay tuned if you're wondering when this is going to get rolling again. It should be quite soon as we see this panel reconvene and get questionings underway again.
Yeah, and it's not surprising that it's taking this long. I used to cover Congress, so I can tell you that the time limits for votes is a very elastic thing. You'll often have a series of votes. It'll be like, I don't know what this morning's series is, but it'll often be sort of a 15-minute vote, a 5-minute vote, and another 5-minute vote, and that often takes like an hour.
Right, if you do the math. It's
right.
like a 15-minute, a 2-minute,
right.
a 5-minute, a 5-minute. But
yeah,
it
that doesn't actually.
Yeah.
In fact, there was actually a little bit of joking about that at the very end of the hearing, where Nadler mentioned that he's been told that they're going to keep to the 15-minute timeline very strictly, and I think Whitaker sort of spat back, "Oh, we're doing that now? That's a new thing," which I thought was very odd because, I mean, why does the acting Attorney General care about how Congress structures its votes? But yes, this length of time is not surprising. And then, of course, after they're done with the votes, they have to sort of re-corral the members, get them back in the room, have everyone get in their seat, have the witness return to the table. So this is not an extraordinary length of time for a break.
Do you imagine this is a good, healthy reset for the acting Attorney General, though?
Sure, I think he is
So early in the process?
I think he's
Yeah.
probably convening with advisors now who are scrolling through Twitter, seeing how this is playing, have just observed in the room how this is playing, and they might be telling him, you know, hey, you know, calm it down a little bit.
Or maybe not,
Or
Matt. I mean, depending on what they want from this. I
Right,
mean,
that's true.
It's hard to know.
Yeah, that's very true. I mean, I guess I had that thought even as we were sitting here. He might like making this into a bit of a circus, biting back, because that helps the Republicans say, look, you're not here for legitimate oversight. You're here to embarrass Matt Whitaker, and he's kind of leaning into that a little bit. He can do that, of course, because next week he won't be the Attorney General anymore, very likely, so he doesn't have to work with these lawmakers again unless he were to come back into government.
As we watched Brett Kavanaugh and his hearing, there were some questions about his aggressive tone, if it was helping him or hurting him. But regardless, it did seem quite intentional and strategic in some way.
No, in that hearing, as I recall, he came in very hot, and then there was a break, and he came back,
Great
and he
point.
was much calmer.
Even apologizing to Amy
yes.
Klobuchar for a testy exchange he had with her.
That's
Yeah.
right. I mean, I do feel like this is an entirely different situation, much more of a standard kind of Hill committee. I mean, for one thing, as chippy, to use Matt's word, as this has been this morning, it's been nothing like the emotion of that hearing. And also, Brett Kavanaugh needed something, right? He was trying to get confirmed. Matt Whitaker really needs nothing from the people on this committee. So I wouldn't be surprised to hear him come back and be very similar to how he was in the first bit. In fact, I feel like he tested out that line about how he didn't think they were asking him about the right things, and I suspect we're going to hear that one over and over again. Where are your questions about opioid addiction? Where's your question about criminal justice reform? That sort of thing.
Yeah, it did seem like a little early to pull that line out. He's going to probably want that in his back pocket, tuck it away again to
it's Washington. There's no law that says you can't just repeat it over and over again.
Such a good point. Roz, since we have you here, I want to talk a bit about the work you've been doing, the investigative reporting and the work you've been doing on the Russia probe and where things are at. You know, the latest story that you have today is about Paul Manafort and how the prosecutors are now saying that he continued doing work related to Ukraine all the way up through 2018, even as these investigations and everything were rolling on.
Yeah, you know, it's been interesting. We have continued to see the Mueller team do two things in court that I think actually is quite relevant to our conversation earlier about how much information they want to release through the report. One is that they continue to make new revelations. There is obviously more material they have learned that they have not yet told the public about. And we can talk more if this break continues about some of the things we have learned just within recent weeks about Paul Manafort and what he was doing before the campaign, during the campaign, after the campaign. The other thing, though, that they have also continued to do is be very vigilant about requesting that material be redacted from the court so that it is not fully available for public view. So we get these sort of tantalizing hints, but a lot of it is being held back. And I can't quite read why that is. If it's because there is some ongoing investigation and they want to give this material to the public all at once, kind of with a bow, they don't want it to drip in the way that it would be dripped out in this particular Paul Manafort process, or if it's kind of that they've decided that it doesn't relate to crimes that are being charged, and hence they don't think the public should know about it, that it should remain secret potentially forever. So we're going to have to see over time, but that's been an interesting process to watch.
And Matt, you're part of this reporting team too. What are the implications of this for Paul Manafort, and just sort of what hot water he's in?
Yeah, so the reason that was filed is prosecutors and Manafort's defense attorneys are debating whether, even after he pleaded guilty, he continued to lie to the special counsel's office. And there are sort of 5 topic areas on which they say Paul Manafort lied. Paul Manafort disputes that he intentionally lied. He sort of chalks it up broadly to misstatements, getting confused in interviews, not having documents in front of him to review. What's at stake for him is a much longer sentence. So they had this hearing. It was all under seal. They unsealed it yesterday, and that's where we learned a lot of this stuff. What is at stake for him, though, is if a judge who at this hearing was trying to determine this, if she is convinced he did intentionally lie, he could face many more years in prison than he otherwise would have if he had continued to simply cooperate with the special counsel's office and they didn't come to believe that he lied. So the judge was hearing from his side and from Mueller's team about what these lies were, what evidence they had that these were actually intentional lies and not just sort of misstatements, and also why these lies weren't important, sort of an important component of federal law. So when you lie to investigators, it's a crime, but the lie has to be material or relevant to the subject they're asking about. So if I sat with the FBI and they were asking about my Washington Post work and I said, well, the sky is yellow, that is a lie, of course, but it's not relevant to what they're asking about. So a lot of it was about what Paul Manafort said to them. Were his lies relevant to their work? There were these big redactions on that subject that are so tantalizing, but we just can't make sense of. So they'd be talking about Kilimnik and his interactions with Kilimnik and this being core to their investigation, and that's significant because big black box.
Wow.
So, I hope one day at least that document will be unsealed, and there are likely many more like that that are totally sealed. Because there are tantalizing hints, and to Raz's point, we don't know if there's some explosive revelation that they're waiting to drop on us later, or if it's just boring, mundane stuff that they feel like we don't even deserve to know and will never deserve to know behind some of those black boxes.
But you bring up this name, Kilimnik. This could be significant, though, in the bigger picture of the campaign and end of Trump world, right?
Yeah, so this guy, Konstantin Kilimnik, was a Russian employee of Paul Manafort's consulting business before he joined the Trump campaign. From Russia, was living in Kiev, Ukraine, and helping Paul Manafort be a political consultant abroad. And we have been told through previous court filings that the FBI has assessed that Konstantin Kilimnik has ties to Russian intelligence. So he is basically alleged to be involved with the Russian intelligence services. And we know through both public reporting and through the Mueller probe that Paul Manafort was in contact with Mr. Kilimnik throughout the campaign. I think we at the Washington Post actually were the first to report that Kilimnik came to the United States from Kiev to meet with Paul Manafort twice while he was serving as the chairman of Donald Trump's campaign in May, And then critically, it now looks like in August of 2016, they have this meeting at the Grand Havana Club in a few blocks from Trump Tower in New York City, where Kilimnik has come from abroad to meet with Paul Manafort. We learned last night in this some of the sort of tantalizing details of this new hearing that Matt was talking about, that Rick Gates, who is also pled guilty to various crimes, also attended that meeting, that apparently for some reason those three men, Kilimnik, Manafort, and Rick Gates, felt like they had to leave the meeting separately. They appeared to be nervous about having been observed attending this meeting together. And we know, too, from some previous court documents that it looks like Paul Manafort at some point in time passed polling data from the presidential campaign along to Kilimnik. We know from emails that we at the Washington Post were the first to report that Paul Manafort had asked this man, Kilimnik, to get in touch with a particular extremely close to Putin oligarch in Russia named Oleg Deripaska and offer him private briefings about the campaign. So there's this enormously intriguing sort of fact pattern about the interactions that Paul Manafort was having with this man who's alleged to have ties to Russian intelligence during the campaign. But interestingly, Mueller hasn't charged anyone for anything about that. So where that's headed is a little hard to know. I mean, they said in the hearing that we just got this transcript for, that they believe that August 2nd meeting is at the heart of their investigation, but it hasn't shown up in any criminal charges. So what does that mean? I think we're all just still waiting to find out.
You're listening to Roz Helderman, Matt Zapotosky. I'm Libby Casey, and we are expecting this House Judiciary Committee to get underway in just a few minutes, really, and get the acting Attorney General back in the hot seat answering questions from both Democrats and Republicans of the House Committee. You know, we did get a sense of what the chairman, Jerry Nadler, wants to ask the acting Attorney General, because Nadler sent a letter a few weeks ago that outlined some of his questions. And it deals a lot with the Mueller investigation, but it also has some questions about just how much the president may have wanted to talk to Whitaker about the Southern District of New York. This Southern District of New York focus is so significant because they're doing a lot of the digging and the indictments and the investigating in other aspects that ultimately do affect Trump world, Roz, and you've been reporting on that, most recently relating to the inauguration.
Well, sure. So there are a couple of investigations in New York, and I might actually suggest that we start with the one that really personally implicated Donald Trump, the Michael Cohen investigation, where Michael Cohen has pleaded guilty to violating campaign finance law with regards to payments to two women who had said they had extramarital affairs with Donald Trump. Michael Cohen said that he did that and said it was a crime. The National Enquirer, which was involved with that, said that they did that. They agreed it too was a crime as part of a sort of immunity agreement where they were not prosecuted for it, but they agreed that it was a crime. And both AMI and Michael Cohen implicated Donald Trump in that, said that he was involved. Michael Cohen said he was acting at Donald Trump's direction. So, if it's a crime for Michael Cohen, it would sure seem like it was a crime for Donald Trump. There are these Justice Department guidelines that say or suggest that the president can't be indicted while in office. So we have not seen an indictment there. But that's a very significant issue where Donald Trump's prosecutors have basically said in court that they believe that the president was involved with the commission of a crime. And so I think it's been very interesting to hear the back and forth between the committee members and Matt Whitaker about that investigation and how it's being handled and how it's being shielded from political interference and what might happen from here on it.
And also the inaugural committee story just sort of has been breaking over the last couple of weeks, which is significant, not only because of what it says about the inaugural committee, but there are close personal people in Donald Trump's life, like Ivanka Trump, like his wife Melania Trump, who could potentially have been involved in some of this organization. I don't want to imply that they're named in these questions that the SDNY is raising, but they were integral in some of the planning and the process here. And so it would make anyone nervous as questions are being asked.
Yeah, I think one interesting, significant thing. So what happened this week is we saw a subpoena that was issued from the Southern District of New York to the president's inaugural committee, and requesting really an incredibly wide array of documents related to the inaugural. Everything about who gave and how they gave and what they got for their donations, and everything about the spending of the committee, the vendors, the contractors. So it's a little hard to know what exactly they're looking at because they seem to have cast such a wide net. I do think it's an interesting reminder that, you know, Matt Whitaker has told us that the special counsel probe appears to be wrapping up, but it's not exactly like once that ends, the president's legal troubles are over. You have all of these spin-off investigations that I think are very likely to continue, and who knows what else might pop up.
A question that Chairman Nadler wants to ask of Whitaker is whether the president discussed with him firing or reassigning people who work for that office of the U.S. Attorney for the Southern District of New York.
Yeah, right. So Whitaker has now answered the question of, did the president discuss the Mueller probe with you? And he said that didn't happen. He hasn't answered this other question, which I sure expect some Democrat will ask. Well, what about SDNY? Because those probes, just like Mueller, are going into the president's orbit. You know, in some ways, the SDNY probe is a little more businessy, financy. The president had said in the past that was kind of a no-fly zone for Mueller, but presumably that would apply to all sorts of prosecutors. So I think lawmakers are likely to want to know, did you, Matt Whitaker, and the president ever talk about this? Did you and other White House officials ever talk about this? How are you keeping SDNY, which sometimes is referred to as the Sovereign District of New York, because they're very proud, they're very independent, even of their own Justice Department bosses. How have you kept them sovereign? You know, how have you kept them away from political influence? I think that's a very ripe line of questioning that we have yet to see.
You know, we already heard frustration from the chairman about executive privilege and whether or not Whitaker will invoke an executive privilege as a hypothetical or something that he actually knows. In other words, I'm not going to talk about that because the president might not want me to speak about it, versus I'm not going to talk about that because the president has said that is executive privilege.
Yeah, it's just a very murky area of law, and cabinet secretaries in the Trump administrations, I remember Jeff Sessions in particularly covering the Justice Department, they will typically go in and say, look, I can't talk about my conversations with the president because it is possible he might invoke executive privilege. It's not sort of their privilege to state, it's the president's. So what would happen if the House really wanted to push this issue is they would say, well, you need to go to the president and see if he is exerting privilege on these particular topics. And if he's not, we need answers. And if you're not willing to give us answers on that, we're going to hit you with the subpoena. That was sort of the whole drama surrounding will Whitaker appear or won't Whitaker appear. So that, you know, but it's a thorny and complicated issue, and the court hasn't given clear guidance on what Whitaker might be able to reasonably say I can't answer and what he could say I will answer. It's just such a murky issue. It usually has worked out just because they negotiate.
So votes are over in the House, and we're seeing some members start to filter back in, so we do expect this to get going soon. I want to get back to this question of the subpoena power that this committee has or doesn't have. We saw the threat yesterday waved out there by the chairman and the Democrats that they could subpoena Matthew Whitaker. That led Matthew Whitaker to say, that threat looming over this hearing, I'm not going to come if that's the way you're going to play. So then they negotiated things last night. When we think of subpoenas, we think of someone like taking the subpoena and like slapping it down in front of you with like the piece of paper being issued with a subpoena. Can you guys talk us through how this actually would work in the case of a committee trying to subpoena a member of the Trump administration?
Well, it has happened before. I think you saw, I forget if it was issued and withdrawn or they just talked about it, but with Rod Rosenstein when Republicans controlled the House. you know, it's not as if they send some process server over there to say produce
Yeah, I'm
these
picturing like a
documents.
bike messenger and somebody showing up at your door with a.
Generally anymore, they put out a press release, and I don't really know what the behind-the-scenes machinations of the particular service to the Attorney General are, but they would say, look, we've subpoenaed him, and they would release the subpoena, and it would say, we want these documents or this testimony by X date. Most of the time you see that negotiated away. Sometimes you don't. They just appear. I can recall Pete Strzok being subpoenaed and him saying, what the heck, I was going to appear anyway. What's the deal with this? Unlike Matt Whitaker, he didn't sort of have the juice to say, I'm not appearing unless you withdraw this. And it has real force, though. It has real force. This isn't just some show. You have to appear or you can be held in contempt, and there can be legal repercussions for this. So it's a real thing. In Whitaker's case, it wasn't one issued yet. It was kind of this strange situation where he just didn't like what he considered the bad faith of it, the axe being hung over his head. But it would have real force if it was issued.
No, there's an interesting distinction between the House and the Senate when it comes to subpoenas. In the Senate, you can only issue, a committee can only issue a subpoena on a vote of the committee, and I forget what the vote count is, but it ends up requiring that it be bipartisan. And so when you see a subpoena from a Senate committee, it's really a very significant action because it means that the two parties have gotten together and agreed to take this compulsory action. In the House, by contrast, I believe the chairman can issue a subpoena on his own. And so it's much more common to see these sort of partisan subpoenas that the other side dramatically disagrees with. Sometimes they even have squabbles about whether or not the other party has been informed that the subpoena is going to be issued. And it's also, from a political standpoint, a lot easier for people to try to fight it because it's a lot easier to sort of say it's a political circus. I'm trying to remember if we know whether or not the Senate Intelligence Committee, as part of its Russia investigation, has issued some subpoenas. I think that they have, but it's rare because it's not easy to do. It requires the two parties to agree.
And in this case, the threat of the subpoena coming today was sort of what was on the table. But just because that seems to have been moved off the table for today, that doesn't today and tomorrow. Thanks, Matt. It does not. That's not a get out of subpoena free card for the rest of even Whitaker's time serving as the acting attorney general.
Yeah, that's right. They have not agreed to sort of take it off the table permanently. It would be hard to envision a world where they would, because then he could go and just not answer any question.
Absolutely.
And they've said, we're never going to subpoena you. I do think they might lose their political appetite to do that once he leaves office, and he might feel more comfortable saying, I'm just not going to do this. But the subpoena has real force. I mean, if they wanted to push the issue, they could issue it, and they could have some executive privilege fight, and we would see where that ended up.
And you saw there Chairman Nadler coming back into the hearing room, followed by Jamie Raskin, another member of the committee. So we'll see this start to reconvene. If you're wondering what all those tables are there on the side, those are the reporters and the journalists who are watching, and then you've got them with their laptops and everything else spread out, and then you've got the public, which we heard Rhonda Colvin tell us. It's been a packed hearing room, a lot of public interest in this hearing today, and it really is a potential harbinger of what's to come over the coming weeks and months as Democrats exercise their control and flex their muscles over on the House side. Is there a danger of House Democrats pushing too far or going too far, quote unquote, in some of either their line of questioning or how aggressive they are at this point? Do you guys see that backfiring at all?
Well, I think that speaks to Roz's point earlier. House Republicans are going to say you aren't legitimately exercising your oversight function. You're just out to get the president.
But
and
does
that's
anyone
not
really
fair.
expect them to bring the acting attorney general, who's only been serving in this capacity, a couple of months, if even, to come in and talk about the opioid crisis or criminal justice reform or anything else at this point, given the giant elephant in the room of the Mueller probe and the president's relationship to it?
Well, no, but this is, of course, kind of a long game, a long argument, right? We saw the president in the State of the Union earlier this week with that very striking line, what was it? You can't have peace and legislation if you have war and investigation.
Yeah. And that the economy will suffer if
right,
there
the
are
economy will suffer,
partisan
that nothing else
investigations.
is going to happen. We'll have war and destruction. And so, you know, I think the president was trying to set that tone that, you know, a kind of Congress on a vendetta to get him is not in the best interests of the country. And I certainly wouldn't expect us to have an understanding of kind of how that's going to politically shake out just today. But I would expect those to be the arguments that are raised by both sides, you know, going forward.
You see some more committee members there heading into the back way. And there is the Acting Attorney General, Matthew Whitaker. We'll see if the tone changes, if the energy in the room changes as everyone takes their seats again. We certainly don't expect the tone to change from Democrats and Republicans. The real question is, will Mr. Whitaker, the Attorney General, have a different tone as he faced questions? As we said, there's just about 40 members of this committee. Most of them haven't had a chance yet to ask anything. So we'll go back to this hearing room live to tune in to see what happens. Thank you so much to Roz Helderman, Matt Zapotosky. We're waiting for the chairman to take his seat, so we'll talk for a moment more. You know, I'm just so curious to hear not just the tone, but if Democrats can sort of chip away at Whitaker's resolve not to say anything of substance, because the way Whitaker was answering questions earlier, it was, I'm not going to answer that. I've said I'm not going to answer, and yet here's my answer.
And he does provide an answer.
Yeah.
I don't think they'll have to like really break through the ice too far to get him to answer. This is a guy who in a press conference, when he had ended it at, I can't really talk about ongoing investigations, kept going. I mean, no one was pressing him, he just did it. So I think the longer he's there, the more they chip. Certainly he might reveal something substantive. To your earlier point, there is a political risk. I mean, think about the House's Benghazi investigation when Republicans controlled. People now see that as synonymous with a waste of government money. So I think there is merit, or political merit, to Republicans saying this is a waste, you know, you guys are just trying to embarrass the president. If you get people to think this is all a political sideshow, it kind of undermines the meaning of real revelations.
And yet you have Democrats who are very eager for answers and are excited to have this opportunity to try to get some. All right, the chairman has re-entered the chamber, the hearing room, so let's go back to this hearing live.
Committee will come to order again. We'll now resume questioning under the 5-minute rule. Ms. Lofgren.
Thank you, Mr. Chairman, and thank you, Mr. Whitaker, for being here today. On January 28th, you made a statement, and I'm trying to understand more about that. You mentioned, and this is a direct quote, right now, referring to the Mueller investigation, right now the investigation is close to being completed. What was the basis for that statement that you made, Mr. Whitaker?
Thank you for that question, Congresswoman. I had a press conference announcing an important indictment related to Huawei and their alleged stealing of intellectual property of an American company. During that course of that press conference, I was asked questions about the special counsel's investigation, and I prefaced that answer by saying I can't talk about an ongoing investigation like the special counsel's investigation. And as I sit here today, I really don't have anything to add to what I said.
Well, it seems to me that you did talk about an ongoing investigation, and therefore you can understand, I'm sure we'd like to know what you meant by what you said. In that same statement, you said, quote, you were, quote, comfortable that the directions that were made will be reviewed through the various means we have, unquote. What does that mean?
Congresswoman, thank you for that question. I would refer you to the special counsel regulations that, again, the question the answer that I gave to the inquiry was regarding the timing of the special counsel's investigation. I have nothing, as I sit here, to add to that, but I do want to mention that the special counsel's regulations, by their very nature, say that the Attorney General will receive a report, that will be a confidential report, and that report will cover the decisions. And so I was talking about, as Attorney General, if as acting Attorney General, if and when I receive that report, again, I only have less than a week, as you know, before Mr. Barr comes on board, that I would review those decisions pursuant to that report.
So is it fair to say that really what you're saying is that the special counsel's investigation is proceeding within the scope of the authorities set forth in Deputy Attorney General Rosenstein's May 2017 order? Is that
Yeah,
essentially
Congresswoman,
what
thank
you're
you
saying?
for an opportunity to clarify that. I think what I just explained to you is that the special counsel's investigation is proceeding consistent with the regulations that outline why the appointment happened, consistent with Mr. Rosenstein's appointment.
All right, thank you very much for that clarification. I'd just like to note that to some extent, it's hard to ignore that the willingness to discuss ongoing investigations has not been applied evenly. I mean, you've just mentioned today the Roger Stone indictment, and that's an ongoing matter. But let me get back to an opportunity you have to clear the air. Many have speculated that your appointment was based on your public appearances that harshly criticized the special counsel's investigation. Prior to your hiring as chief of staff to then Attorney General Jeff Sessions, I'd like to know, did you discuss or share your private opinions of the special counsel investigation with President Trump or other White House officials such as Mr. Kelly or Trump family members or public surrogates like Mr. Giuliani? And I would note that this is not covered by executive privilege because at that time you were a private citizen.
Congresswoman, thank you for that question. I came to Washington, D.C. in October of 2017 to be Attorney General Sessions' Chief of Staff. I have the greatest respect, as you know, for General Sessions, and I am really, honored to carry out the role of acting Attorney
If I
General.
may, that's very nice, but that wasn't the question I asked.
Well, as you know, I am, as I mentioned, honored to serve as acting Attorney General, and I'm honored that the President selected me to be the acting Attorney General. I can assure this committee that before appointing me to this position, the President did not ask for and I did not provide any commitments, promises concerning the special counsel's investigation or any other investigation, as I mentioned in my opening statement.
That's not the question I asked, sir. And I see that my time is about to expire. So, Mr. Chairman, I would like to add, I know that we're going to have a follow-up depositions under oath.
I'll allow
We'll add this.
allow you to
question.
ask the question again more specifically and ask the witness to answer the question specifically and not to continue filibustering.
The question is whether you shared your private opinions of the special counsel investigation with President Trump, other White House officials such as John Kelly, Trump family members, public surrogates such as Rudy Giuliani. At the time that I'm referencing, you were a private citizen before you were hired, so it is not covered by executive privilege. Did you do that?
Congresswoman, just to be clear, you're asking me whether or not I talked with anybody essentially in the President's circle or at the White House about my views of the special counsel's investigation.
Correct.
When I was a private citizen
Correct.
and not at the Department of Justice?
Correct.
No, I did not.
All right.
Thank you. Mr. Chabot.
Thank you, Mr. Chairman. Mr. Acting Attorney General, as you mentioned earlier, there are other important matters within the purview of the Justice Department and within the oversight responsibilities of this committee, besides fishing expeditions trying to get the goods on this president in an apparent effort to impeach him. For example, 70,000 Americans died from drug overdoses in 2017. Now, I'm old enough to remember back in the mid-'80s when President Ronald Reagan and his wife felt so compelled to do something about the scourge of drugs in this country that the effort to just say no began and other efforts following that. And that was because back at that time we had 10,000 deaths a year due to drug overdoses, and we now have over 70,000 deaths. So it's gotten, unfortunately, over time, worse, not better. Most of the increase in deaths in 2017 were due to synthetic drugs, synthetic opioids, specifically like fentanyl, which accounted for a significant number of those deaths. This is clearly an epidemic which has been declared a state of emergency nationwide by the President and has deeply affected families in my home state of Ohio as well as families all across this nation. What efforts and resources has or does the Justice Department intend to use to combat this growing epidemic? And what help can Congress provide to assist you in your efforts?
Congressman, I appreciate that question, and I know how Ohio has been dramatically affected by the opioid crisis. We have done a lot at the Department of Justice, and I would like to partner with this committee, and I'm sure General Barr would as well, to combat and have additional tools to combat this opioid crisis. But some of the things that we have done is we set up in 2017 the Opioid Fraud and Detection Unit, which was a way that the Justice Department could utilize data to help combat the devastating opioid crisis. We did the largest healthcare fraud takedown in June of 2018. We set up the PILL Task Force, otherwise known as the Prescription Interdiction and Litigation Task Force, in February of 2018. We set up a really innovative way called Operation SOS, which was synthetic opioid surge. General Sessions and I went down to Tampa, Florida, where we saw Manatee County had taken an AUSA and embedded them once a week into the sheriff's office in order to take every fentanyl overdose case. And they dramatically reduced the number of overdose deaths in Manatee County, and we decided to take that model and apply it to the most affected states and districts that could really make a dramatic difference in saving lives.
Thank you. Let me just, if I could, let me stop you there. I just have a follow-up question along the same topic. And the President addressed this to a considerable degree in a State of the Union the other night. And do you have an opinion? Is there a relationship between enhancing border security, particularly at our southern border, and making at least some progress in reducing the scourge of drug addiction in this country?
Congressman, absolutely there is a connection between the drugs that are being imported through our southern border, which is a large majority of those drugs, and the opioid crisis we now face. In fact, I went to China in August as Chief of Staff for then General Sessions. He asked me to go to talk to the Chinese about what more they could do to reduce the amount of fentanyl that's being produced in China. And we had a nice dialogue with some high-level government officials. And the President, as you know, has agreed with General Xi to reduce fentanyl and eliminate fentanyl production in China. And one of the ways that China's agreed to do that was by scheduling the analogs of fentanyl. It's a very serious problem, and I know Ohio is dramatically affected by it.
Thank you very much. I've only got about 30 more seconds, so let me just touch on one last thing. I know you've only got a week left, so you probably won't personally...
Less than a week, actually.
Yeah, less than a week. Yesterday, this committee, in a bipartisan manner, passed the No Oil Producing and Exporting Cartels Act of 2019. This is something that I had introduced almost 20 years ago, along with my Democratic colleague, John Conyers, who was chair and ranking member of this committee over the years, that would basically give the Attorney General the authorization to bring suit against oil cartels when they artificially manipulate the prices and we all pay for this at the gas pump time and time again. So I know we've been in contact with the Justice Department, and we look forward to working with your successor in that effort. I don't know if you have any comments you'd like to make about that.
Congressman, I'm fully aware of that bill, and I look forward to the Department of Justice working with you to successfully not only pass it, but implement it.
Thank you, and I'd like to give Mr. Nadler and some of our Democratic colleagues, as well as Mr. Collins and others, a lot of credit for that as well. So thank you very much. Yield back.
I thank the chairman very much. This is extraordinary times, Mr. Attorney General. We know that the former director of the FBI testified to the House Intelligence Committee in an open hearing. The there was an active investigation into the associates of the Trump campaign, and he was fired subsequently. Mr. Mueller was then hired. Investigations have secured numerous indictments, convictions, or guilty pleas, and of course they deal with perjury charges like obstruction of justice, perjury, false statements. So at the current rate, we're seeing so many of the Trump organizations being indicted. And with the short time that I have, I want to make sure that your questions are answered in a yes or no matter. This is the first oversight hearing we have had in the Justice Department in almost 15 months. You did not have a confirmation hearing, and you have not yet appeared for an oversight hearing, yes or no? Yes or no?
Congresswoman, I am the acting
Yes or
Attorney
no?
General.
Have you appeared before an oversight hearing in the Congress?
Congresswoman, I have not.
It has been 10 years.
appeared before.
Witness will answer the question as asked, please.
Mr. Chairman,
Mr. Chairman, if the parliamentary inquiry, if he feels that a yes or no is appropriate, he'll answer in a yes or no. If he does not feel it's appropriate, he should be able to answer in the appropriate, as many Democrat administration officials have done before this committee before. That is unreal.
The member has only 5 minutes, and
If we've just discovered that we have
she
a
wants a
5-minute
yes
rule,
or
that's
no answer,
amazing.
she's entitled to it. I will not allow the witness to stall and waste members' time. The
Where
witness
were
will
you
answer
when
the
Ms.
question.
Lynch and Mr. Holder were
Chairman,
here?
Witness will answer the
Mr.
question.
Chairman, may I have my time restored? I think it was at 4 minutes.
Yes, you may.
Thank you. Again, Mr. Attorney General, the question is, did you have a confirmation hearing, and has it been more than 10 years since you testified before Congress?
Congresswoman,
Can the
it
clock
is-
be restored?
I'm sorry, what was your, I don't know if your time's been restored or not.
Mr. Attorney General, we're not joking here, and your humor is not acceptable. Now, you are here because we have a constitutional duty to ask questions, and the Congress has the right to establish government rules. The rules are that you are here. So I need to ask the question, and I need to have my time restored so that you can behave appropriately. I will behave appropriately as a member of the Judiciary Committee. I'm asked a question. Did you have a confirmation hearing, and have you not yet appeared for an oversight hearing?
Congresswoman, I am an acting Attorney General. I have been appointed according to the Vacancies Reform Act, and I have never appeared in front of Congress for any hearing, even when I was United States Attorney.
I'm asked for a yes or no answer. Is that? Yeah. And so you've never appeared. Let me quickly ask a question. Prior to the firing of former Attorney General Jeff Sessions, did you discuss or share your private opinions of the special counsel investigation with the Chief of Staff, Trump family members, and others? Yes or no?
As I previously answered, Congresswoman.
Yes or no, sir?
As I previously answered, Congresswoman, I have not
Yes
discussed.
or no?
As I previously answered, Congresswoman, I have not discussed.
And since you're appointed acting Attorney General, did you discuss or share your private opinions with the special counsel?
Again, the special counsel's investigation is an ongoing investigation, and I have nothing more to say than what I've already said.
So you are denying reports that you shared many one-on-one calls with President Trump and his then Chief of Staff, John Kelly, when Jeff Sessions was still Attorney General?
Again, Congressman, is there someone that provides you the basis for that question, or is that an anonymously sourced
I am asking
article?
the question, sir. Answer the question, yes or no.
Could you repeat the question, please?
So you are denying the reports that you shared many one-on-one calls with President Trump and then his Chief of Staff, John Kelly? Are you denying that, yes or no?
Congresswoman, as I've mentioned several times today in my opening statement and otherwise,
Yes or no?
I'm not talking about the conversations that I've had with the President of the United States or his senior staff.
So that is a no?
I don't think you can assume anything from that.
Well, let me just pursue on my line of questioning. Since the investigation secured numerous indictments, I would like to pursue the line of questioning with respect to your understanding of the Mueller investigation and the review that you've given. Have you given an extensive review?
Congresswoman, I have been briefed on the special counsel's investigation.
Do you believe the involvement of the hostile foreign entities interfering with the elections is more severe than the false representation of voter fraud in elections? Do you believe that a foreign interference with the elections is more severe?
Congresswoman, I think foreign interference in our election system in the United States is a very serious and ongoing concern. I also believe that voter fraud is a serious concern.
After you left office, you pursued a series of other political offices, one of which was the United States Senate. Yes or no, if during the pursuit of that office, a hostile foreign power contacted you to offer dirt on your opponent, which at the same time included other candidates such as Steve King and now Senator Joni Ernst, would you have contacted the FBI?
Congresswoman, I'm not here to
Yes or
address
no?
hypothetical questions, and I'm here for an oversight hearing. I don't believe, I was very
You have the
unsuccessful in my Senate
responsibility
campaign.
of answering the question. Would you have contacted the FBI if you were asked to take dirt on your opponents?
Congresswoman, if I was contacted by a foreign national or a foreign country when I was a candidate for the United States Senate, I would have most likely reached out to the FBI, but it didn't happen, so it's hard for me to answer your hypothetical.
With respect to civil rights, you have not, under your jurisdiction, prosecuted one voting rights case. Is that correct?
Time of the gentlelady has expired. The witness may answer the question.
Congresswoman, just so I have a complete answer on this, we'll follow up in writing as to the voting rights cases that we've done.
Thank you, Mr. Gohmert. Let's see here. Mr. Jordan.
Thank the chairman. Mr. Whitaker, why did Rod Rosenstein send a memo to Bob Mueller on August 2nd, 2017 concerning the scope of the special counsel investigation?
Congressman, thank you for that question, and I know this is of a great interest to you, and I hope we can have a discussion about this today. The special counsel regulations require a scoping of the special counsel's investigation that identifies the subject and the targets of the investigation. So I am certain that it would have identified the scope of the investigation pursuant to the special counsel's.
Well, my question is not what, I'll get to that. My question is why, because it was 2.5 months after the special counsel was formed. So let's go back to the beginning document, which you told the chairman earlier you're completely briefed on the special counsel's investigation. I want to go, it's just a one-page document. Order number 3915-2017 says this, Mr. Whitaker. The special counsel is authorized to conduct the investigation, including any matters that arose or may arise directly from the investigation. That's pretty broad. Do you agree?
Yeah, and in my experience, it's consistent with other appointments of special counsels.
That's fine. I think it's maybe too broad, but it's as broad as you can get. One-page order, go do your investigation, and anything that arises out of it, you can investigate as well. But then 2.5 months later, we get this 3-page memo from Rod Rosenstein, Acting Attorney General, to Robert Mueller, Special Counsel. Title says, Scope of the Investigation, Definition of Authority. This is what confuses me. Because in this memo, that only Mr. Mueller, and my guess is you and Mr. Rosenstein and a few people at the Justice Department have seen, most of it's blacked out. In this memo, it says this: the following allegations were within the scope of the investigation at the time of your appointment and are within the scope of the order. Well, if that's true, why do you have to say it? If you could do it all along, why do you have to put it in a memo?
Congressman Jordan, first of all, I was, because of General Sessions' recusal from the special counsel's investigation, I was also recused from that investigation. And so I was not.
I'm not asking that. I'm asking, you said you were fully briefed. The chairman asked you that.
You're asking me why at the time Rod Rosenstein.
I'm asking you why 2.5 months after the broadest order you can have, why did Rod Rosenstein say, hey, you could do this all along, but now I'm putting it in a memo? And I'll tell you what really troubles me, Mr. Whitaker, is right after that statement, the following allegations were within the scope of the investigation at the time of your appointment and are within the scope of the order. Right after that, you know what? You know what happens? Everything's redacted. Look at this. The whole darn thing. So if you could do it all along, and you have to send a memo to them 2.5 months later, and then you redact everything after it. You know what's under the redactions, Mr. Whitaker?
I do, sir.
You do. Are there names under the redactions, Mr. Whitaker?
In my experience with investigations generally, You would not have a public document identify targets or subject matter of an investigation, especially if someone is not ultimately charged with a crime.
Let me frame it this way. Did Rod Rosenstein give the special counsel the authority to investigate specific Americans?
Congressman, Mr. Rosenstein, acting as the Attorney General because of Mr. Sessions' recusal, gave authorization and jurisdiction to the special counsel. And so, yes, under the special counsel regulations, that's the whole purpose of the special counsel.
So I want to make, you said yes, so there are specific names 2.5 months into the investigation that Rod Rosenstein gave the special counsel specific American names to go investigate.
Congressman, as
Because
you know,
I mean, if that's the case, then it's, well, I hope you, I want to know yes or no.
as
I hope
you
you
know,
answer.
this is the subject of an ongoing investigation. And I spoke to you generally about investigation.
But I'm asking you a specific, or let me ask it this way. Can you give us assurances that there are not specific names under this 70% redacted memo that, that Rod Rosenstein sent to the special counsel?
Congressman Jordan, I know this is
And you know why I'm
very
asking
important
this,
subject to
Mr.
you.
Attorney General? Because in this country, we don't investigate people, we investigate crimes. And if there are specific American citizens' names in this redacted, and I asked Mr. Rosenstein to see this, and he got all mad and huffy with me in his office and wouldn't show it to me. But I think the American people, if this alters, changes, and names specific Americans, the scope of the investigation of the special counsel, don't you think it's appropriate for the American citizens to know the full parameters of an investigation into the guy they made President of the United States?
Congressman, let me be very specific about this, because you are right. We investigate crimes, not individuals.
And that's why I'm asking the question. I would like a yes or no answer. Are there names mentioned under this redacted portion of this memo?
On that, as I mentioned before, that memo props up a confidential investigation, as is every Department of Justice.
Simple question, Mr. Whitaker. Are there names, specific American names mentioned in this redacted, 70% redacted memo that happens 2.5 months after the special counsel gets his order to start his investigation, where he was given the broadest latitude you can possibly have?
Time of the gentleman has expired. The witness may answer the question.
I would just refer the Congressman to the general practice of the Department of Justice, that we investigate crimes and not individuals.
Mr. Cohen.
Thank you, Mr. Chair. Mr. Attorney General, the Inspector General of the GSA have a rather scathing report on the GSA's decision not to address significant issues concerning the government's post office and its lease to the Trump family concerning the emoluments clause. And it was said that GSA attorneys said they did not refer the matter to OLC, but a senior attorney told the IG that the OLC, Office of Legal Counsel, knew about the old post office lease and it was up to them to do something. Are you aware of anything the Justice Department did to look into violations of emoluments clause at the Trump Hotel?
Congressman, the emoluments clause, as it relates to the Trump Hotel, is the subject of several ongoing litigation matters.
Right.
And so while I can acknowledge that I am aware of the, not only of the situation you described, but generally the litigation surrounding the emoluments clause, as the acting Attorney General sitting here today, I'm unable to talk specifically about those cases.
You can't say if there are any memos from the Office of Legal Counsel regarding emoluments clause violations and limitations?
Congressman, as I sit here today, the emoluments clause, as it relates to the Trump organization, especially the hotel in Washington, D.C., is the subject of ongoing litigation.
And the Justice Department's helping to represent the president in those suits, is he not? Is that appropriate when it's a violation of him making personal monies out of the Trump Hotel and being charged with violations of the emoluments clause by not reporting it to the Congress as he's supposed to by the Constitution? Shouldn't he have his personal lawyers and not Justice Department lawyers represent him for this nefarious conduct?
Congressman, I can understand that this is an important issue to you, but as it relates to the emoluments clause and the Department of Justice defense of the President of the United States, it is well within our purpose to be involved in that case.
You said that if the special counsel's investigation looked into President Trump's finances, it'd be crossing a red line. You said that, I think, in a television interview. The Attorney General has made clear that Mr. Rosenstein told the special counsel he could go into any matters that arose or may arise directly from the investigation. If matters arose from the investigation, directly or indirectly, that the Trump family owed lots of money to Russian oligarchs and people real close to Putin, and that affected the actions that they took as the President of the United States on behalf of the United States of America, would you agree that that was not crossing a red line, but in fact was a red line from Moscow that we need to look into?
Congressman, when I made that statement, I was a private citizen and had no publicly available information. I only had publicly available information. And so I made that as a commentator and not as the Acting Attorney General of the United States. I am very familiar with the responsibilities of my office as Acting Attorney General, and we make our decisions based on the law and the facts on a case-by-case basis.
So that's no longer your opinion? It's not crossing a red line for him to look into the finances if they might have interfered with the objective judgment of the President concerning his duty of trust to the United States of America and not to his personal financial interest or his family's.
Congressman, as I mentioned earlier, at the Department of Justice, and as long as I'm Acting Attorney General, we're going to follow the law and the facts wherever they may lead, and we're going to do our jobs with fidelity.
Thank you, sir. Let me ask you this. There's been a conviction in the special counsel investigation of Mr. Manafort. Jury trial, conviction. There have been guilty pleas from Flynn, Manafort, Gates, Papadopoulos, and Michael Cohen, and dozens of indictments, including 13 Russian nationals, 3 Russian companies, and Roger Stone. Would you say the special counsel's investigation is a witch hunt? Are you overseeing a witch hunt?
Congressman, as I've mentioned previously, the special counsel's investigation is an ongoing investigation, and so I think it would be inappropriate for me to—
But you wouldn't oversee a witch hunt, would you? You'd stop a witch hunt, wouldn't you?
Congressman, it would be inappropriate for me to talk about an ongoing investigation.
You said that you're not interfering with the special counsel's investigation. Have you denied him any funds he's requested at all?
Congressman, I can tell this is an important issue for you, but
it's an important issue for the American public and for the whole world.
Congressman, to answer your question directly, I have not denied any funds to the special counsel's investigation.
Have you denied him the opportunity to go any areas where he wanted to investigate or any matters of investigation?
Congressman, as I previously testified, I have not interfered with the special counsel's investigation.
I yield back the balance of my time.
I thank the gentleman, Mr. Gomert.
Thank you, Mr. Chairman. Acting Attorney General, thank you for being here today.
It's good to see you again, Congressman.
I'm amazed that you would be coming since your successor is going to apparently be confirmed next week, and you'll no longer be acting director, so I don't know what kind of suicide wish you had or whatever, but it's good to see you. One thing I wanted to hit first was a statement that you had made, and I want to confirm that these are your words. And I quote, "There is no doubt in the law enforcement community that the vast majority of the illegal drugs in this country is coming over our southern border, a pattern that is true for all crimes generally, and there is no doubt that criminals and cartels seek to exploit weaknesses in our southern border." Are those your words?
While I don't know which speech or statement you're quoting, it sounds like something I would have said, yes.
Yeah. And you wouldn't have said that if you didn't believe that, correct?
Oh, I believe what you're saying. The drugs and the general illegality that's pouring in through our southern border is having a negative effect on our country.
Now, I want to get to this issue of career officials, since colleagues on the other side of the aisle have made such a big deal about it, that you have not, they accuse you of not following the advice of career officials. Do you know the backgrounds of the people that are working directly under you and directly under Rod Rosenstein?
Congressman, I sit on top of an organization that has 115,000
I'm talking about the people
employees.
directly to you and directly to Deputy Rosenstein.
I am familiar with the people that report to both of us, yes.
Yeah,
although I will tell you, I think Rod Rosenstein as Deputy Attorney General has over 100 direct reports as Deputy Attorney General.
Well, that was something I recommended to Attorney General Sessions, that he needed to reorganize and have some of those people reporting directly to him. But one of the mistakes, I think, my dear friend Jeff Sessions, for whom I have immense respect, one of the mistakes that I saw him making, he was listening to people who loved Sally Yates, loved her efforts to disrupt anything that President Trump tried to do. They loved what President Obama did through the Justice Department. And in fact, I had informed Jeff that that his contact at with the NSC was sitting on his notices, so either developed conflicts or wasn't properly prepared, and that was Tashina Gahar. And she reported directly to Rosenstein. The AG should have somebody, the liaison with the NSC should report directly to the AG and not go through Rod Rosenstein, and especially when they are setting the Attorney General up to be harmed. But this, and then Anthony Ferranti, I know currently, apparently he's the Senior Managing Director of FTI Consulting. He was another one that some considered a career position at the DOJ. Let's see, he had Jordan Kelly there. She's currently Director of Cybersecurity Policy and Incident Response at the NSC through the White House. There were reports that she met routinely with the Mueller investigators. You know, between these people who, like Tashina Gahar, just thought Yates was wonderful, I would hope that wisdom in you as acting director, wisdom in the incoming Attorney General will be to look at the backgrounds, look at the people who are political hacks, and figure out, oh, they're giving me advice on this. This is not for my well-being. This is to hurt the President of the United States. And I know you may just have another week, but I would encourage you that as people make a big deal about career, look beyond career, look where their loyalties are, because even though they may be in a career position, if their loyalties are not to the Attorney General and not to the President of the United States and are more political than they are constitutional, disregard what they say.
Time of the gentleman has expired. Mr. Johnson.
Thank you, General Whitaker. Do you agree with the President's statement that the Russia investigation is a witch hunt?
As I mentioned previously, Congressman, I think it would be inappropriate for me to comment about an ongoing investigation.
Well, you commented about the Roger Stone investigation, which is ongoing, did you not?
Congressman, just to be clear about this.
You did comment on that. I mean, we heard you comment on the Roger Stone investigation. Why would you comment on the Roger Stone investigation, but you are reluctant to answer our questions about the Mueller investigation?
Well, that's a good question, Congressman. And my comments about the Roger Stone investigation were merely to acknowledge that I was aware that CNN had appeared to receive or was at the
You don't know whether or not the
location.
CNN reporter was camped out with no advanced knowledge, or whether or not he was tipped off or not. Isn't that
Congressman,
a fact?
that is true, but I'm very
Right, well, let me move on.
that
Let me move. Hold on, sir. I'm
is
controlling the time. Let me move on. I'd like to take a moment to better understand your decision not to recuse yourself from the supervision of the special counsel's investigation. Isn't it a fact, sir, that you received your final ethics guidance on this matter on December 19th, 2018?
I appreciate this question, and I'm glad this is an
It's a pretty
opportunity for me
direct
to address
question.
this.
Did you receive your final guidance on that question
As
on
you
December
know,
19th?
we have communicated with Congress the entire process that I went through to address any recusal questions that I might have, and I had no conflict of interest. I had
Let
no
me
financial.
just ask you, I understand you take that position, but my simple question is, isn't it a fact that you received your final ethics guidance on that question on December 19th, 2018?
Congressman, we laid out very explicitly the process that we went through, and ultimately the decision whether or not to recuse was my decision,
Mr.
And I made
Whitaker,
that decision,
you were asked a
very
direct,
comfortable with that decision.
Mr. Whitaker, you were asked a direct question, and it's getting a little tiresome hearing you stall and wasting the member's time. The member only has 5 minutes. He asked you a specific question. Did you last receive advice on that on December 18th? The answer ought to be yes or no or some other date, or I don't remember. But we don't need a speech. The gentleman may repeat. No, the gentleman may repeat his question.
Mr. Chairman, I mean, if we're gonna counsel the witness and act as his attorney on how he should answer, are you answering the question or is there a witness answering the question?
I'm
It's a
asking
yes
the
or
witness
no.
not to stall.
And we have endured that many times here when he's trying to answer the
Gentleman-
question in the way that he is asked.
Point of order. The gentleman is out of order. Mr. Johnson has the floor.
And I'd like to
Your
have
time will be restored.
Thank you, sir. Sir, isn't it a fact that career officials at DOJ recommended to you that you recuse yourself to avoid an appearance of a conflict of interest or bias? That was the guidance that you got from career DOJ officials about your participation or oversight of the Mueller investigation. Isn't that correct?
Congressman, I made my recusal decision by myself.
But there
after
were
consulting
career
with
DOJ officials who advised you that you should not touch that investigation. Isn't that correct?
Congressman.
Yes or no?
I consulted with career ethics officials. I consulted with my senior staff. I consulted with the Office of Legal Counsel. It was my decision to make. I decided not to recuse. I'm happy to walk through the step-by-step advice that I received.
There were four individuals who you consulted who advised you that you had the ability to not recuse yourself from this investigation. Isn't that correct?
Congressman, the regulations actually say
Four
that I have the-
individuals advised you that you did not have to recuse yourself. Is that correct?
Congressman, let me be clear. It was
You're
my
not
decision to
being clear,
make,
sir,
and I
other
made
than
the decision.
in your obstruction and refusal to answer
I'm not
my
obstructing
question.
anything. I'm answering your question.
Well, you are
I
obstructing.
consulted with a lot of people regarding my recusal, but it was my
Well, you're
decision.
not telling me who it was. Who
followed
did you
the
consult
regulation.
with?
As I mentioned, I consulted with
Name-
career ethics
name me
officials.
some names.
I consulted with my senior staff, and I consulted with the Office of Legal Counsel.
Name me some names, sir.
Well, one person would be the Assistant Attorney General for
What's
our
his
Office
name?
of Legal
Or her
Counsel.
name?
Steve Engel.
And
He's
who else?
a Senate-confirmed.
Who else did you consult with?
I also consulted with his principal deputy.
And that person's name is?
His name is Curtis Gannon.
And who else did you consult with, sir?
Congressman, I
I'm
don't
asking
think
you
the public
a pretty
exposure
clear
of these
question,
folks-
sir. Who else did you consult with about whether or not you should recuse yourself from the Mueller investigation?
Generally, who did I consult with?
I want to know specifically who you talked to.
Okay, well, I talked to Brad Weinsheimer, who is the senior career official at the Department of Justice.
And he advised you that your recusal was unnecessary, or did he advise you to recuse?
He actually could not identify any precedent for me to recuse. He said it was a close call. He said that, I'm sorry, did you have a question?
Go ahead.
Okay. He said that my other public statements did recognize the professionalism and competence of the special counsel. He said that out of an abundance of caution, that if asked, he would recommend a certain course. But again, he also said.
Did he recognize that
he
you
also
recused
said
yourself?
Time of the gentleman has expired.
Can I finish?
The witness may finish his answer.
Okay. He also said, Congressman, that the decision was mine to make based on the regulations of the Department of Justice, and I made that decision, and I stand by that decision.
Mr. Radcliffe.
Mr. Attorney General, I spent a number of years as a federal prosecutor, and because of that service, I have literally hundreds of friends at the Department of Justice right now and at its component agencies like the FBI, folks that I have tremendous respect for. And so I appreciate your stated desire earlier today to want to highlight their good work. And for the new members of the Judiciary Committee, an oversight hearing is typically where that would take place, where an Attorney General would give an accounting of the work of 115,000 men and women in the Justice Department and provide some idea of the vision with respect to the department's priorities. Priorities like drug and human trafficking, preventing terrorism, reducing gun and gang violence. Now, earlier this week, my colleagues on the other side of the aisle indicated that they had a great desire to reduce gun violence in this country. In fact, we had an 8-hour hearing with 6 witnesses that talked about the need to reduce gun violence in this country. We started this hearing at 9:30 this morning. It's now 12:30 in the afternoon, and I haven't seen you field a single question from the other side of the aisle about any of the enforcement priorities of the Department of Justice. Despite the fact that you are the head of an organization that has a greater ability to impact and reduce gun violence than anyone or anything in the country. So I may be the only person today that wants to ask you a question about that, but I'm going to use the remainder of my time for that purpose. When I was at the Department of Justice, we had a very successful initiative called Project Safe Neighborhood. It was a program that took guns out of the hands of criminal offenders. It was a successful program that was killed by the Obama administration. The Obama Justice Department ended it. I understand that it has been reinstated during the Trump administration. I'd like you to inform us about its progress, as well as any other measures or programs or enforcement priorities of the Department of Justice with respect to reducing gun violence in this country.
Thank you, Congressman. As you know, we served as United States attorneys together until you went into politics and I went into private practice. I want to talk specifically, and it's a really good question, about Project Safe Neighborhoods. In 2017, the Attorney General Sessions announced the expansion of Project Safe Neighborhoods, which encourages U.S. attorneys' offices to work specifically with their unique communities they serve to develop a customized crime reduction strategy. One study showed that when you and I were doing PSN, it reduced crime overall by 4.1%, and with case studies showing reductions up to 42% of violent crime. We had the Project Safe Neighborhoods National Conference, as I mentioned in my opening statement, and I can tell you that, especially in our largest cities, our 29 major cities, we are seeing a reduction of violent crime because of U.S. attorneys specifically working with their sheriffs and police chiefs and their federal and state and local partners in reducing gun violence. Some other things that we've done is the Attorney General was one of the 4 cabinet positions that were part of the School Safety Commission that came out with a report in the last several months that gave a practical outline as to how states especially could work to reduce gun violence, including the idea of the ERPOs. And there is, Congressman, I appreciate your tone that this oversight hearing is not a hearing about the types of things that we're talking about, but Congressman, the chairman sent me a letter specifically outlining things that he wanted to talk about, and I don't feel like we've talked about many of those things. So I'm glad that you offer that opportunity to talk about the Department of Justice efforts reducing gun violence.
Sorry, but not a problem.
Thank you, Attorney General. I'd like to yield the remainder of my time to Congressman Jordan.
I appreciate the gentleman yielding. Mr. Whitaker, are there any other memos? Any other memos that Mr. Rosenstein has sent to Mr. Mueller that we don't know about, and if we did, would be redacted like the one that happened on August 2nd, 2017?
Congressman, as you know, the special counsel's investigation is ongoing, and it would be inappropriate for me to talk about any other memos related to that.
Well, Mr. Whitaker, we already know that there's been some modification of the broadest order I think you could have with this August 2nd, 2017 memo. And all I'm asking is, are there any other modifications, any other changes to the parameters of an investigation into the President of the United States?
Congressman, just to be clear, the special counsel understands the scope of its investigation and is complying with all the regulations and orders related to that.
Thank you, Mr. Chairman. General Whitaker, you and I are both lawyers. My first day of crim law, my professor came in and said, if someone asks you a yes or no question, don't just repeat the question, answer yes or no. Otherwise, during your career, people will think you're not a good lawyer. We know you're a good lawyer. Let's heed that advice going forward. In November 2018, we didn't. The advice is good nonetheless. In November 2018, Chris Wallace asked the president, a question. He said, do you know before you appointed him that he, meaning you, had a record that was so critical of Robert Mueller, and the president said, I didn't know that. I didn't know that he took views on the Mueller investigation. Do you believe President Trump was telling the truth when he said that he just did not know that you were critical of Mueller before your appointment?
Congressman, the president
I am going to
appointed
go
me.
back. Right now, I understand how it all worked. I'm just asking you, do you believe the president was telling the truth when he said he did not know that you had been critical of Robert Mueller before making your appointment?
Congressman, I have no reason to believe when I sit here today that the president wasn't saying what he believed.
Who'd you interview with for the chief of staff job? Not for this job, for the chief of staff job.
It was General Sessions' decision to make. I interviewed with him, and he offered me the job.
And before you got the job, did you ever, before you took this job, did you ever speak with the president about the Mueller probe from May 17th, 2017 to September 22nd, 2017?
Are you saying about before I was actually the chief of staff?
I'm saying between May 17th,
Well,
2017.
Congressman, I had never met the president until after I joined the Department of Justice.
So
in
have
October
you,
2017.
let me just ask you another question. You didn't communicate with him. Did you communicate with anyone at the White House about the special counsel investigation before September 22nd, 2018?
I assume you're excluding my appearances on CNN. Because I don't know who at the White House was watching my
If you
appearances
talked to
on
anybody at the White House, I mean, you've told me that the president wasn't watching those, otherwise he would have been aware of your positions. So I assume the president wasn't watching. Did you talk about those appearances with anyone at the White House?
I did not talk about my appearances on CNN.
Did you talk about your views of the Mueller investigation with anyone at the White House?
I did not talk about my views of the Mueller investigation with any at the White House in this time period, essentially May of 2017, until I joined the Department of Justice in October of 2017.
And when you were, throughout that process, did you ever communicate with anyone? Here's the question. But by my count, you made 6 comments in op-eds, talk radio, or on cable news critical of the special counsel between the time you interviewed in June 2017 and the time you were hired as chief of staff to the Attorney General. Did you ever use any intermediaries? Did you have anyone, since the president didn't know, did you have anyone communicate with the White House or anyone at the White House, either staff members, friends, or others, to let them know exactly where you stood as expressed in at least those 6 public statements?
Congressman, I had at the time you described, May of 17 until I joined the department on October 4th of 2017. I didn't have a relationship with the White House.
Did you talk to any White House personnel before you were hired? Anyone at the White House?
Congressman,
That's an easy one. Did you talk to anyone at the White House? Is the answer no?
Congressman, I had previously been at the White House when I was a private citizen to talk about a different position.
No, I understand, but did you talk to anyone at the White House about your views on Mueller? Any personnel at the White House at all before you assumed the position?
In May,
Let me just go forward, because here's the issue. When you became the Attorney General, since becoming the Attorney General, you said that you've been briefed on the special counsel. Did you use anyone else to have communications? Did you do anything to make sure that the White House might have learned some of what you learned in those briefings? Could it be that someone else on your staff might have spoken to someone at the White House, since you told us you didn't?
Congressman, I'm not aware of that happening.
Who else, how many people were in those briefings with you when you're briefed about the Mueller investigation?
Congressman, I'm not going to go into the specifics of the briefing, but it was a very limited group. There was only one member of my staff who was present with me.
And have you ever attempted to use any intermediaries to get information to the president or others on his staff?
No, I have not attempted to use any intermediaries to get information to the president.
So I'll close, Mr. Chairman, just by saying this is going to be a long hearing. We're going to go on for a while. The concern that we have, Mr. Whitaker, is that there was no Senate confirmation here. We're not the Senate, but the administration justified their decision in picking you under the Vacancies Reform Act. There was a law on the books for the Attorney General's succession, and the authority to oversee the special counsel's work. It goes from one Senate-confirmed official to another, from the AG, Deputy AG, Associate Attorney AG, Solicitor General, Assistant Attorney General, the Attorney General in charge of the Office of Legal Counsel, Assistant AG for National Security, Assistant AG in charge of the Criminal Division, and on and on and on. None of them are the Chief of Staff to the Attorney General. I think what we're trying to figure out is, why is it exactly that the President chose to go beyond the statute and choose you? And I hope over the balance of this hearing that'll become clear. I yield back, Mr. Chairman.
Thank you, Congressman. I believe the President chose me to be the Acting Attorney General for a couple of reasons. First, I had served previously in the department as the United States Attorney, which is a very important position, as Mr. Radcliffe previously stated, and in the administration of justice. And for 13 months, I was the Chief of Staff for Attorney General Sessions, and I had done the full year with him side by side. Obviously, he made the decisions, but I gave him advice and counsel, and I was aware of everything that was going on at the Department of Justice that General Sessions wasn't recused from. And so I think the President was comfortable that to continue the momentum at the Department of Justice that we had established in addressing these important priority issues like reducing violent crime, combating the opioid crisis, and others, that the President felt I was best positioned to do the duties of Attorney General.
Thank you, Mr. Chairman. And I'll just say to Mr. Whitaker, my questions normally in a normal oversight committee would be vastly different than the direction I'm going to go, because we've kind of wandered into this other stream over here. So I'm going to ask you some questions. The longstanding constitutionally based Department of Justice policy holds that a sitting president cannot be indicted. And that's based on the last review which happened during the Clinton administration. Is that still in effect, or has it changed?
That is still the policy of the Department of Justice.
Have you spoken to Deputy Attorney General Rosenstein about his statements on invoking the 25th Amendment and wiretapping President Trump?
I have seen the statements by Deputy Rosenstein that he made to the press regarding those statements, and I have no reason to believe that he did not, that those statements were consistent with what he believed at the time.
Okay, I'm not sure I understood that. You said no reason to believe that they were not consistent, so there are a couple of negatives there. Do you believe they were consistent to what he believed at the time?
I do. I believe what Deputy Attorney General Rosenstein said to the press when it was first reported about his discussion.
Oh, you're talking about his comments, not his comments to the press, not the ones about him wearing a wire.
I'm talking about Deputy Attorney General Rosenstein's comments to the press after it was reported that he had considered wearing a wire and invoking the 25th Amendment.
I didn't mean to interrupt, but his responses then you think are consistent. So did you talk to him about this issue at all?
I'm not here to talk about the internal discussions that I have with the.
But this is really critical. It's not, with all due respect, this is not an ongoing. This has nothing to do with an ongoing investigation. What it has got to do with is Mr. Rosenstein and his role as an unbiased overseer of the Mueller investigation. So it's not directly dealing with the investigation, but deals with his capacity to be unbiased. So I'm not asking whether, I'm not trying to get into the substance or even the periphery. I want to know, though, did you have a conversation with Mr. Rosenstein about his comments as reported?
Congressman, this is an important question to you, but I'm not going to answer my conversations with Deputy Attorney General Rosenstein. I believe that they are deliberative. Obviously, I'm exercising the full responsibilities of the Acting Attorney General position.
I appreciate that. I appreciate it. I know that that answer is important to you. I know that's important to you. But the answering in a way that we as the American people can understand, that's important to us. So let's get to June 21st, 2017, where you said the truth is there was no collusion with the Russians in the Trump campaign. There was interference by the Russians into the election, but there was not collusion with the campaign. That's where the left seems to be combining these two issues. The last thing they want right now is the truth to come out. And the fact that there's not a single piece of evidence that demonstrates that the Trump campaign had any illegal or even improper relationships with the Russians. It's that simple. Do you still adhere to that statement? Is that still true in your mind today?
Congressman, as I mentioned before to previous questioning about my statements as a private citizen before I joined the Department of Justice, those were made based on publicly available information, and I had no inside information. I did not know the details of the investigation. I obviously know the traditions of the Department of Justice, the rules and regulations, and I'm going to continue to follow those as I exercise the duties.
I remember the
Acting
answers
Attorney
that
General.
you gave to other similar questions, but not this question here. And so that's not what I'm asking. What I'm asking is, as we sit here today, a year and a half later, has your opinion changed from what you stated June 21st, 2017? Has it changed? That's a simple question. That's not hard.
Congressman, the special counsel's investigation is an ongoing investigation, and I'm not going to characterize that investigation or give you my opinion of that investigation as I sit here today.
So the scope memo indicates that the scope of the Mueller investigation was any links and/or coordination between the Russian government and individuals associated with the campaign of President Donald Trump, and two, any matters that arose or may arise directly from that investigation. Has that scope been expanded in any way?
Congressman, as I was discussing with Representative Jordan, I am not going to talk about the scope of the special counsel's
All right, then I'll go forward then and say the indictments and the relation to scope one, Papadopoulos for false statements occurring after Mueller was appointed, Manafort for acts unrelated to the election or campaign, Gates, acts unrelated to the election or the campaign, Flynn, false statements about post-election conversations, Richard Pinetto, unrelated to campaign or election, Cohen, referred by Mueller to Southern District of New York because it was out of his scope, Sam Patton, not related to the 2016 election or campaign, and Stone for false statements occurring after Mueller was appointed. Not one indictment alleged an illegal relationship between a member of the Trump campaign and Russia. And that's consistent with what we've seen so far, and with that, thank you, Mr. Chairman.
Thank you, Mr. Chair. Mr. Acting AG, I actually wanted to ask you some questions regarding what you did prior to being Acting AG. It's my understanding that before you moved to the Department of Justice, that you were the Executive Director of the Foundation for Accountability and Civic and Trust.
Mr. Chairman, I have a point of order. Mr. Chairman.
Mr.
Chairman, I have
fact
a
is
point
a
of order.
conservative ethics watchdog
I have a point
where
of
he
order.
made full use of the opportunity to call for
Gentleman will state his
investigations
point.
of multiple Democrats.
The gentleman will state his point of order.
My point of order by the very statement from the gentlelady is outside the scope of an oversight investigative hearing on the Department of Justice.
It is not. You need to
That
let
is
me
not-
finish my question, and you'll see what I was
The
asking.
gentlelady will suspend. That is not a valid point of order. The gentlelady will continue.
Thank you.
Mr. Chairman, I make a point of order, rule pursuant to 10 of the House rules, that the question is outside the scope of.
The gentlelady has the floor.
Mr. Are you just going to overrun a point of order?
Yeah, because your point of
Gentlelady
order
will
is
state my
invalid.
point of order. Are we just
The
gonna-
gentlelady will suspend. I ruled that it was not a valid point of order, and the gentlelady has the floor. The gentlelady will continue.
Thank you.
I was not through with
So
my
you-
point of order.
The gentlelady will continue.
Fill the ruling of the chair.
Move to table.
I move to table.
Motion motion to table the appeal of the ruling of the chair is before the committee. Motion to table is not debatable. The clerk will call the roll. One moment while we set up the clerk. Wait, slow down.
Mr. Chairman, may I make a unanimous consent request while we're waiting for this vote? No. Karen, since when is the bias of a witness not relevant to anything?
I was going to.
Mr. Chairman. Mr. Chairman votes aye. Ms. Lofgren. Ms. Jackson-Lee. Ms. Jackson-Lee votes aye. Mr. Cohen. Mr. Cohen votes aye. Mr. Johnson. Mr. Deutsch. Mr. Deutsch votes aye. Ms. Bass. Ms. Bass votes aye. Mr. Richmond. Mr. Richmond votes aye. Mr. Jeffries. Mr. Jeffries votes aye. Mr. Cicilline. Mr. Cicilline votes aye. Mr. Swalwell. Mr. Swalwell votes aye. Mr. Liu. Mr. Raskin. Mr. Raskin votes aye. Ms. Jayapal. Ms. Demings. Ms. Demings votes aye. Mr. Correa. Mr. Correa votes aye. Ms. Scanlon. Ms. Scanlon votes aye. Ms. Garcia. Ms. Garcia votes aye. Mr. Neguse. Mr. Neguse votes aye. Ms. McBath. Ms. McBath votes aye. Mr. Stanton.
Aye.
Mr. Stanton votes aye. Ms. Dean.
Aye.
Ms. Dean votes aye. Ms. Mucarsel Powell.
Aye.
Ms. Mucarsel Powell votes aye. Ms. Escobar.
Aye.
Ms. Escobar votes aye. Mr. Collins. Mr. Collins votes no. Mr. Sensenbrenner. Mr. Chabot. Mr. Gomert. Mr. Jordan. Mr. Buck. Mr. Ratcliffe. Ms. Roby. Ms. Roby votes nay. Mr. Gates. Mr. Johnson. Mr. Biggs. Mr. Biggs votes no. Mr. McClintock. Mr. McClintock votes no. Ms. Lesko. Ms. Lesko votes no. Mr. Reschenthaler. Mr. Reschenthaler votes no. Mr. Klein. Mr. Klein votes no. Mr. Armstrong. Mr. Armstrong votes no. Mr. Stubbe.
Is there any member of the committee who hasn't voted who wishes to vote? Ms. Lofgren.
Ms. Lofgren? Aye. Ms. Lofgren votes aye.
Is there any other member who hasn't voted who wishes to vote? The clerk will report.
Mr. Chairman, the ayes are 21, the noes are 8.
In that case, the motion to table is adopted. We return to Ms. Bass.
Thank you, Mr. Chair. Mr. Whitaker, during the time that you were the executive director of the Foundation for Accountability and Civic Trust, you recommended that facts called for ethics investigations into or filed complaints about the following Democratic politicians, officials, and organizations: the Democratic National Committee, Hillary Clinton, John Kerry, Speaker Pelosi, Representative Ami Bera, Huffman, Lewis. In fact, the organization actually called for an investigation into a member of this committee, Representative Hank Johnson. So that's a total of about 46 individuals or organizations that over the time period when you were the executive director of FACT, that you called for either ethics investigations or filed complaints. So since you have joined the AG's office, I want to know whether or not any investigations have been initiated into those people. Well, just answer that, yes or no. Have there been investigations initiated into the people that you suggested be investigated during the time you were the ED of FACT?
Congresswoman, I was the executive director of the Foundation for Accountability and Civic Trust. We were an independent, nonpartisan ethics watchdog group. We did file ethics complaints against members of both parties.
You filed ethics complaints against Republicans. Can you tell me which Republicans you filed ethics complaints against?
Again, I'm here for an oversight hearing.
Yes, you are. And so my questions are leading to that. So can you answer that? Which Republicans did you file investigation or ask for ethics investigations of?
The nice thing about being an ethics watchdog group is that FACT filed all of its complaints on its website, and I would refer you to that.
I don't have time to look into the website. I'm asking you a question now. You were the executive director. Which Republicans did you file?
Congresswoman, again, as I sit here today, all I can do is refer you to the website.
Okay, so let me just ask this. Since you have been in the DOJ, have any complaints been initiated against the 46 Democrats, either individuals or organizations, in the time that you've been the acting AG?
Congresswoman, as I sit here today, I am not aware of any, but obviously if I had recommended as the executive director of FACT that someone be investigated, I would, and my recommendation was adopted by the Department of Justice, I'm certain that I could not be involved in that investigation.
You're certain, but you don't know whether did you recuse yourself?
You know, recusal decisions, I think this is important for everyone to understand, is recusal decisions are made based on a matter.
Let me move on. I wanted to ask questions about ethics guidance that you received in December. Did they recommend that you recuse yourself from any involvement in the criminal investigation into the World Patent Marketing, the fraudulent patent promotion scam to which you still owe almost $10,000 to the court? Did they provide an ethics opinion, or did you not seek one related to the World Patent Marketing matter?
Just to be clear, Congresswoman, who do you mean by they? Do you mean the ethics officials?
I'm asking you, what guidance did they recommend that you recuse yourself? So that's a question to you. Did they recommend that you recuse yourself from any involvement in the criminal investigation into the World Patent Marketing?
I am recused from the investigation into that company.
What about any matter involving Hillary Clinton? It's been well documented of your public calls for renewed investigations into matters related to Mrs. Clinton.
Again, any investigations into former Secretary Clinton, if they're open, confirmation or denial of a recusal would suggest that there is or is not an investigation regarding
You know, I actually
that person.
believe I have more time on the clock since I was interrupted.
I'm informed we paused the time.
Okay. Go ahead. Continue.
What I'm saying is your inquiry about whether or not I'm recused from any matter concerning former Secretary Clinton would by its very nature, suggest that there is an open matter regarding Secretary Clinton. Any recusal decision that I would make would be based on what the matter was, and we'd go through the exact same analysis that I went through in the case of the special counsel's investigation.
Thank you.
At the request of a number of people, the committee will stand in recess for 5 minutes.
I get 5 minutes for lunch? Oh.
Brief pause in this hearing as the House Judiciary Committee continues to question the acting Attorney General, Matthew Whitaker. We're partway through their You're watching live coverage from the Washington Post as the acting Attorney General Matthew Whitaker takes questions from the House Judiciary Committee. A lot, Democrats especially, are trying to pack in their brief 5 minutes to question the acting Attorney General. This should be a short break, despite Matthew Whitaker's concerns that he'd only have about 5 minutes for lunch. He just had about an hour-plus recess as the House went to vote, so we'll see how long they pause. I'm Libby Casey, and I'm with Aaron Blake here, senior political reporter and writer for The Fix. Aaron, I'm sensing frustration from Democrats. They start a line of questioning Matthew Whitaker. They've accused him of filibustering or sort of deflecting a question, and then they're having a hard time hitting their punch, right? Actually landing the punch to get to the point they're trying to make.
It's always difficult when you only have 5 minutes. These hearings are even more difficult than you would see in a Senate confirmation hearing because there are so many more members and they really need to get to everybody. There are 40 members here as opposed to, 15 or 20 in the Senate hearing. And so Matthew Whitaker knows that. He has clearly been coached on that fact. And so there was a moment, I think it was about an hour ago, where he began starting his responses. It was shortly after he came back from that first break, and he started answering these questions by starting out and saying, Congressman, thank you very much for that important question. Thank you for this chance to clarify. He did that 5 times in a span of 6 questions at one point. He clearly is trying to give himself some time, 1, to think, 2, to fill up some time so that these members can't get momentum behind their lines of questioning. And actually, I think he has frustrated them to some degree. The more that you can prevent them from asking, 15 questions as opposed to 5, the less likely they are to actually get to the point that they want to get to. And so it's certainly been a shaky performance from Matthew Whitaker, but at the same time, he seems to have avoided revealing anything that he doesn't want to, and a lot of that is because he does seem to be, in a lot of ways, ignoring the questions, deflecting them, arguing over process, things like that.
And running out the clock. We saw Hank Johnson, Democrat of Georgia, trying to ask him some direct questions about getting advice on whether to recuse himself from the Mueller investigation. And Whitaker was deflecting and going into some other longer explanations. And it frustrated Johnson, and it frustrated the chairman, Jerry Nadler, who basically said you don't have to give a speech, and answer the questions.
Well, and a lot of the questions were extremely simple questions. They were date and time questions. Was the last time that you consulted ethics officials on December 19th? That's
yes or no.
There are reasons for witnesses to avoid yes and no questions. A lot of times those questions will be posed in very leading ways that you don't want to commit to a firm yes or a firm no. But when you're talking about date and time, there are established facts here. If you can either say yes or no rather easily, and so the fact that Whitaker was avoiding even on those kinds of questions, I think kind of shows exactly what he's up to here.
Now, this is nothing new. We've seen Democrats in the minority frustrated as they ask questions, Republicans in the majority in other scenarios frustrated when they ask questions. But one challenge of these hearings is it's hard to get a rhythm going because it does go Republican, Democrat, Republican, Democrat. So you could see that Democrats would like to carry on a string of perhaps a prior line of questioning, but it's hard to keep that rhythm and momentum going. One thing that they have been able to try to get a little bit more detail on is just who Whitaker went to figure out this question of recusal. We know that Department of Justice ethics officials advised him to recuse himself. He chose not to. And one question we expected today was Democrats to find out who else was advising him, who specifically was advising him. We did hear a couple of names listed, but then Whitaker sort of deferred on the rest and said that he was concerned about their public exposure.
Yeah, so he named 2 people. The first one was Steve Engel. The second one was Curtis Gannon, whose exact job titles I'm not going to claim to know offhand right now.
And then one is like a principal deputy.
Yeah,
and,
so he resisted at first. He tried to just say senior staff. He tried to say, I consulted with several people, and Hank Johnson said, no, name some names here. And so he named those first 2 names, and then he resisted, and he said he's worried about public exposure. Then he named one more person, which was Brad Weinsheimer. These are all Senate-confirmed political appointees. These are not low-level staff members who the American people have never heard of. These are people who are accountable to the very committees that he's talking to right now. So I thought it was pretty remarkable that he was trying to protect them from getting dragged in here, given they do serve at the president's pleasure. They do serve with the confirmation and the approval of the Senate. So
yeah, that seemed like a dubious excuse. And then as they were getting into this question of just what advice did they give him, that was also a little bit unclear.
Yeah, he said, he emphasized over and over again that these officials had told him that it was ultimately his decision. That's focusing, that's being very narrow in your focus. Of course they would have told him that because that is in fact how things work. If you are the Attorney General, final recusal decisions are made by you. But that wasn't really the question. The question was, what was their advice to him? And we know from reporting that the career ethics officials, at least, who consulted him on this, said that it was a close call, but did say that this is something that they would recommend that he had recuse himself on.
The way that Whitaker talked about it, I believe this was related to Brad Weinsheimer specifically, although there were a lot of, those three names were thrown out there. That it was a close call, as you point out. We've already reported that, and we knew that. And that public statements Whitaker had made did acknowledge or recognize the professionalism and competence of the special counsel. But then Whitaker started to say, out of abundance of caution, he would recommend a certain course. And then it sort of got talked over, and we never heard what was that the certain course would be, the implication being that it was probably to recuse yourself.
Right.
But the decision ultimately ended with Whitaker.
It was it was remarkable that he didn't seem to want to acknowledge things that had been in the public record, that had been reported very widely, because he feels like it's almost conceding a point and leading to a larger discussion about recusal that he clearly doesn't want. That's why he keeps going back to the idea that this is not a confirmation hearing, this is an oversight hearing, this should be about the things that the Department of Justice is doing right now, which that's generally what this kind of hearing is supposed to be about, but they also have an official who has never been confirmed and is in a very important position. And I would add, by the way, a lot of the questions about the Mueller investigation, those are oversight questions. He oversees the Mueller investigation. So when he, right after that second round of questioning, came out and said, this is a confirmation hearing, Bill Barr is going to be here next week, this should be an oversight hearing, that kind of rang hollow for me a little bit, because the questions that he had been asked to that point were in fact about oversight of the Mueller probe, which is maybe his most important job right now.
Let's go to our colleague Rhonda Colvin, who's live on Capitol Hill. Rhonda. Fixed. There is a line that Republicans are trying to push, that this is not the venue to be grilling the acting attorney general over the Mueller investigation. We've heard Whitaker say it as well. This is an oversight hearing. I'm glad, Aaron, that you point out that the Mueller probe is part of what oversight involves. But we have heard Republicans trying to pivot to other programs, other issues, whether it's drug problems or Project Safe Neighborhoods. And then it goes back to the Democrats, and they try to pick up the thread largely of the Mueller investigation.
Right, and that's exactly what Matthew Whitaker and the administration would want those Republicans to do. These are the things that they'd like to talk about. They want to kind of, these are very important things. These are things that in a normal oversight hearing with a confirmed attorney general probably would be the focus. We saw last week the intelligence chiefs came up to the Capitol, and they were generally asked very substantive questions about what their departments were up to. But the backdrop of this is you just can't ignore it. They have been waiting to talk to this guy. They have not had a chance to confirm him. He's in a position of very great power. And so they're going to take the chance to ask him the questions that they want to, because it is their prerogative as members of this committee. They have an oversight responsibility, but that's pretty broadly defined. They don't have to keep their questions narrowly defined on one thing or another.
Let's check back in with Rhonda Colvin, live on Capitol Hill. Hi, Rhonda.
Hi, Libby, that's right. I'm still outside of the hearing room. I was inside during that exchange with Representative Sheila Jackson Lee, and moments after that exchange, that tense exchange that you all might have seen, she came out, she spoke to us, and she said, I asked her, did you expect that? And she said, no, she didn't. She came in here optimistic that he would answer questions, that he wouldn't challenge the committee, because they have been forthcoming with him on what type of questioning that they intended to ask today, and they have not been receiving that same respect from him. So she said she hopes that, the duration of this, we will see more answers from him, but she said she is disappointed in how he answered her. She admonished him, if you all saw that scene, when he would not answer one of her questions. So I hope we will have that footage shortly to show you our interview with her. But as it stands now, she said, as a member of this committee, they still have the right to go after him, and if he's not answering specific questions, and get him to answer those questions. So that's probably what stood out to me in this last part of the hearing. Libby?
Thanks, Rhonda. That's right. Congresswoman Sheila Jackson Lee telling Whitaker that she was not here for a sense of humor. Some pretty firm words there.
Yeah,
She was not pleased.
When I saw that, basically, to recap what happened, there was a point of order raised by the Republicans. Sheila Jackson Lee asked for her time back. Then she asked the chairman how much time she had left, and Matthew Whitaker kind of volunteered that he didn't know how much time she had left. It wasn't clear to me that he was trying to make a joke about it or something. Maybe he was being a little bit smart about it. But from that point on, she was focused like a laser on him. She kind of pointed at him, and I thought it was a really tense exchange. Another really interesting one was, I think around that same point, Congressman Steve Cohen from Tennessee asked Matthew Whitaker the question that gets asked of all these Trump officials that come up on the Hill who have some relationship to the Mueller probe. He said, "Is this a witch hunt? Are you overseeing a witch hunt?" Matthew Whitaker would not answer that question. He said that that was under the purview of answering questions about an ongoing investigation. Well, I look back, people who have answered this question and said it's not a witch hunt include Rod Rosenstein, who oversees this as the Deputy Attorney General, and FBI Director Chris Wray, who is also, of course, involved in this to some degree. So the fact that those two are willing to say, no, not a witch hunt, and then we see Matthew Whitaker come up here and not be able to answer that question, I think is pretty telling that he doesn't want to depart too much from President Trump's talking points on this. Oh, and by the way, Bill Barr also said in his confirmation hearings, this is not a witch hunt.
Not a witch
He's
hunt.
not related to the investigation right now, but you know, the fact that all these people are willing to say that and he is not is pretty remarkable, I think.
Yeah, but as we pointed out earlier, he is keeping his options open in terms of it may not be in his best interest to be pinned down on that because he's not looking at a career in this position. He's thinking about what role he might play next, be it in the Trump administration, be it as a TV commentator.
Yeah.
You know, who knows what comes next? So
I would
he's keeping in
argue-
mind his own future.
Yeah, I would argue, certainly that's got to factor in for anybody in this position. They want to look out for the next job that they might be able to get. But this is a pretty low bar that we're talking about. The idea that the Justice Department is not engaged in a vast, basically conspiracy to take down the President of the United States.
And he is the head of the Justice Department. He is not an outsider looking in and criticizing it. These are the men and women who work for him.
Right.
Now.
He could very easily answer that question without getting into any details of the investigation. I can't imagine that he was not prepped that he would be asked that question at some point, and the fact that he decided not to answer it, I think, says it all.
We see the chairman has resumed his seat, so we'll keep an eye on this hearing and go back to it as it continues. I do want to point out questions by Congresswoman Lofgren, Democrat of California. She was asking, you know, as we expected to come up, about conversations that he may have had with members of Team Trump as a private citizen. So before he was the acting attorney general. There's also this question of conversations he may have had as the chief of staff of Jeff Sessions, which is a little bit of a grayer area. But she wanted to know about conversations they may have had about the Mueller probe or other things like that. And we still did not, it took us a long time to get at any sort of answer to even that question.
Yeah, his strategy seems to be kind of get the question, you know, argue over the process of the question and then eventually give some sort of an answer. And usually he actually gets around to offering some sort of an answer. But that one I was still kind of fuzzy on, and I wouldn't be surprised if we see Democrats come back on that question. Because he also recused himself as Sessions as chief of staff. He was recused from Russia when he was chief of staff, so he would have no reason to talk about it with the president.
All right, I'm giving Aaron the wrap sign as we go back to the hearing. Thank you so much, Aaron Blake.
Thank you, Mr. Chairman. Mr. Whitaker, I'm sure you'd agree that the appearance of favoritism or partisanship by law enforcement agencies is absolutely deadly to a nation that's founded upon the principle of equal justice under law. If law enforcement agencies are perceived to be biased or partisan, I think faith in them can, and in our system of justice, can quickly collapse. And I am concerned about many alarming developments in the conduct of the FBI and the Department of Justice that call its impartiality into question. I've been reading Greg Jarrett's book on the Comey investigation into the Clinton emails and the Uranium One deal, and the Mueller investigation into the Trump campaign. And in it, Mr. Jarrett meticulously documents case after case of political bias by the FBI, of illegal conduct at the highest levels of the Department of Justice, destruction of evidence, possible obstruction of justice by Mr. Comey himself, perjury by top DOJ officials, prosecutorial misconduct and political bias throughout Mueller's team. Now, if the Russia investigation was initiated because of a patently false dossier, why aren't we seeing an equally aggressive investigation into these very meticulously documented charges?
Congressman, as you mentioned at the beginning, we do conduct our investigations independent of political interference at the Department of Justice.
That's not what
Let me finish.
the preponderance of evidence is telling me from sources such as this one.
Well, and specifically related to the document you just described, that is the subject of an Inspector General's review, investigation, together with the U.S. Attorney from the District of Utah that was appointed by General Sessions to look into and review certain matters that this committee had asked be reviewed.
Can we expect a full, complete, and aggressive investigation of charges of wrongdoing by officials in the FBI and the Department of Justice on these matters?
Congressman, I can assure you that any allegation of misconduct by an employee of the Department of Justice will be looked into thoroughly.
Well, I think back to the Lois Lerner scandal, and that never was addressed. Why should I be more confident in your assurances now?
Congressman, I was a private citizen when the Lois Lerner situation occurred. In fact, it occurred mostly under the previous administration. I know that General Sessions did a review of that matter before I was Chief of Staff, so I really don't have any visibility as I sit here today as Acting Attorney General as to what happened in that situation.
Let me talk about the apparent double standard and disproportionate show of force in cases like the arrest of Roger Stone. As I understand it, Stone's attorneys were in constant contact with the Department of Justice. He's 66 years old, doesn't own any firearms, and yet he was the subject of a pre-dawn raid by 29 combat armed officers. As Mr. Jordan has pointed out, CNN was obviously tipped off to have cameras there. And in fact, they arrived to set up before the raid began. They were allowed to stay to film the entire spectacle, despite the fact the public was kept out, ostensibly because the FBI was so concerned of violence by the 66-year-old unarmed man in this pre-dawn raid. You compare that to cases like Bob Menendez, who was allowed to quietly turn himself in. The obvious explanation is that this was a political act whose purpose was to terrify anyone thinking of working in the Trump campaign in the future. And again, it harkens back to the conduct of the IRS, terrifying rank-and-file Tea Party members with tax audits because of their political views. How do you explain this, and what are you doing about it?
Congressman, this is a very serious situation that you raised, but just know that the FBI makes arrests in a manner most likely to ensure the safety of its agents and of the person being arrested. The FBI must also consider the safety of the surrounding.
And how do you explain the discrepancy between the way Roger Stone was treated and the way Bob Menendez was treated?
Again, the arrest team has to consider numerous factors in making the judgment as to how to conduct the operation.
Do you at least understand the appearance of impropriety that projects to the country and undermines the faith that the American people have in their justice system and in its detachment from politics?
Congressman, I cannot provide the details in this open hearing without revealing what factors the FBI considers in those decisions, and obviously that information could be used to put other FBI agents conducting other operations in harm's way. What I can assure you, Congressman, is that the FBI is prepared to brief this matter on the decisions that were made in that particular arrest in a closed session of this committee.
Thank you, Mr. Chairman. Mr. Whitaker, the DOJ was created in 1957 under the Civil Rights Act, correct?
Congressman,
Well,
I believe
it
President
was.
Grant signed the Department of Justice.
No. It was. We're just not going to do all this delay stuff. It was. And it was created to protect against discrimination based on race, color, sex, disability, religion, familial status, and national origin. Wouldn't you agree?
Oh, you're talking about the Civil Rights Division specifically?
No, DOJ.
The Department of Justice was set up to...
What? You know what? Never mind. Let's keep going. You were Chief of Staff when Jeff Sessions testified in this committee in 2017, correct? November.
I was, and in fact, I sat right behind him.
Right. That's exactly where I'm going.
because do you remember me asking him a question about diversity in leadership at DOJ and the fact that they had no African Americans in leadership at DOJ? Do you have any African Americans at the top leadership in the Department of Justice?
If the Senate confirms my friend Don Washington to be head of the U.S. Marshals, which I believe he is pending on the floor of the Senate currently, then the answer to that question would be yes. But as we sit here today, I do not believe. But what do you consider the leadership of the Department of Justice?
The hierarchy with people responding to them, head of a division, deputy attorney generals. If you look at the flow chart, the upper echelon. So think about the image to me. DOJ created to protect civil rights and advocate for all. We've had the last two attorney generals come here. Not one of them thought they could find or did find an African American at DOJ to bring with them. And you're charged with enforcing civil rights and making people feel that you're fighting for equality. You mentioned Charlottesville and charging the person with 30 counts, and I applaud you for that. Do you believe that in Charlottesville there were good people on both sides?
Congressman, I think the act, while it's part, again, a part of an ongoing prosecution, I can tell you,
let me just say this.
The act was charged as a hate crime.
I agree with you, and I applaud you.
Act.
I applaud you for that. But that's the one individual. I'm asking you in general, do you believe that there were good people that were protesting and there were good people that were anti-protesters? So I'm talking about the people marching with lights, the tiki torches and the chants. Do you think that some of them were good people is the short question.
Congressman, there is no place in a civil society for hate, for white supremacy, or for white nationalism.
Thank you. Also, out of the 115,000 employees that you have at DOJ, are any of them transgender?
Congressman, as I sit here today, I don't know the answer to that question. I can imagine that generally, based on the way the population is distributed, that we would. I would also be happy to get back to you to that answer if those people identify that way.
Would you have a problem with a transgender person being from a clerk to an agent in the field for any of your law enforcement agencies?
No.
Thank you. You mentioned also that voter fraud is of a serious concern. How many voter fraud cases have you all initiated?
Congressman, as I mentioned in previous questioning, I'm happy to get those specific details back to you. As I sit here today, I don't know off the top of my head.
Is it a lot? Is it a few? I mean, if we're talking about a serious concern in the United States of America, I would think we're talking over 100, or we're talking less than 25. But if you don't know a ballpark, I'm fine with that. What about North Carolina? Because that is the only congressional seat that has not been determined because of widespread voter suppression in that race. Is the DOJ, have they opened an investigation in that? And if they have, I guess you can't talk about it.
Congressman,
are you looking at that?
While I can't talk about open investigations, and I appreciate your acknowledging that there might be open investigations, I am very aware of what is happening in North Carolina. We have previously done voting rights cases in North Carolina, and we're watching that situation very carefully.
Well, I don't want to go over my time, and I guess in the last 12 seconds, I will just implore you to implore, which will now be the third Attorney General during this term, that after 2 years, we should be doing better with diversity in the Department of Justice, and I'm talking more specifically black and brown people and women. I applaud you for having one woman with you, but the DOJ should look like the country. And you all have been here twice, and it is not a fair representation of what makes this country great. With that, I yield back the balance of my time.
Thank the gentleman. Mr. Klein. Oh, I'm sorry. Ms. Lesko.
Thank you. You know, I have to say that I'm very disappointed in this hearing. You know, I ran for Congress to get things done. And At the beginning of this, you know, we were told that this is about asking about DOJ oversight and some legitimate questions. And here we are, it's nothing but character assassination, harassment of our witness, and it's really disappointing. At first I was mad, I have to tell you. When this thing started hours ago, I went outside and a reporter asked me, "What do you think of the hearing?" And I said, "It's a joke." But now I'm just sad. I'm sad because we were on the floor just a little while ago talking about how we were honoring our late Representative Dingell and talking about bipartisanship and how we need to get things done. And yet here we are with a blatant political show that doesn't help anything. I imagine if American people are watching this right now, they'd be shaking their heads. Like, what are you doing there? We need to work together to get things done. And so that's my statement, but I do have a question for Mr. Whitaker about DOJ oversight. Following the New York Governor Cuomo's support of abortion up to the moment of birth, and Governor Northam of Virginia's comments indicating support of an action which, in my opinion, relates to infanticide, are you concerned about some of these actions of late that implicate the Federal Partial Birth Abortion Act that criminalizes gruesome procedures? I mean, I'm getting really concerned that this is violating the law, and has DOJ looked into this?
Yes, as an American citizen, I am very concerned.
And can you also tell me, I read recently a Wall Street Journal opinion piece. It was from 2018, and in that it said in New York City, thousands of more black babies are aborted than born alive each year, and my grandkids are African American. And so, you know, if there was a crime occurring in this country that exceeded the number of deaths from cancer, heart disease, AIDS, accidents combined, which abortions do, is that something that the DOJ would get involved in and be concerned about and try to stop?
Congresswoman, every life is valuable. And while I can't wade into the political issue that you raise, the members of this committee have a lot of power as to how we value life and how we enforce the laws at the Department of Justice. And this is an issue that I know there is a lot of passion about, and I appreciate your passion, and it's something that we actually share together. And if you look at my statements previous to joining the Department of Justice, especially during the 2014 campaign for the United States Senate, I was very outspoken in this regard. But it's as I sit here as Acting Attorney General, I think it would be inappropriate for me to comment more fulsomely on this issue, but we're going to enforce the laws that Congress passes, and we're going to hold those accountable that violate the law.
Thank you. I yield back my time.
Thank you, Mr. Jeffries.
Mr. Whitaker, thank you for your presence here today. This hearing is important because there are many Americans throughout the country who are confused. I'm confused. I really am. We're all trying to figure out, who are you, where did you come from, and how the heck did you become the head of the Department of Justice? So hopefully you can help me work through this confusion.
All right, well, I mean, Congressman,
Mr. Whitaker, that was a statement, not a question.
Okay.
I assume you know the difference. The investigation into possible Trump-Russia collusion in the 2016 election has resulted in 37 indictments. Is that correct?
I believe that number is correct, but most of those folks were Russian citizens.
34 individuals have been indicted, true?
While I haven't counted those as I prepared for my hearing preparation, I believe those are consistent with the numbers that as I know them.
3 corporate entities have been indicted, correct?
I believe so, correct.
The investigation has identified 199 different criminal acts, true?
I haven't counted every indictment, but that sounds consistent with what I understand.
There have been 7 guilty pleas, correct?
Yes, there have been 7 guilty pleas.
4 people have already been sentenced to prison, true?
I believe so, but again, I do not have this information in front of me. So to the extent that, I disagree with you, it's because these are facts.
Understood, thank you. Trump's best friend, Roger Stone, was recently indicted for lying to Congress in connection with his possible involvement with WikiLeaks and Russian interference with the 2016 election, correct?
Yes, and I mentioned Mr. Stone's indictment and arrest.
Trump's campaign chairman, Paul Manafort, pled guilty to conspiracy to defraud the United States, true?
Mr. Manafort did plead guilty, yes.
Trump's deputy campaign manager, Rick Gates, has pled guilty to lying to the FBI, correct?
While I don't have the indictment in front of me, I have no reason to disagree with you.
Trump's former national security advisor, Michael Flynn, has pled guilty to lying to the FBI, correct?
That is a true fact, yes.
Trump's longtime personal attorney and consigliere, Michael Cohen, pled guilty to lying to Congress about the Trump real estate organization's Moscow project. Is that true?
I believe that was one of the bases for his plea agreement. There were several other reasons that Mr. Cohen pled guilty.
Trump's campaign foreign policy advisor, George Papadopoulos, has pled guilty to lying to federal investigators about his contacts with Russian agents during the 2016 campaign, true?
While I'm sure there are many that would disagree with that title that you put on Mr. Papadopoulos, it is true that he has pled guilty, yes.
So despite all of the evidence of criminal wrongdoing that has been uncovered, do you still believe that the Mueller investigation is a lynch mob?
Congressman, can you tell me specifically where I said that?
I'd be happy to. So in a tweet that you issued on August 6th of 2017, you made reference to a note to Trump's lawyer, do not cooperate with Mueller's lynch mob. You recall that?
I recall that I said that I retweeted an article that was titled that. I did not necessarily agree with that position, but my point was that it was an interesting read for those that want to understand the situation.
Okay, reclaiming my time. Manafort, Gates, Flynn, Cohen, Papadopoulos, and Stone are all in deep trouble. One by one, all of the president's men are going down in flames. It's often said where there's smoke, there's fire. There's a lot of smoke emanating from 1600 Pennsylvania Avenue right now. Yet, you decided not to recuse yourself, is that right?
Congressman, the decision to recuse was my decision to make. I looked at all of the information. I consulted with many people that I've discussed today, and I determined that it was not necessary for me to recuse.
And Donald Trump considered the Sessions recusal to be a betrayal, is that right?
Congressman, I have no idea as I sit here today what the president believed about General Sessions' recusal.
Okay, so let's be clear. The investigation into Russia's attack on our democracy is not a witch hunt, it's not a fishing expedition, it's not a hoax, it's not a lynch mob, it's a national security imperative. The fact that people suggest otherwise comes dangerously close to providing aid and comfort to the enemy. In your final week, keep your hands off the Mueller investigation. I yield back.
I thank the gentleman. I now recognize the gentleman from Virginia, Mr. Klein.
Thank you, Mr. Chairman. Thank you, Mr. Acting Attorney General. I was hopeful that we would get into some oversight over the array of areas of the Department of Justice that are so critical and so important to addressing the problems that are facing my community: drugs, crime. All of these issues are of top concern to my constituents. And one of the most important things that I hear about when I get back to my district is, are you going to keep the government operating? Can you reach an agreement on immigration issues? So when we talk about immigration, I can ask you a couple of questions that would probably help get to an immigration agreement. The backlog of pending cases in immigration courts nationwide have been growing exponentially since 2008, from fewer than 200,000 cases in 2008 to more than 800,000. And Border Patrol is currently apprehending almost 50,000 aliens each month, a certain percentage of which ends up in that same pending case backlog. And in the face of this backlog, what steps is DOJ taking to ensure that its immigration judges can efficiently and effectively adjudicate cases and reduce this backlog of pending cases in a fair and efficient manner?
Thank you, Congressman. This is an important issue to the Department of Justice, and our immigration judges work hard every day to adjudicate those cases. But quite frankly, the number of immigration judges we have been overwhelmed by the number of asylum seekers. Over 80% and really over 90% of those that are encountered at the border and detained and arrested claim some form of asylum. Ultimately, that causes those folks to be put into the immigration court system and then requires that a hearing be held by an immigration judge. And meanwhile, most of these folks, those 800,000 that are pending, are not part of the detained docket. They are part of the released docket. And those cases take longer, the ones that are not detained, the non-detained docket, and they have caused, since 2008, that number to go dramatically up. What we have done about that situation is General Sessions and I have issued Attorney General orders changing some of the specifics as to how those cases are adjudicated. And in addition, we have, together with the help of Congress, which you've authorized and funded more immigration judges, we've put a dramatic number of more judges, especially to the areas where it's needed, which is oftentimes at the border.
So you've also put in place an additional performance metric to gauge the performance of judges working to complete cases and reduce the backlog. Are those working? And you've gotten pushback from groups who are concerned that they amount to case quotas. And if they are working, are you aware of any organization in which productivity of its workers isn't assessed as one part of a multidimensional performance review?
Yes, in fact, government-wide, where there are administrative law judges similar to our immigration judges, there are typically performance metrics that are in place to not only evaluate their productivity, but also to budget and manage that workforce.
And what are you doing to ensure that continuances in immigration cases are not abused and are granted solely for good cause?
We issued an Attorney General order which set the standard, which had been different based on what the Immigration Appeals Court, which is an internal, the Board of Immigration Appeals, which is an internal DOJ body that the Attorney General sits over. We've passed rules and regulations and a new standard for issuing those continuances for good cause, as you mentioned.
All right, thank you. I yield back.
Thank the gentleman. I'll now yield to the gentleman from Rhode Island for the purpose of unanimous consent request.
Thank you, Mr. Chairman. I would ask unanimous consent that the following articles be placed in the record. The first is an article entitled Exclusive Trump Loyalist Matthew Whitaker was counseling the White House on investigating Clinton. A second article, Sessions replacement. Matthew Whitaker called Mueller's appointment ridiculous and a little fishy. Third article, all the time Robert Mueller's new boss railed against the Russia probe. Trump's pick to replace Jeff Sessions once said Mueller investigation risked becoming a witch hunt. And finally, an article entitled Trump's new acting attorney general once mused about defending Robert Mueller.
Without objection, these documents will be placed in the record. I now recognize the gentleman for 5 minutes.
Thank you, Mr. Chairman. Mr. Whitaker, I'm going to be really straight with you up front. I'm going to cut you off if you make long speeches. We have very limited time. You do not need to thank me for asking the question or compliment me that it's a good one. I'll assume they're all good questions and you're grateful. One, you were briefed by the special counsel. You've acknowledged that. Did you share that information with any members of your staff, the information you learned in that briefing from the special counsel or his team?
Congressman, as I previously testified, there was one other individual in that briefing with me.
And who is that individual?
It is the U.S. Attorney from the Eastern District of California who I've brought on.
What is the name of the individual, Mr. Whitaker?
His name is Greg Scott.
So did you communicate any information you learned in those briefings to other members of your staff?
I don't believe so, no.
Do you know whether any information that you learned in those briefings were communicated to anyone at the White House?
As I mentioned previously, Congressman, we have kept a very close.
Mr. Whitaker, it's a yes or a no. Do you know whether it was communicated to anybody at the White House?
As I sit here today, I don't know whether it was communicated.
Did you put into place any restrictions or limitations or instructions to your staff not to share this information with anyone at the White House or the president's legal team?
Yes, together with the general standard that investigative information and materials need to know and law enforcement.
Thank you, Mr. Whitaker. Did the president lash out at you after Michael Cohen's guilty plea for lying to Congress about a Trump Organization project to build a tower in Moscow?
The president specifically tweeted that he had not lashed out.
I'm asking you, Mr. Whitaker, did the president lash out at you? I'm not asking you what he tweeted. I don't have a lot of confidence in the veracity of his tweets. I'm asking you under oath.
Congressman, that is based on an unsubstantiated.
Sir, answer the question, yes or no. Did the president lash out to you about Mr. Cohen's guilty plea?
No, he did not.
And did anyone from the White House or anyone on the president's behalf lash out at you?
No.
Mr. Whitaker, did the president lash out to you on or about December 8th, 2018, to discuss a case before the Southern District in New York where he was identified as individual one?
No, Congressman.
Did anyone on the president's behalf, either inside the White House or outside the White House, contact you to lash out or express dissatisfaction?
Did they contact me to lash out?
Yes. Did they reach out to you in some way to express dissatisfaction?
No.
Okay. Did you share the questions that Mr. Nadler forwarded to you prior to this hearing with anyone at the White House or the president's legal counsel?
Congressman, I did not.
So when you claimed earlier that you were going to invoke a privilege, you were invoking a privilege about questions the president hasn't even seen.
Congressman, to be clear, I'm not invoking any privilege.
Well, you said earlier that you, in your written testimony, that you would not answer questions about your conversations with the president. Did you not?
Yes, I did.
So you are not sitting here today saying the president has instructed you not to answer a question, correct?
I am not sitting here today saying that the president has instructed.
So then you're prepared to answer all these questions.
Congressman, I think I was pretty explicit in my opening statement.
So have you spoken to the president, Mr. Whitaker, about the Mueller investigation?
Congressman, as I have previously testified, I did not talk to the president about the Mueller investigation.
Have you ever spoken to the president or parts of his legal team about information that you've learned in your capacity as acting attorney general related to the Mueller investigation or any other criminal investigation involving the president?
Congressman, while I have specifically been saying that I'm not going to comment about my conversations with the president or his senior staff, I have also been very clear that the president has not instructed me to do anything.
That wasn't my question. My question is, have you had conversations about what you learned? That's a yes or a no.
Congressman, I spend all day, every day talking.
Mr. Whitaker, my question is very specific. Have you spoken to the president or his legal team about what you've learned in the Mueller investigation or the related criminal investigations that may involve the president? Yes or no?
Congressman, as I specifically answered earlier to a question.
Mr. Whitaker, you're clearly not going to answer the question, so I'm going to move on. You know Professor John Barrett, correct? Well, anyway, this is a law school professor who tweeted that you told him in June of 2017 that you were flying out from Iowa to New York City to be on CNN regularly because you were hoping to be noticed as a Trump defender and through that to get a Trump judicial appointment back in Iowa. You then went on to describe the Mueller appointment of the special counsel as ridiculous and a little fishy, that Mueller investigating Trump's finances would be going too far, that there is no criminal obstruction of justice charge to be had against President Trump, that there was no collusion with the Russians and the Trump campaign, that any candidate would have taken the same meeting as Donald Trump Jr. with a Russian lawyer, and finally that a replacement for Sessions could reduce Mueller's budget so low that his investigation grinds to almost a halt. You said all those things, and they're all in print, and it answers Mr. Deutsch's question. The American people wonder just how is it that Mr. Whitaker becomes the acting Attorney General of the United States in violation of existing statutes? Was he put there for a particular purpose? That wasn't a question, it's a statement. I yield back. And
I've
thank you.
observed that. The time of the gentleman has expired. Who's next? Mr. Eschenthaler.
Thank you, Mr.
Eschenthaler
Chairman.
is recognized.
Thank you, Mr. Chairman, and thank you, Mr. Whitaker, for being here today. I just want to quickly reference the letter that was sent to you from the chair on January 9th. In this letter, in the chairman's own words, it said that this committee was here to, quote unquote, to conduct oversight of the department. In this letter is also important other topics that were supposed to be discussed here today, like immigration, gun violence, the Violence Against Women's Act, Obamacare, national security, and that's not even the complete list. I know you read the letter. I was excited to be here. I thought these were critically important issues that affect the constituents of my district and millions of Americans. And frankly, a lot of these issues are life and death. So I'm really confused as I sit here today in this hearing with my Democrat colleagues focused solely on one topic, and that's the Mueller investigation. I really hope that my friends across the aisle would have used this opportunity for more bipartisanship and less showmanship. But clearly I was wrong. With that said, I want to get to some of the important topics that we were supposed to have focused on today. One of those is sanctuary cities. In my home state of Pennsylvania, the sanctuary city of Philadelphia has released at least 3 child molesters back onto the streets. And everyone knows the tragic story of 32-year-old Kate Steinle, who was murdered by an illegal immigrant who was convicted of 7 felonies and deported 5 times. Now, those child molesters in Philadelphia, the murder of Kate Steinle, they were all released because some city wanted to score cheap political points. And that's why I'm focused on ending sanctuary cities. Mr. Whitaker, what steps is DOJ taking to end the dangerous practice of sanctuary cities?
Well, first of all, we're ending taxpayer-funded grants to sanctuary jurisdictions. The Attorney General Sessions announced new conditions for our Burn JAG grants that will increase information sharing between federal, state, and local law enforcement to ensure public safety. I don't know if the congressman knows this, but one of the challenges we have is in a sanctuary jurisdiction, jails will release convicted criminals back into the community instead of informing Immigration Customs Enforcement that the person is available to be picked up at the jail. It is an incredibly dangerous situation to make an ICE officer go into a community to try to arrest somebody that is here illegally and has been convicted of a crime, oftentimes crimes that, like you mentioned, and I cannot imagine a situation where a mayor or a city council or a county executive or otherwise would put law enforcement officers in harm's way. It is quite frankly bad policy, and we are going to work very hard to end it, and one of the ways we're ending it is by taking away the resources to those jurisdictions that have that policy.
Thank you, Mr. Whitaker. Mr. Whitaker, I have one more question regarding the opioid crisis. This crisis is striking our country hard, particularly southwestern Pennsylvania. Data from 2017 shows that it is more likely now that someone's going to die of a drug overdose than a car crash. My district has been hit really hard. In particular, Fayette County saw an 88% increase in overdose deaths from 2015 to 2017. What steps has the DOJ taken to address this shift? And do you think that a lot of the problems that we're seeing in these stats comes from a porous southern border?
To address your second question first, I do believe that most illegal opioids, like fentanyl, non-prescription illegal opioids, like fentanyl, heroin, and their derivatives are imported through our southern border. Some, not a majority, but some are also imported via direct mail, for example, and ordered off the dark net. I went through a list of things that the Department of Justice is doing to combat this opioid epidemic. I hope that this committee, while it's something I was prepared and wanted to talk about, and I appreciate the question, will look at other ways that we can put resources into the opioid crisis. 70,000 people, as you mentioned, have died of drug overdoses. A majority of those are from some form of opioids. And we also, quite frankly, and I mentioned my trip to China last August, we have to work together with the Chinese government to reduce the inflow of fentanyl, and we also have to, we have emergency scheduled right now the fentanyl analogs, but we need an act of Congress, and I hope that we can get that to make that permanent, that these fentanyl derivatives and creative chemists that change the chemical makeup of fentanyl do not continue to try to evolve their drug to avoid our regulation.
Thank you, Mr. Whitaker. I yield back my time.
Thank you. Mr. Whitaker, did your watchdog organization ever receive contributions from foreign donors?
Mr. Chairman, point of order.
I'd ask you to stop the clock.
The gentleman will suspend, the gentleman will state his point of order.
My point of order, and I'm going to go back to this, and would, again, undoubtedly the majority does not care, but this is outside the scope of this hearing. This was not while he was employed here, and whether he outside had donors or not during the time he was not employed, making no connection either way is not inside the scope of this hearing. And that's not the call of this committee. Now, and you know, look, I'm outgunned over here. I have no votes. This is not part of the call of the hearing. Mr. Waltwell, there's plenty of things to do. Ms. Cicilline, you
Will
can...
the gentleman yield?
Mr. Collins, if you want to sit down there with his lawyers, you can go sit down there, but you're not his lawyer.
Gentleman will suspend.
And neither are you, Mr. Swalwell. And if you ask questions that are actually part of this, instead of running for president down there, we could get this done.
You can sit down there. There's room.
Both gentlemen will suspend.
Mr. Chairman.
Gentleman has stated a point of order. The chair will rule the point of order is not well taken. The scope of people's questioning, we afford a wide latitude, and we don't even know where it's going at this point. The gentleman's point of order is not well taken. The gentleman will resume.
Appeal the ruling of the chair.
The gentleman appealed the ruling of the chair. The gentlelady moved to table. Move to table is not debatable. The clerk will call the roll on the motion to table.
Mr. Chairman.
Oh, let's call the roll. All in favor of tabling the resolution, I'm sorry, all in favor of tabling the appeal of the ruling of the chair will say aye. Aye? Aye. Nay? Nay. The ayes have it. The appeal of the motion is tabled. The gentleman will continue.
Mr. Whitaker, did your organization have foreign contributions?
Just to be clear, are you talking
Yes or
about,
no?
What do you mean by my organization?
You led an organization called FACT. Did it receive foreign contributions while you were there?
I don't actually know the answer to that. I do not believe, as I sit here today, that it did, but our main donor was a group that was a U.S. entity.
Did you interview with Don McGahn in July 2017 to have the job that Ty Cobb would ultimately get?
I ultimately did not meet with Mr. McGahn, so I met with
Did you
his
talk with
staff.
him on the phone?
You know, we actually never did end up talking on the phone either.
Who did you meet with on his staff?
I talked to Annie Donaldson from his staff, who was his chief of staff at the time.
And when you talked to Mr. McGahn's chief of staff, did you express in that conversation your prior views about the Mueller investigation?
No, I did not.
Was it brought up by the chief of staff?
In fact, at the time, Congressman, everyone at the White House did not want to talk about the special counsel's investigation.
But you were interviewing for a job that would respond to the special counsel's investigation, is that right?
At the time, I was interviewing for the position that was ultimately occupied by Ty Cobb.
But I want to understand how you could interview for a job that would respond to the special counsel investigation, but you were not to talk at all about the special counsel investigation. How would they know?
Well, I said we didn't talk about it. They did not want to talk about the investigation because the folks were dealing with that investigation, and that's why they wanted to bring in someone that had been unrelated to the investigation and the campaign.
Did they talk to you about your prior opinions about the Mueller investigation?
No, we did not discuss it. We
Has there
discussed
been
about my background as a United States attorney and my legal practice.
Has there been discussion at the department about keeping the Mueller report from going to Congress?
No, in fact, we're continuing to follow the special counsel regulations as it relates to the report. And we haven't received the report.
Has there been a draft opinion about keeping it from going to Congress?
You know, Congressman, I'm not going to talk about the kind of ongoing investigation that is the special counsel. I will share with you that
Mr. Whitaker, did Donald Trump ask you if you would recuse before you became acting attorney general? If that question came up, did he ask you what you would do?
Congressman, I've already answered that question in my opening statement.
Do you believe Attorney General Sessions should have recused?
As I mentioned in my answers previously, the recusal decision...
No, do you believe, yes or no, that he should have recused?
I actually, as I sit here today, I do not have an opinion. I believe he determined it was the right decision for him to make, and so I agree that he made the right decision for him.
Have there been any discussions at the department about pardons for Paul Manafort, Roger Stone, Michael Flynn, or Michael Cohen?
Congressman, we have a very well-worn system
That the president doesn't follow, but have there been discussions about pardons for those individuals that you're aware of, yes or no?
Congressman, as I've been acting Attorney General, I have not been involved in any discussions of any pardons, even and including the ones you're discussing.
You made a public statement last week that the investigation was nearly complete. Is that your characterization, or is that Bob Mueller's characterization?
Congressman, that position that I mentioned last week in a press conference was my position as acting Attorney General.
Would Bob Mueller, if sitting before us right now, agree with you?
You know, Congressman, Bob Mueller is going to finish his investigation when he wants to finish his investigation.
Is Mr. Mueller honest?
Congressman, I have been on the record about my respect for Bob Mueller and his ability to conduct this investigation.
Do you believe he's honest, yes or no?
I have no reason to believe he's not honest, so yes, I do believe he's honest.
Do you believe he's conflicted, yes or no?
Congressman, as I mentioned regarding recusals, you know, sort of the conflict analysis is for the individual lawyer to make once a matter is before them. And I'm sure that whether it's Bob Mueller, whether it's Rod Rosenstein,
But the president
or
has
anybody
called
else
him
at the Department of
conflicted.
Justice,
The
they would
president's
do
called
it.
him conflicted, and you oversee the investigation. Do you believe that Mr. Mueller's conflicted?
Congressman, as acting Attorney General, I have followed regular order at the Department of Justice, and I have expected that the lawyers and the support staff and agents that work for me follow regular order, and as I sit here today, I don't have any reason to believe that.
So you don't believe you believe he's honest, you don't believe he's conflicted. Can you say right now, Mr. President, Bob Mueller is honest and not conflicted?
Congressman, I'm not a puppet to repeat what you're saying.
Are you able to say it, or do you not believe it?
I have answered your question as to what I believe about the special counsel. I stand by my prior statement.
Can you say it to the president, though?
Congressman, I am not here to be a puppet to repeat terms and words that you say that I should say.
Can you say that to the president?
Regular order.
Mr. Chair, he hasn't answered that question.
Sorry?
He has not answered the question if he would say that Mr. Mueller is honest.
The time
not
of the gentleman
conflicted
has
to the president.
expired. The witness may answer the question.
I don't have anything further to add. I think I've answered the Congressman's question.
That's a question for observers. The gentleman from North Dakota, Ms. Armstrong.
Mr. Whitaker, you've obviously been acting Attorney General during some fairly interesting times, and we've heard a lot about that today. But I also want to commend the Department of Justice, the FBI, the White House, and all other law enforcement who was involved in the First Step Act. This is a tremendous shift, not just for the Department of Justice, not just for Republicans, and not just for Democrats. And it's the way government's supposed to work. It's supposed to show redemption, tough on traffickers, organized crime, and also work towards a smarter way to deliver criminal justice, particularly with addiction-related crimes. So my only hope is that because it is called the First Step Act, there will be a second step. And if you ever, unfortunately, I have some other questions for you, so anytime on your way out, if you have any advice on something Congress can do to continue this momentum, I would be very, very appreciative.
Well, you know, Congressman, I was involved on behalf of the Department of Justice in the First Step Act, and I just want to commend everyone on this committee that worked on the First Step Act to successfully get that passed and to get it through both the House and the Senate. I actually know how difficult that is. I think one of the things that we could use your help on is to make sure you fund the First Step Act and what you've requested the Department of Justice to do. You know, we continue to implement the First Step Act consistent with the law that you passed. And in fact, just last night, we sent out guidance to our U.S. Attorney's offices out of how to implement the First Step Act. And I know that the Bureau of Prisons as well is implementing the act.
And I would hope to work towards having a federal level pretrial release program to be available to every state and county courthouse across the country, because one of the great ironies I've always found about your pretrial release program is it is incredibly effective, and then you get a 10-year minimum mandatory. So the pretrial release program at the Department of Justice and U.S. Attorney's offices across this country is phenomenal, and they deserve to be credited for that.
And as a former United States attorney for 5.5 years in Des Moines, Iowa, I understand uniquely how pretrial release works. And so we'd be interested in your proposal, and we'll look at that and work with you carefully to try to implement something like that.
Now, in our role as oversight, I do actually have a question about something that has come up in the past and that, given the nature of the testimony today, very, very possibly could come up in the future. And I think often when we have names like Clinton and Comey and Rosenstein and Trump and Mueller and Russia, we forget that the law is the law. You testified earlier to Representative Jordan that we prosecute crimes, not people. And I think often across this country, we think laws apply differently to people depending on their status. And one of the areas where this came up, and it was something that concerned me before I was involved in this, is when we started talking about the difference between gross negligence and intent. And it was in a very particular statute, and we were dealing with it, and there were members of the FBI and the DOJ that said that were concerned about vagueness. But as far as I understand in the federal code, particularly the federal criminal code, gross negligence has the same definition approximately everywhere in the criminal code, right?
In my experience, your statement is generally correct, yes.
So if gross negligence would be vague under one particular statute of the criminal code, then we should be concerned that it's vague under every other other section of the criminal code.
That is correct. And there's, for example, jury instructions that would say, inform a jury as to how to evaluate a gross negligence standard to convict someone of a crime.
And assuming that it wasn't political in nature as to why gross negligence wasn't looked forward in any particular case, under your leadership, under the DOJ, has anybody reviewed this, looked at it, and made any proposals to Congress, particularly regarding whether or not we need to tighten up gross negligence language, not just, let's say, in the Espionage Act, but in any section of the federal criminal code?
As I sit here right now, I don't know the answer to your question, but I'd be happy to get back to you on that.
I'd appreciate that. And then I'm just, again, under normal course of order, I'm assuming it works the same as everywhere. Law enforcement agents, and I know a lot of FBI agents actually do have law degrees, but FBI agents investigate crimes, and then it goes up the food chain to the U.S. Attorney's Office, usually, maybe.
Remember, I mean, you need a predication to even open an investigation, and that's the step that I think a lot of people forget. I mean, there's many steps along the way, and when you conduct a criminal investigation, first you have to predicate the investigation. Then it's investigated by the special agents that investigate the crimes. Typically, an AUSA works with them to get search warrants and the like, and then ultimately a case is developed and presented to a grand jury, and that is charged. So I mean, that's typical. And then again, there's a discovery process and a trial process. It's a very, very well worn, and to go back to something you mentioned earlier, Congressman, all of that is done at the Department of Justice without improper interference or interference based on a political nature.
Well, I'm just concerned moving forward that we have the same, I mean, everybody knows, and obviously this is hypertension and hyper-political, but I'm very concerned moving forward that everybody knows what the rules of the game are as far as statutes are, and that the law is actually applied in the way the law should be applied, because I do believe in the past it has not been, and obviously this is continuing to go on. This hearing today is noticeable of that. So on your way out, maybe it's the best time to deal with some of those things, because sometimes that's when we have the courage to do it. But this could very much come up again in the future.
Thank you, Congressman.
Time of the gentleman has expired. The committee will stand in recess for 2 minutes. I ask that the members remain here if they can.
Do you have to go to the bathroom?
You're watching live coverage from the Washington Post as the House Judiciary Committee takes a brief break. Acting Attorney General Matthew Whitaker still faces questions from a number of members of Congress. We skipped over some Republicans who weren't present earlier. We'll see if they turn up to get their chance to ask him questions. But we've got about half of the Democrats left in this committee yet to ask questions. This is a 40-member panel, and so it's an extensive list of people who each get their 5 minutes, although the 5 minutes are going fast, and you can certainly feel the frustration in that from Democrats in the room. Republicans choosing to hit a range of other topics and questions as they go through the process. We saw some interesting exchanges, notably with Eric Swalwell, Democrat, pushing to try to get some answers from Matthew Whitaker, the two clashing over the line of questioning and just how they were asked, just how it was going. Eric Swalwell asking whether the president was having these conversations with Matthew Whitaker on recusal, the question of recusing himself from the Russia probe. We also saw Hakeem Jeffries give some tough questions, Democrat from New York. Let's take a look at one of the exchanges from today's hearing.
So let's be clear. The investigation into Russia's attack on our democracy is not a witch hunt. It's not a fishing expedition. It's not a hoax. It's not a lynch mob. It's a national security imperative. The fact that people suggest otherwise comes dangerously close to providing aid and comfort to the enemy.
Go ahead. You saw there Hakeem Jeffries, Democrat, talking to Matthew Whitaker, really delivering quite a speech. He started off his line of questioning by saying, "Who are you? Where did you come from? And how the heck did you become the head of the Department of Justice?" As Mr. Whitaker began to answer, Congressman Jeffries said, "Look, that's just a statement, not a question," and it went from there. Mr. Jeffries brought up some past comments by Matthew Whitaker, including a tweet. Now, we all know that people don't always take credit for retweets they do or the headlines that they tweet, but this was really significant because the tweet in question was an article talking about the Mueller probe and describing it as a lynch mob. And so Attorney General Whitaker tried to disavow that and step back from it, but it does give you a sense of Democrats' concerns over his past statements and the history he has with criticizing the Mueller probe. As we watch Republicans throughout this hearing, they're trying to do two things. They're trying to push back at the notion that this is a proper hearing, that this is a chance to hold Matthew Whitaker's feet to the fire. They're saying this should be about oversight, this should be about bigger issues. And they're also trying to get at some questions of their own, talking about things like criminal justice reform, talking about the opioid crisis. But that is not what Democrats want to get out of this hearing. Chairman Jerry Nadler, he's the gentleman in the center who you saw gavel out just a few moments ago to take a very quick, what's probably a bathroom break, went into this hearing with a list of questions he planned to ask the acting attorney general. And at this point, a lot of those questions have really been sort of dodged around, and Matthew Whitaker hasn't been pinned down yet. A primary question is just what kind of conversations he had with the White House about the Mueller probe and what the tone of those conversations were. One member of Congress asking about rumors and stories that the president had lashed out at him over anger on issues including Michael Cohen's comments. So Matthew Whitaker's back in the seat. We'll head back to the House Judiciary Committee hearing. Still a lot of members to go to ask questions as they start the process up again. Stay tuned.
Thank you, Chairman Nadler. Mr. Whitaker, thank you for being here today. Last year, FBI Director Christopher Wray came before this committee and stated that no one is above the law. You would agree with that statement, wouldn't you?
I would. In fact, there is a Time magazine.
Thank you. Well, good.
Covers
Yeah.
in my office.
Thank you. You don't have to keep saying it. Thank you. You haven't taken any sort of a loyalty oath to Donald Trump, have you?
No, I have not taken this vote.
Have you signed any non-disclosure agreement with the White House or Donald Trump?
We signed our ethics pledge, which was the most robust ethics pledge, but I haven't signed any other documents other than the normal DOJ employment document.
And there was no non-disclosure agreement with anything you've signed, correct?
I don't believe so, but I don't know what the standard DOJ forms are.
In fact, the only thing you really had to do before you could assume your current position was take an oath to the United States Constitution, isn't that right?
I proudly took the oath for the second time when I came back to the Department of Justice.
Thank you. So I'm going to ask you a series of questions about the U.S. Constitution that you can easily answer yes or no. The first question is, there is no sentence in the Constitution that states that the president's national security advisor can't be indicted, correct?
Congressman, as is consistent with the practice of the Department of Justice, we investigate crimes and we prosecute individuals that commit crimes.
Just asking a simple question. I'll go on. There's no sentence in the U.S. Constitution that states the president's former campaign chairman can't be indicted, correct?
Same answer to your previous question.
Does that sentence exist in the Constitution?
Of course it does not, Congressman.
That's
You know
right,
that,
'cause-
and I know that.
Right, because Paul Manafort was indicted. There is no sentence in the Constitution that says the president's children can't be indicted, correct?
Congressman, you know, you can give me the whole list. I mean, you know, sort of.
No, I'll give you three more.
Okay.
Yeah, right?
There is
Children's
no
not in there,
sentence
right?
in the United States Constitution that says that the president's children cannot be indicted.
There's no sentence in the U.S. Constitution that says the vice president can't be indicted, correct?
That's correct.
Right. There's no sentence in the U.S. Constitution, this is my last one, there's no sentence in the U.S. Constitution that says the sitting president of the United States cannot be indicted, correct?
Congressman, because that is the opinion of the Office of
Yeah, I
Legal
don't
Counsel
actually
of the
care
Department
what
of Justice.
DOJ policy is, I'm
It's
asking
been
about the
consistent with the
Constitution.
practices of the
Mr.
Department of
Whitaker,
Justice
it's just a
for
yes or no question.
years,
Mr. Whitaker, I'm asking you a
under
factual.
both administrations.
After this hearing, you can spin the Constitution all you want. As you sit here today,
not
you just
spinning
have,
the
you just have to answer a factual yes or no question. I'm going to make it even easier for you. There's no sentence in the Constitution that says, quote, the sitting president of the United States cannot be indicted, unquote. Correct?
Congressman,
yes or no?
As you know, I would
have
refer
it
you.
right here.
I have
Is
I
that
have a copy myself.
Right, so is that
Congressman.
sentence in this Constitution? It's not, correct?
The
I'm
court
not trying to
did-
trick you. It's
No,
not a hard question.
I don't. Again,
It's a
it is-
founding document of our federal government. Is that sentence in this Constitution?
Congressman, you and I both know that the way that the OLC opinion is written.
I'm asking about the
lays out a
Constitution,
very
the
clear
founding-
question as to why the
Right.
president
I'm
of the United
just
States,
asking about the Constitution.
sitting president of the United
Right.
States, can't be indicted.
I'm just going to, Mr. Chair, I'm just going to submit the U.S. Constitution for the record and say, no, that sentence is not in there. Now we're going to move on. Earlier today, you had testified that you did not communicate to Donald Trump or senior White House advisors about the special counsel's investigation. So I'm going to ask you a related question. Did you communicate to Donald Trump or any senior White House advisors about investigations from the Southern District of New York concerning the Trump Organization, the Trump Inaugural Committee, Michael Cohen, or other investigations that relate to Trump entities or potentially the president?
Congressman, I mentioned that, I said other investigations in my opening statement. I really don't have anything further to add to that answer.
And when you said other investigations, you mean you communicated to the president about other investigations?
No, I didn't. That's
That you
not
did
what I
not.
said in my opening statement. I'll refer you back to my opening statement. I was very clear
Did you
about that.
communicate to the president, any senior White House advisors about investigations from the Southern District of New York related to Trump entities? Or
Again, I was very explicit in my opening statement as to that, not only about my communications regarding the special counsel's office, and I said other investigations, and the Southern District of New York would be included in other investigations.
Okay, thank you. So we're going to move to another subject. The president has talked about national emergency. Under the latest FBI data, it's correct, isn't it, that violent crime across the United States has gone down?
Yeah, we celebrate actually that violent
That's right.
crime
In
has gone
fact,
down
property
over the last 2
crime,
years.
property crime has gone down as well, isn't that right?
Congressman, as I sit here right now, I believe generally all crime is down over the last 2 years
And then
since
my last
President
question.
Trump was elected.
Sure, my last question to you is, you would agree with Donald Trump, wouldn't you, when last year he tweeted out that border crossings are at a 45-year low?
We saw a precipitous decline in border crossings after the president was elected and sworn into office. Unfortunately, we haven't been able to retain those gains, and we've seen an absolute dramatic surge in family units.
Thank you.
Time of the gentleman has expired. Mr. Raskin.
Mr. Whitaker, before you took the call from President Trump, you had a fascinating career. Owned a daycare center, a concrete supply business, trailer sales, GOP activist, U.S. attorney who unsuccessfully prosecuted Iowa's first openly gay state legislator on trumped-up Hobbs Act charges that were dismissed by the jury in about an hour, Senate candidate. There have been some scandals, too. Here's one. Trump's acting attorney general involved in firm that scammed veterans out of life savings. Veteran says, I spent the money on a dream. I lost everything. But the newspapers say you struck gold when you arrived in Washington, which the president calls the swamp. Here's one that tells the story. Conservative nonprofit with obscure roots and undisclosed funders paid Matthew Whitaker $1.2 million. According to the Washington Post, in the 3 years after he arrived in Washington, Whitaker received more than $1.2 million as the leader of a charity that reported having no other employees. That's a pretty good deal. Now, what was the name of the charity that you ran, Mr. Whitaker?
Congressman, you've mentioned a lot in your...
No, but I'm asking you a very specific question. What was the name of the charity?
You have challenged my character.
No, I'm asking you a question. I control this time, Mr. Whitaker. If you want to ask the chairman for time of your own, you can do it. This is my time. Mr. Whitaker, you don't run this committee. You don't run the Congress of the United States, and you don't run the Judiciary Committee.
Gentleman will suspend. The gentleman is correct. The witness will answer the questions, and it's up to the gentleman to decide what questions. The gentleman will continue. We'll resume.
What was the title of the not-for-profit that you ran?
What time period, sir?
What was the last title? I know it changed its name 3 different times, right? What was the final name?
While I was employed as the executive director, it was called the Foundation for Accountability and Civic Trust.
Did you name it?
I did. Actually, you know,
those are highly noble goals, accountability and civic trust. So let's talk about some accountability and civic trust. Mr. Whitaker, I've got a question for you.
No, you asked me a question.
I asked you a question. I control the floor, Mr. Whitaker. You don't understand. Now,
Gentleman is correct. The gentleman controls the time, and if he wishes, as many members have done on occasion, they make a statement, they don't even ask a question, but if he wishes to proceed to another question, it's his time.
But Congressman, I do not feel, I mean, Mr. Chairman, I do not feel like my answer would be complete on the record.
It's up to
the question he asked.
okay, Mr. Whitaker, see if you can get into this. Tell us where the money came from that you were paid, the $1.2 million that you were paid before you went to the Department of Justice. I'm asking my question.
Mr. Chairman, point of order, which overrules your question. Point of order.
The gentleman will explain his point. The gentleman will suspend, the gentleman will state his point of order.
Look, we're going to go down this probably many more times, but again, if you wanted to do a confirmation hearing, this is not under the scope of this hearing. This is not a confirmation hearing and is not shown to be a...
Mr. Chairman, this goes to
the gentleman's point of order is not well taken. The gentleman, the gentleman from Maryland has the discretion to ask the questions. The gentleman will proceed.
Appeal the ruling of the chair.
The gentleman has appealed the ruling of the chair. The gentlelady has moved to table. All in favor of the motion to table the appeal of the ruling of the chair will vote aye.
Aye.
Opposed, nay. The ayes have it. The ruling of the motion is tabled.
Mr. Chairman,
gentleman,
can you and I engage in a
the
colloquy?
gentleman will.
Can we suspend the clock and you and I engage
No.
in a colloquy?
We're in the
may solve some longer
we're in the
problems,
middle of the.
Point of order, Mr. Chairman. Is the ranking member just going to continue to interrupt when he doesn't like the flow of questions?
Excuse me.
I'll probably make a point of order when that needs to be made.
I
Right now,
Good if it'd be useful if it was actually a point of order.
Everyone will please suspend. The gentleman made a point of order. It was ruled out of order. Right now, the gentleman has the time. If the ranking member wants to make a point, I'll recognize him after the gentleman is completed. The gentleman will resume.
Thank you, Mr. Chairman. It's been reported publicly that there was one donor. And as we understand it, I think you're testifying today that you were the sole employee of the group. So there was one donor and one employee. Do you know who the donor was to the group that funded your salary for $1.3 million?
Yes, I do.
Who was the donor?
The donor was another nonprofit 501c3 organization called the Donors Trust.
Okay, now that was the pass-through vehicle, but who reached into their pocket and wrote the check to go through that to pay your salary?
Congressman, as you know, because you've looked at this issue, the Donors Trust is much bigger than the Foundation for Accountability and Civic Trust and raises millions, if not hundreds of millions of dollars every year. I actually, as I sit here today, have no idea who the donors to Donors Trust that then funded
thank you.
the
All right,
foundation.
well then I've got a theory that I want to float with you, and it goes to something very strange that's been happening at the Department of Justice recently. Casino billionaire and magnate Sheldon Adelson hates online gambling for obvious reasons. It's competition for him. He wants people in the casinos, not online. And he spent more than $1 million lobbying Congress to override a 2000 opinion by the Office of Legal Counsel at DOJ, saying that the Wire Act plainly prohibits only sports gambling online, not gambling in the states, which is why Florida, Pennsylvania, New Jersey, lots of states have built important businesses for themselves online. But Congress wouldn't change the law according to the demands of Mr. Adelson. So rather than change the law, he decided to try to get the Department of Justice to change the interpretation of the law. And he threw millions into a campaign to remake the DOJ and get the Office of Legal Counsel to perform a complete reversal and say that the Wire Act bans the kinds of lotteries that states run online, even though its language plainly prohibits only sports betting. And when Donald Trump won and Mr. Sessions became AG and you became Chief of Staff, DOJ leadership ordered a reevaluation of this legal question. And what do you know? The Office of Legal Counsel found some subtle and invisible points of law that apparently escaped the Department of Justice back in 2011, and it reversed the plain reading of the interpretation, which talks specifically about sports betting. Now, were you involved in that decision?
Congressman, the General Sessions was recused at the time that that decision came out.
So were you recused too?
Therefore, I was recused, and so I was not involved in that decision.
Did you ever talk to Sheldon Adelson about it?
No, I've actually never met Sheldon.
Okay, did you talk to any of his lobbyists about it?
No, I did
Did you
not.
talk to Charles Cooper about it?
No, but I do know Charles Cooper, and I would point out one of the things, Mr. Rask.
Well,
it's
look,
very
if
important.
you can ask the
It's when-
chairman for
it's when
time,
the
but I
opinion-
can't give you my time. Forgive me, we only have 5 minutes. here.
OLC
So,
opinion came
The
out.
gentleman controls the time. At the conclusion of his
the
statement,
chairman not want
at
the
the
witness to give
conclusion,
full answers?
at the conclusion of his 5 minutes, I will afford
Okay.
the witness some time, but the gentleman controls the time.
Thank you, Mr. Chairman. In January and February of 2018, the chairman and vice chairman of Wild Rose Casino and Resorts, a casino in Iowa, each donated $2,600 to your Senate campaign, which was over 4 years before when you lost that campaign. How did these casino operators come to donate to your campaign several years after you lost? Did you talk to them?
Time of the gentleman has expired. The witness may answer the question.
To answer your question specifically, no, I did not. To go back to the other point I'd like to make, Congressman, is that the first OLC opinion that preceded the one we just issued in November was done, and the state of Illinois provided a white paper regarding the position on the Wire Act. And so I think it is very consistent, and your inference that somehow that process was corrupted or corrupt is absolutely wrong, and the premise of your question I reject.
Gentlelady from Washington, Ms. Jayapal.
Thank you, Mr. Chairman. Mr. Whitaker, thank you for being with us. Our country is still reeling from the horrors of family separation that occurred at the border. I was the first member of Congress to talk to hundreds of women and men who had been ripped apart from their children. I went into a federal prison to talk to those women. Many of them had not even been able to say goodbye to their children. They sat in the room next door as they heard their children yelling for them, and they were not able to go and speak to their children. And for weeks, they didn't know where their children were. Most of these women, most of the men, were seeking asylum. And your department, instead of allowing them their legal right to seek asylum, your department instead imposed a zero humanity policy to prosecute them in mass proceedings, resulting in the U.S. government tearing thousands of children from their moms and dads, and this is still happening. And the truth is, we may not know how many children were separated from their parents. So, Mr. Whitaker, you were former Attorney General Jeff Sessions' Chief of Staff at the time, is that correct?
Of the zero tolerance policy being implemented?
You were his Chief of Staff at the time.
At what point in time? I was...
Of the family separation policy. Let me just tell you,
I'm sorry, there was no family separation policy. There was a zero tolerance policy.
This has been given 4 Pinocchios multiple times. I'm just going to tell you, you were former Attorney General's Chief of Staff at the time. Last month, Senator Merkley released a leaked draft memo by senior officials at the Department of Justice and Homeland Security outlining policies to separate children from their families. Were you aware of this memo at the time?
No.
So as the chief of staff, you were not aware of what your boss was doing?
Was the memo, I'm sorry, are you talking about the leaked memo or the memo that General Sessions issued?
There was a
implementing the
leaked
zero-
draft memo by senior officials at the Department of Justice. You were the chief of staff. I would think you would know, and you would be a senior official, you would know about that memo. The memo stated that a policy of criminally prosecuting parents would require close coordination between DHS and the Department of Health and Human Services, which would be tasked with housing children separated from their moms and dads. And yet a report released by the Government Accountability Office last October says that DHS and HHS were, quote, unaware that your former boss's zero tolerance prosecution policy memo was coming. Is it correct that the Department of Justice provided no advance notice to those departments?
Congresswoman, the department's policy.
It's just a yes or no. Did you provide advance notice to those
We conducted
departments?
a press conference in San Diego with the head of the Immigration Customs Enforcement when we announced the zero tolerance policy. And all the zero tolerance policy does is says that we will take all referrals from DHS.
I'm just going to stop you right there because it is my time. According to the GAO report, the GAO, the Government Accountability Office, report on family separation, DHS and HHS officials told us the agencies did not take specific planning steps because they did not have advance notice of the Attorney General's April 2018 memo. It went on to say specifically, CBP, ICE, and ORR officials stated that they became aware of the April 2018 memo when it was announced publicly. So before or after the zero, and actually let me go back. Are you saying that CBP, ICE, and ORR lied to the GAO and that they were somehow aware and given advance notice?
No, I'm not going to suggest that anybody was not telling the truth. I'm saying that when we publicly announced the zero tolerance policy, it was pursuant to a public event in San Diego.
And so prior to the
Head
public
of
event,
ICE participated.
Mr. Whitaker, prior to the public event, these ICE, CBP, and ORR officials told the GAO that they had not gotten any notice. I'm not talking about once it was public, I'm talking about whether there was advance notice. Let me go on. Before or after the zero tolerance policy was put into place, and I call it the zero humanity policy, did the U.S. attorneys track when they were prosecuting a parent or legal guardian who had been separated from their child? There's only one answer to this. It's gone through the courts.
You know, did we track it?
Did you track when you were prosecuting a parent or legal guardian who had been separated from a child?
I don't believe we were tracking that.
You were not tracking it. That is the correct answer. And when parents are prosecuted and sentenced, they are in DOJ custody, correct?
Correct. They are their custody is transferred to the U.S. Marshals.
So these parents were in your custody, your attorneys are prosecuting them, and your department was not tracking parents who were separated from their children. Do you know what kind of damage has been done to children and families across this country? Children who will never get to see their parents again. Do you understand the magnitude of that?
I understand that the policy of zero tolerance.
Has the Justice Department started tracking parents and legal guardians who were separated from their children at the border?
The time of the gentlelady has expired. The witness may answer the question.
Congresswoman, I appreciate your passion for this issue, and I know that you've been very involved on the front lines of this.
This is about more than my passion. This is about the children's future, Mr. Whitaker. Please answer. Go ahead, please.
The witness may answer.
Congresswoman, the responsibility for the arrest, the detention, and together with the custody of the children was handled by DHS and HHS before those people were ever transferred to DOJ custody through the U.S. Marshals.
Thank you. The time of the gentlelady has expired. Ms. Demings.
Thank you so much, Mr. Chairman. Mr. Whitaker, I spent 27 years in law enforcement. I served as the chief of police. I took an oath just like you did, and I took that oath very, very seriously to uphold the Constitution and to protect this country from all enemies, foreign and domestic. I hope you took the oath that you took very, very seriously. But today, as I've sat through, and my colleagues right, this has been painful because I believe that you have worked to make our criminal justice system, to make a mockery out of it. And it's painful for me for you to do that, and anybody up to and including the President of the United States. But let me ask you this, and it's really been painful for someone who has been given so much responsibility, representing the men and women who have dedicated their lives to public service. That really means a lot to me. I hope it means a lot to you. Mr. Lieu asked you if you ever prove it. Mr. Lieu asked you if you ever communicated with President Trump about investigations in the Southern District of New York. Instead of answering, you referred him back to your statement, referred him back to what was written for you. But all you said is that you didn't make any, or statement that you didn't make any promises or commitments to President Trump. I want to know whether you talked to President Trump at all about the Southern District of New York's case involving Michael Cohen.
Congresswoman, as I've mentioned several times today, I am not going to discuss my private conversations with the President of the United States.
So yes or no,
did you? No matter what the question is.
Yes or no, did you discuss with the President Trump anything about Michael Cohen?
Congresswoman, as I have expressed several times today, I am not.
Did you ever have any conversations with the President about firing or reassigning any personnel, U.S. attorneys or others who work with the Southern District of New York? With the President or anybody at all? Did you ever have any conversations with anybody about reassigning or firing any personnel, including U.S. attorneys with the Southern District of New York?
Congresswoman, I sit on top of the Department of Justice, as you mentioned.
Did you ever have any conversations about anybody who works with the District of Virginia firing or reassigning? With anybody, not just the President, anybody at all?
Congresswoman, I am not going to talk.
Okay, so let's talk about the great 115,000 men and women who work for the Department of Justice, because I agree that they, is your words, extremely talented, highly principled public servants who are dedicated to upholding our great Constitution and the laws of the United States. I'm sure you're familiar with this because you keep up. At a rally last fall, the President said, look what's being exposed at the Department of Justice and the FBI. You have some real bad ones. You see what's happening at the FBI. They're all gone. They're all gone, but there is a lingering stench. And we're going to get rid of that too. Do you agree with the President's characterization of the Department of Justice and the FBI? As the Attorney General, please tell me why you would agree or why you would not agree with that statement.
Congresswoman, since I've become the acting Attorney General, I have reestablished a positive relationship between the Department of Justice and the White House.
Before you established that positive relationship, what was your opinion of the 115,000 men and women who dedicate their life to public service? Before you had your current position, what was your opinion of them?
I have actually a very high estimation of the men and women at the Department of Justice. They are the most exceptional, hardworking people that I have ever.
So you disagree with the President's characterization because they don't deserve it, Mr. Whitaker, and you are here. You supervise, you manage them. You don't agree with the President's characterization of them. Is that correct?
Listen, before, Congresswoman, in all due respect, I feel very strongly that as the acting Attorney General of the United States, that I have to set the tone for the entire Department of Justice. And what is so important.
If I worked for you, Mr. Whitaker, and you thought I was highly principled and very talented, and that was your answer when I was asked, or you're asked about how do you view the people who work for you, that's your answer, that's pretty pitiful. Let me ask you this. You've only mentioned drugs coming through the southern border, the problem at the southern border as characterized by you and the President. Could you please paint a picture of drugs flowing through our ports of entry? Because I'm told the overwhelming number or percentage of drugs that flow into our country come through the ports of entry. Do you agree or disagree with that statement? And if so, yes or no, why not?
The time of the gentlelady has expired. The witness may answer the question.
Congresswoman, we actually both agree. The ports of entry at our southern border are our most trafficked with drugs and illegality. It also comes in between ports.
Overwhelming of drugs come through the ports of entry. Do
On
you
our southern border, yes.
agree or disagree with that?
I believe that a tremendous amount of drugs come through our ports of entry on the southern border, yes.
Correa.
Thank you, Mr. Chairman. Good afternoon, sir. I wanted to ask you about your enforcement priorities. One of my jobs here in Congress is to serve on the Department of Homeland Security. And within that job, one of my most important critical jobs is to make sure our citizens are safe, to protect our nation against terrorist threats. In May of 2017, a joint FBI-DHS bulletin warned of a growing threat of violence posed by white supremacists, neo-Nazis, right-wing extremists, and other white nationalist groups. An extensive study of terrorist plots between 2008 and 2016 found that plots and attacks by white nationalist groups in the U.S. outnumbered the threats by Islamic extremists 2 to 1. White supremacist groups have been aggressively recruiting in our college campuses, and violent incidents involving these groups have more than tripled since 2017. More than 100 people have been killed or injured since 2014, and more than 60 in 2017 alone by these alt-right groups. Sir, just very basic question. Do you believe that white nationalism, white supremacists, extremists, or right-wing groups in this country pose a threat?
Yes, I do.
Is it growing?
Based on that report issued by the FBI, I have no reason, as I sit here today, to disagree with it.
Do you believe that the administration is placing enough of an emphasis, enough resources allocated, dedicated to stopping these kinds of homegrown terrorist attacks?
I believe that we are dedicating resources to the appropriate threats. That is done obviously below my role. It's done mostly at the line and the management level at the FBI and our other agencies, including our partners at DHS, as you mentioned. And I really, as I sit here today, I think we are adequately addressing the threats that we face, but we are always reallocating resources based on how those threats evolve.
Adequately addressing the threat, and you mentioned earlier in your opening statement, 30 convictions, hate crime convictions. Yet in 2017, an increase of 17% hate crimes reported, which they're usually underreported in this country. More than 7,000 hate crimes in 2017, and you have 30 convictions. Do you think you're allocating adequate resources towards prosecuting hate crimes?
I do, and if you look at some of the high-profile cases we've done, like the synagogue shooting in Pittsburgh, or the Charlottesville situation that we previously discussed, or even the case where we sent a prosecutor to my home state of Iowa to help prosecute a state hate crime. I think we have addressed the hate crime.
If you look at the number, 7,000 reported, almost 20% increase in 2017, 30 convictions. Adequate?
Congressman, we always work with our state partners and the local police to determine where is the best place and the most effective place to prosecute a crime. And so to suggest that somehow that those victims of those crimes don't receive the proper justice, I think would be a
I think I'm looking at it from relative, we're looking at foreign terrorism, and yet are we ignoring domestic terrorism?
No, we are not ignoring that.
So are we allocating the equal or more resources to domestic versus foreign, yes or no? Or
Again, Congressman, we allocate our resources based upon the threats and where the federal government should deploy those resources. And again, it's a very dynamic, daily evaluation as to where the threats are, and I believe we are adequately resourcing all of the threats, including the ones you described.
do you think domestic terrorism from white extremist groups is on the rise? And do you think we should allocate additional resources to combating these kinds of terrorist attacks in this country?
Congressman, I believe I already answered this question, but I just want to be clear. I agree with the FBI's assessment.
I'm sorry, I didn't hear your answer.
Okay, well, I believe with the FBI statement that those crimes are on the rise. I also believe that we have adequately deployed our resources on a daily basis, dynamically, as required by those threats. And I have seen it based on my intelligence briefings that I participate on almost a daily basis, and I know that the FBI and the other federal law enforcement agencies are adequately resourcing these threats in addition to all the other threats we face. It is a target-rich environment when it comes to law enforcement and making sure that
Sir, I'm
we go
running out
after.
of time. I'm going to say we're going to continue to look at this in Homeland Security because I believe that we're missing the ball here. In 2017, DHS terminated grant funding to look at some of these issues of domestic terrorism. We have to keep addressing this issue. Lives, the safety of our citizens is at stake. Mr. Chairman, I yield.
Ms. Scanlon.
Good afternoon, Mr. Whitaker.
Good afternoon.
In response to a question from my Pennsylvania colleague, you mentioned that the Department of Justice has been attempting to withhold federal dollars from so-called sanctuary cities. Is that right?
Well, yes, I talked about the Burn JAG
Okay,
grants.
thank you. And one of those cities is Philadelphia, right?
I believe so, yes.
I happen to represent Philadelphia. Isn't it true that Judge Mike Bailson of the Eastern District of Pennsylvania ruled that the Department of Justice's attempt to withhold this money was illegal and unconstitutional?
Congresswoman, that is the...
Isn't it correct that that was the ruling of the federal court?
Congresswoman,
Isn't it
I am
correct
not going to
that that was
discuss
the
an
ruling of-
ongoing litigation
Isn't it
matter.
correct that the federal court ruled that the Department of Justice's action was illegal and unconstitutional? That's a matter of public record, sir. Is it
Congresswoman-
correct?
Congresswoman, I don't disagree
Mr.
that a
Whitaker,
district
you
court
may,
judge
you
found
may be confused here. This may appear to be a contact sport, but it's not a gridiron, and I'm not letting you run out the time, okay? Isn't it true the federal court ruled that that was illegal and unconstitutional?
Congresswoman, again, this
Okay,
is
I'll take that as a
subject of
yes.
ongoing litigation.
Isn't
It
it
would not
also
be
true,
appropriate
Mr.
for me to
Whitaker?
comment about it.
Mr. Whitaker, I'm asking the question. Isn't it also true that the court found that the Department of Justice had not produced any credible evidence that undocumented immigrants committed crime at a higher rate than any other group?
Congresswoman, this is the subject of ongoing litigation.
Isn't it true that the federal court found that in a public opinion?
Congresswoman, I am not going to comment on
Okay, I'll take
ongoing
that as a
litigation.
yes as well. Let's move on to some other questions. And just to be clear, I'm asking oversight questions about your enforcement priorities during your tenure, okay, at the Department of Justice. I want to make sure we're clear on when that tenure began. I have a date of September 22nd, 2017, that you became Chief of Staff. Is that correct?
That is incorrect.
Okay, when is your first working date as Chief of Staff for Attorney General
I
Sessions?
started at the Department of Justice on October 4th of 2017.
Okay. And then you became Acting Attorney General as of November 7th, 2018?
The President tweeted that I was going to be the next Acting Attorney General on November 7th of 2018. The order that I have received from the President has the date of November 8th of 2018.
Okay, do you have a copy of that order?
I do have a copy of that order.
Can you provide it to the committee, please?
I'd be happy to. I
That
don't have
would
it
be
with me, though,
great.
if that's your question.
Okay, that'd be wonderful. Turning to some other enforcement priorities. On December 22nd, 2017, the Department of Justice sent a formal request to the Census Bureau asking for an addition to the census of a question asking about citizenship status. Did Attorney General Sessions direct the department lawyers to draft that request?
Congresswoman, the department is currently defending the Census Bureau in litigation on this issue across the
Did Attorney General
country.
Sessions ask, or are you refusing to answer the question?
I think it's inappropriate for me to comment about
Okay,
the subject of
would you-
ongoing litigation.
Okay, Mr. Chairman, I'd like to reflect that Mr. Whitaker hasn't answered the question, and I'd ask this matter to be addressed in the upcoming deposition. Let's see. Do you know if the President directed Department of Justice lawyers to make that request?
Congresswoman, this is the subject of ongoing litigation.
Okay, so you're not going to answer that
We are currently
question
defending in
either?
United States courts.
Thank you. Was Acting Assistant Attorney General John Gore involved in the drafting of that request to add the census question?
Congresswoman, as I've previously stated, this is the subject of ongoing litigation.
Okay,
We are
so we'll let the
defending
record
the
reflect
Census
that
Bureau.
again, you're refusing to answer the question. Okay, we can agree that one of the functions of the Department of Justice is to enforce the Voting Rights Act, correct?
Correct. One of the
Okay,
jobs
thank
of the
you. And
Department of
isn't it
Justice.
also true that the most recent Voting Rights Act enforcement action was filed on January 10th, 2017?
As I've mentioned previously, the department is
Is it
committed
correct
to
that the most recent Voting Rights Enforcement Act action filed by your department was in 2017, January 10?
Congresswoman, I'll give you an
It's a
example.
yes
where
or no
during
question.
the first term of the Obama administration, they filed, I believe, one
Okay, reclaiming my
Section 2
time,
voting
no running
rights.
out the clock.
I'm
I'll
trying to answer your question.
Chairman, if we can enter into the record the Department of Justice website, which reflects when the last Voting Rights Act case was filed, January 10th, 2017.
Without objection, the fact that that is noted on the website will be entered into the record.
Thank you. Isn't it true that under the Trump administration, the Department of Justice has reversed its position on at least 3 important Voting Rights Act cases?
May I answer the question? I see my time has
I
expired.
think there's a yes or a no.
The Department of Justice.
The gentlelady's
changed-
time has expired. The witness may answer the question.
Thank you. The Department of Justice has changed positions only in one voting case, and that's the Husted case. And the Supreme Court agreed with our new reading of the statute.
Thank you, Mr. Chairman. I have about 4 documents I ask for unanimous consent to be entered into the record. The first one is titled Crime and Murder in 2018, a preliminary analysis. The second one reads, Border communities have lower crime rates. The third one reads, amid crisis rhetoric, local leaders defend border region from misconceptions, and this is a report from the Rio Grande Valley in Texas. And then the last one is Progressive Times, Mission, Texas, Sheriff. Crime dropped 10% in rural Hidalgo in the last year.
Without objection, these documents will be entered into the record. The gentlelady is now recognized for 5 minutes.
So, Mr. Attorney General, what is it in your mind that leads you to conclude that the border region is crime-ridden when these documents that I just entered the record clearly show that Del Rio, Brownsville, El Paso, all the areas in the border region, and in fact, even El Paso is listed in the top 29 cities where crime has gone down that you quoted in your written testimony. If all of these stats show differently, why are you so insistent that this is a crime-ridden area? And I just, please, a short answer because I've only got 5 minutes.
I don't recall saying today that the border region is crime-ridden, but I will answer your question as fulsomely as I can. And that is that illegal immigration through our southern border is dramatically and negatively impacting the crime rate in our cities. It would be lower if we didn't have illegal immigration. I point to the example of Molly Tibbetts.
So you're talking about other cities, not the cities there, in fact, in the border areas.
Well, I think you would agree with me that most illegal immigrants that come in through our southern border don't reside at the border region, that they transit through there, then make their way to other parts of our country.
Well, I know many come to Houston because we've got good jobs and we're an open city. But I heard you say earlier, and maybe the word crime-ridden was not the exact word you used, but it was alluding to the fact that the border areas had a lot of crime. And I just simply don't agree with you. But let me move on to another topic in following up on some questions about the family separation policy or the zero tolerance policy. You said earlier in answering a question about some of your background that you were by a General Sessions side for a full year side by side, and you were aware of everything in the Justice Department separation policy. Is that true?
I served as chief of staff for 13 months, and I'm familiar with the zero tolerance policy, yes. I don't
Well, but you
understand.
said you were with him side by side, so can you tell us if you were in the room when it happened, when the actual zero tolerance policy was hatched?
I participated in discussions about the zero tolerance policy internally, but again, I'm not going to talk about the internal deliberations. The decision was to issue a zero tolerance policy.
But who is the brainchild of the policy? Who hatched it? I mean, where did it come from? We've never had it before and to the level that it's being executed now.
It was General Sessions' decision to implement, and he signed the memo implementing it and distributed that to our border district U.S. attorneys.
All right, so let me go on and ask this question. How many children are still separated from their families as we sit here today?
That's a number that only DHS and HHS would know. As I sit here, the Department of Justice isn't involved in handling children that are encountered at the border, whether as a family unit or as unaccompanied minors.
So you have no idea how many children might be? You've not seen any documents cross your desk from DHS or ORR or anybody else?
Again, those are different departments within the
No, I know
within the
that, sir,
executive branch.
but I know that you're the acting attorney general, and you get a lot of reports, a lot of documents, a lot of data. You've not seen anything to give us any idea just how many children have been torn away from the arms of their mothers.
No, I would have to refer you to HHS and DHS. Again,
Do you know how many have been reunited with their families?
Again, Congresswoman, those are not statistics that I'm involved in because those cases,
Again,
those
and
matters are being
you
handled
don't
by
have to
HHS
be
and
the one
DHS.
to write the little finger sticks counting the children. I just want to know if you've seen anything cross your desk or any member of your staff so that Americans who are just find this policy to be abhorrent and inhumane can have an idea as to when the children will ever be reunited with their families. You cannot tell us that today.
No, I would have to refer you to HHS and DHS, which would be responsible for the parts of the process. Because once we receive individuals for prosecution under the zero tolerance policy, we only deal with the adults.
All right, one last question, since I'm running
data.
out of time. At the State of the Union, the president said that he was going to make, and I'm paraphrasing, a priority to make sure that people with pre-existing conditions were protected. Does that mean that you're going to drop all the ACA litigation that you're involved in?
As you know, Congresswoman, that the Affordable Care Act litigation is ongoing in the
Well, I know
Fifth Circuit
that.
and
The
other
question
circuits.
is, are you going to be willing to settle it? Are you going to be able to drop some of that since the president is changing priorities and direction for his Department of Justice?
The time of the gentlelady has expired. The witness may answer the question.
We have a unitary executive, and if the president sets a policy and issues a policy directive, we will follow that policy.
Thank you.
Mr. Neguse.
Mr. Attorney General, thank you for being here. I also want to thank my colleague, the distinguished gentleman from South Dakota, on the other side of the aisle, for his support of criminal justice reform, and looking forward to working with him.
North Dakota.
North Dakota, my apologies. I look forward to working with him on criminal justice reform. I want to talk about another policy matter with respect to cannabis. I represent the state of Colorado. In Colorado, recreational use of marijuana was legalized in 2014. Today, more than half the states have legalized either the recreational or medical use of marijuana. Researchers at the University of Colorado, which I'm proud to represent, are working hard to understand the health effects. They're studying promising approaches that use marijuana to relieve chronic pain and the symptoms of Parkinson's disease. In August of 2016, I understand this is before you were at the Department of Justice, Mr. Attorney General, the DEA took a big step towards improving scientific research on marijuana when it submitted a request in the Federal Register for applications to produce federally approved research-grade marijuana. Several institutions have submitted an application that have yet to receive a response. What is the status of those applications, if you might know, and do you know if the Department of Justice and the DEA intend to support legitimate cannabis research that can help protect the health and safety of our citizens?
For the 3 months that I've been the acting attorney general, this is an issue that I've been aware of, and I've actually tried to get the expansion and the applications out. We have run into a very complicated matter regarding a treaty that we're trying to work around. We have some international treaty obligations that may not allow the way that marijuana has to be handled from the research facilities to the researchers, or the grow facility to the researchers. And so it is something that I am very aware of. It's something I'm trying to push. Unfortunately, I have 6 days left in this chair at the most. I don't know if I'm going to successfully get to it, but I understand the concern and know that we're trying to make it work.
I appreciate that and I applaud that. And if I could get your assurances that within the 6 days, if you could just follow up with the department staff to follow up with our office in writing, it'd be incredibly helpful for us as folks reach out. So.
Yeah, we'll try to get an answer as to the current status, but in my recollection of where I last found it is that the
Sure, no, that's sufficient. I want to make sure I get, thank you, Mr. Attorney General. You mentioned earlier that the public essentially learned that Attorney General Sessions was fired on November 7th, 2018 by tweet, and you were appointed via that same tweet. When did you first learn that Mr. Sessions was fired or would be fired?
I learned on November 7th, if that's your question. I mean,
It is.
Yeah, okay.
Okay,
Yeah,
so you learned by virtue of that same tweet that, that we all learned?
I mean, I would suggest, the only point I'd put on that, Congressman, I'm sorry to interrupt, but is that Mr. Sessions resigned, send in his resignation letter.
Understand. So did you have any conversations with folks at the White House prior to November 7th, 2018 about Attorney General Sessions resigning or being fired, however you would characterize that?
As is the longstanding practice of the Department of Justice and the executive branch generally, the president's entitled to confidential communications, and while I'm not confirming or denying the existence of any conversation, I'm not going to talk about my private conversations with the President of the United States.
We will follow up on that front with respect, or would ask the chairman to take that up in a deposition to the extent that one is noticed. Question around, you mentioned earlier in some of your testimony around the reasoning behind your appointment, that one of the reasons you believed in your view that you were appointed was to the position of acting attorney general was your experience as a former U.S. attorney, correct?
Yeah, correct. I spent 5.5 years as United States Attorney for the Southern District of Iowa.
Yes, sir. And you also mentioned that one of the reasons in your view that you believed you were appointed acting attorney general was that you've been at the Department of Justice for the last year or so, working as the chief of staff to Attorney General Sessions, side by side, I think you mentioned.
Yes, and I knew all of the active matters that we weren't recused from, obviously. I knew all the policies that we had not only implemented, but that were in progress. I knew all the people and the individuals, both inside the Department of Justice and the interagency.
Understand. I just want to reclaim my time here. So I appreciate that, and I guess the question I have is, I'm sure you're aware that Deputy Attorney General Rod Rosenstein is a former U.S. attorney, that he also has been at the Department of Justice, that he knows the people, he knows the matters, and that under the Vacancy Act, he was next in line in succession to be appointed Attorney General in the occasion of which that office was vacant, occasioned by Mr. Sessions' termination or resignation or what have you. And so I'm trying to understand why. I mean, were you surprised that you were appointed rather than Deputy Attorney General Rosenstein, that the ordinary rules of succession weren't followed?
It's been an honor of a lifetime to serve as the acting Attorney General, and I have, as I mentioned, 6 days left, and I'm going to take full advantage of that, including enjoying this hearing. But there are two different statutes that applied to the vacancy that was created by General Sessions' letter of resignation, and one was the succession statute by the Department of Justice, and as you know, the other one is the Vacancy Reform Act, which has been passed by Congress. And so my appointment, as is outlined in the 20-page OLC opinion, is legitimate and has precedent.
And I'm not, with respect to Attorney General, I was not referencing the legitimacy of the appointment. What I was saying is under the Vacancies Act, 28 U.S.C. 508, the Deputy Attorney General is the first assistant to the Attorney General, and so therefore would be the appropriate designee to fill that role. But with that, I yield back the time.
The gentleman has yielded back. McBath.
Mr. Chairman, I'm sorry.
Yes.
I just wanted to address that issue really quickly, just so we're all on the same page. The first assistant, together with any other Senate-confirmed individual, together with anyone that's served 90 days or less, 365 days at a senior position, is eligible to be, and there's no ranking or hierarchy of those three positions. Obviously, I'm in the third bucket as Chief of Staff. I just want to make sure we're clear on that.
Thank you. Ms. McBath.
Thank you, Mr. Chairman. Mr. Whitaker, I'm completely aware that North Carolina and Georgia were dealing with similar problems with voter suppression, and I can actually tell you I witnessed voter suppression firsthand in Georgia, even as I was running in my own election. Is it fair to say that the department was not remotely interested in securing the elections in North Carolina, rather that its intent was abusing its subpoena powers and wielding its mandate to protect our elections in a thinly veiled effort to suppress minority elections and populations?
The Department of Justice is committed to upholding the voting rights of all Americans.
I understand that. But what I need you to clarify for me is what actions were taken for all of the voting rights to be upheld? Because you stated earlier, your statement earlier was that you were side by side with Attorney General Sessions, advising him on all aspects of the department, yet you don't know, but at this point you're saying you do not suspect that there was any voter suppression. So what I'm asking is that, do you not know of any voter suppression, or do you not know whether or not those laws were being enforced?
I don't believe I said that I'm not aware that there might have been voter suppression. Is that something you heard me say?
No, I'm just asking you, might it be the case that you were not aware of any voter suppression?
Well, at the Department of Justice, I sit atop a massive organization, as you can imagine, and cases regarding voter suppression, voter fraud, or really any enforcement of the Voting Rights Act or other statutes is done by U.S. attorneys and FBI agents that are in the district doing those cases. And so it would be unusual that I would have specific knowledge about any of the evidence in those cases. So, obviously, we do our cases free of political interference, and if there is evidence of, as you suggest, voter suppression, and we can predicate an investigation, that is something we will seriously look at.
So did the department assess the need for election monitors in the 2019 elections?
I think I mentioned in my opening statement that we sent out 35 Civil Rights Divisions teams to, I believe, 19 states, if I remember right. I might be wrong, and I'd refer you back to my statement, but we did send out election monitors from the Civil Rights Division.
Okay, because I was in Georgia, and I can tell you, I saw the problems, but I didn't see the election monitors. Did you send any that you were aware of?
As I sit here today, I do not know if Georgia received what I'm describing. Obviously, the Civil Rights Division would have determined where those assets could be deployed. I know in the 2004 election, when I was U.S. Attorney, the Civil Rights Division sent, I think, 3 or 4 lawyers to my office to monitor the elections in Des Moines. So I wouldn't be surprised that they did send election monitors to Georgia.
Well, I can tell you, I really think that we needed them, and I'm very disappointed in the numbers that we received. We needed far more help than we got. But also on February 1st, the committee sent you a letter asking again for information on the department's voting rights enforcement. And these questions were asked by members during the 115th Congress, but were never answered. Will you commit to providing this information for this committee?
We try to respond to all the letters we receive from Congress. Obviously, February 1st was, I believe, only a week or so ago. I've kind of lost track of what day it is. But yeah, I mean, we will look at that letter and we will respond consistent with the way we respond to requests from Congress. But I mean, these are important issues, and I share your concern about some of these places where there is alleged voter suppression. And I know that we are going to enforce the Voting Rights Act robustly, and we will continue. Again, if there is evidence, we should get that to our FBI and the people that enforce these laws so we can properly predicate an investigation.
Okay, well, thank you for that, because if we don't get answers, I promise you we'll keep asking. Another question that I have is, let's see here. No. What steps did the department take to support election security efforts during the 2018 election? Specific efforts.
Are you talking about the actual voting devices?
Yes.
Or the responsibility for the security of the voting devices and machines is actually the responsibility of the Department of Homeland Security.
Mm-hmm. Can you tell this committee what those responsibilities were, those steps that were actually taken? Because I can tell you, there were many, many instances in Georgia, we saw over and over again, where people were not allowed to vote.
The time of the gentlelady has expired. The witness may answer the question.
Again, if there's specific evidence that crimes have been committed, we would be very interested in that at the Department of Justice.
Thank you.
Thank you, Ms. Stanton. Mr. Stanton.
Thank you very much, Mr. Chair, Mr. Whitaker. Thank you for appearing before us here today. Your time as Acting Attorney General is near end. After that, you may or may not be working for Department of Justice or another position within the Trump administration, but there are, of course, several congressional investigations that involve yourself. And I want you here today to pledge that you will answer any Inspector General questions and cooperate fully with his investigations even after you depart from your current position.
Are you talking about the DOJ Office of Inspector General?
Yes, the Justice Department's Inspector General is currently considering several congressional requests for information and investigations that involve you. Since you'll be leaving this position soon, I want you to commit here today in front of this committee that you will answer the IG's questions and cooperate fully with those investigations.
I'm happy to commit to that. I will cooperate with the Inspector General. Michael Horowitz is a fine DOJ career employee. I have the utmost respect for him. I think he's done exceptional work.
Excellent. Thank you
since
so
he's
much.
been there.
The impact of the government shutdown on the functioning of the Department of Justice, the law enforcement functions. Is it fair to say that the shutdown was devastating on the ability of the department to do their work?
The shutdown really was a difficult time at the Department of Justice because most of our employees are law enforcement and are accepted in their performance of their duties, and so they showed up every day like dedicated public servants and did their job, knowing that you here in Congress would ultimately pay them and come to some resolution of the shutdown.
We appreciate your recognition of that. I think every person up here in a bipartisan way would agree that the work of the rank and file members of the Department of Justice, FBI, the other law enforcement officials is outstanding. It seems appropriate then that the department did issue a memorandum saying that during the time of the shutdown, ancillary functions of the department that involve travel would be not allowed. Is that accurate?
I don't have that memo in front of me, but that is consistent with my understanding of our guidance in that regard.
On January 13th, 2019, in the middle of the government shutdown, did you travel to give a speech to the Heritage Foundation?
Congressman, this is an important question, but I want to be very clear. I have 24/7 security detail that drives me everywhere. And so the term travel, I'm not sure what you mean. I went to Capitol Hill to give a speech to the Heritage Foundation, yes.
Okay. Would you consider that activity, a speech to the Heritage Foundation, to be an ancillary function of the department?
Congressman, again, I had no other way to get to a speech that I had committed to give before the shutdown.
Thank you. The speech involved the topic of RFRA and the commemorate RFRA. In October 2017, during the time that you were Chief of Staff to the Attorney General, the Attorney General's office did issue guidance on federal law for religious liberty. The guidance involved expansion of exemptions to RFRA. At a religious liberty summit held in summer of 2018, Attorney General Sessions announced the formation of the Religious Liberty Task Force to further coordinate implementation of the guidance across the federal departments and agencies. It's fair to say that there's been limited public information on the task force and its work. The only public documentation is a 2-page memorandum issued establishing task force. Are you aware of any additional documents or guidance that further explain the task force mandate and processes?
No, I'm not familiar with any additional.
Do you know what the budget is of the task force?
I do not believe, as I sit here today, that we've actually effectuated the task force yet, and so I don't, it's going to be an internal task force that would have no specific separate budget.
Will you commit that during the remaining time that you're acting Attorney General to provide to this committee any additional details regarding that task force, which has been in place now for, I guess, 7 months or more?
Yes, Congressman, I will be happy to follow up in writing with you or someone from the Office of Legislative Affairs about that Religious Liberty Task Force.
Recently, HHS interpreted the RFRA to allow a Christian-based foster care agency that does receive federal tax dollars to discriminate against potential foster parent because they happen to be Jewish. Do you know if the Justice Department stands behind this HHS determination that a taxpayer-subsidized organization can discriminate against a Jewish individual?
I am certain that the Department of Justice will defend that position of a sister agency.
Thank you very much.
Time of the gentleman has expired. Ms. Dean.
Thank you, Mr. Chairman, and thank you, Mr. Whitaker, for agreeing to appear before us today. And I'm delighted to hear of your department's focus on the scourge of gun violence, and so I look forward to your full endorsement and support for H.R. 8, the Universal Background Check Bill. Today you said a couple of things that really touched me. You said that you have to set the tone of the department, and you said that the job you are doing now is the honor of a lifetime. All of us here can quite imagine that. I believe that actually you do, as the head, as the acting AG, set the tone for the department. Tell me, and this is not a negative question, it is just a factual question, how many positions did you interview for with this administration prior to you going to the Department of Justice?
As we previously explored with one of your colleagues, I had interviewed preliminarily for the position that ultimately Ty Cobb occupied, and then Emmett Flood, I think, currently occupies. And then I interviewed with General Sessions and some of his staff for the Chief of Staff job. So, in fact, I had never, after the election of 2016, I had never intended to come into the administration, but I was happy to be asked, and I explored opportunities, and those are the two that I interviewed for.
And in the meantime, in your private life, you became a commentator on CNN and other places, and you disparaged the Mueller investigation. Is that true?
I used my experience as a
Is it
United
true,
States
yes or no?
attorney. No, I wouldn't characterize it as disparagement, no. I think I tried to explain to the American people when I was on CNN and other outlets how the process worked, how the process for appointment, how the process for the
No, I'm not asking you about process. I'm asking you about the subject and the investigation and the validity of the investigation. We know, the record is public, that you did say very negative things in your private life, and you have said today you're not willing to take those back, so they stand. Your thoughts on the Mueller investigation are fully public, and they stand because you did not take them back today. How did you learn of the extraordinary honor that was bestowed upon you? How did you learn you got the job?
You know, I can't remember if it was which preceded which, but I believe I received a phone call from the President of the United States asking me to be the acting Attorney General.
A moment ago, you said you learned by tweet. Did I misunderstand you?
Yeah, I think you did.
Okay, so you learned first by a phone call from the President.
I believe so, but they were very close in time, and so I actually, as I sit here right now, I can't remember which preceded which.
Okay, and how long was that phone call? Was it just simply, I'm letting you know of this, or was there substantive conversation about your role?
While I'm not going to discuss the private conversations I've had with the President, I think it's important that he is entitled to that confidentiality from a cabinet secretary, even acting like I am.
Okay, and
I will tell
following
you
your-
that it was not a substantive phone call.
It was an honor phone call, probably. And following that and the tweet, when did you next meet with the President about your job? Because it's during this time you have to
Congressman, I don't
decide.
remember.
It's during this time, in that month or more, that you have to decide whether or not to recuse, am I right? So how many times did you meet with the President prior to your decision not to recuse?
Congresswoman, while I'm not going to discuss any meetings that I've had with the President nor conversations, I will tell you that I interact with the President on a regular basis, including after I was appointed acting Attorney General.
You said you set the tone for the entire department, and so you had to carefully consider whether or not to recuse yourself from any dealings
Yeah, I
with the Mueller.
spent 5 weeks. I spent 5 weeks considering
determining
that
that.
question.
And you got information from two sources that we know of. Career officials at the Justice Department recommended you recuse yourself to avoid the appearance of a conflict or bias. Is that correct? And that was on December 19th. To avoid even the appearance of a conflict or bias based on your previous statements. Is that correct? Is that the advice you got?
Congresswoman,
It's
I
a
would-
yes or no. Please, my time is running
Congresswoman,
out.
I would just point you to the
And
letter.
I've waited a
It's
long
more
time.
full- it's a more-
Please,
it's
it's
a
a
more
yes or
fulsome-
no.
This question is not a yes or no question because you have to understand how it was my decision to make. The career
No,
ethics
no,
officials
I'm not talking
told me
about your
it was
decision. I'm
my
talking about
decision to make.
the guidance that you received,
It
not
was
your
not
decision.
their decision to make because
No, no, no. I'm asking you factually about the guidance you received. Career officials told you you should recuse to avoid even the appearance of an impropriety, a bias, and you set the tone for your department. Am I correct?
Congresswoman, they told me it was a close call. They said it could go either way, and they said
So to set the tone, you think on a close call, you go the other way?
as the Attorney General and not to bind my successors, yes, I believe on a close call as the Attorney General of the United States that I made the right decision. It was my decision to make.
And yet you had career, have I lost my time, Mr. Chairman?
Yes,
Oh,
get this question out, I'll let him answer it, that'll be that.
would you be able to provide us the written guidance that you got from the career professionals in terms of recusal? They recommended recusal. Would you please provide this committee that written document?
Congresswoman, that would require me to provide you internal deliberations that are not typically provided in this relationship, but I can tell you As we sit here today, I did not receive any written advice from the career ethics officials.
Time of the gentlelady has expired.
Thank you, Mr. Chairman.
You're welcome. Ms. McCarcel-Powell.
Thank you, Mr. Chairman. Mr. Whitaker, I want to go back to your time when you worked for the Foundation for Accountability and Civil Trust. I worked for many, many years for various 501c3s. So it's very interesting to me when I look at the board, is this a private or a public foundation? Fact, was that the 501c3? Is it a private or a public?
I don't know.
There are two separate types.
Congresswoman, I don't have the 990 filings or
But you
any of
worked
those
there
documents.
from 2014 to 2017.
I was
And
there.
you were the executive director for the foundation.
Yes, I was.
But you don't know if it's a private or a public.
I haven't worked for FACT in 16 months, and in my preparation
Okay,
for this
thank you,
oversight
Mr.
hearing,
Whitaker.
I didn't review their filings, so I don't know which box we
Thank you,
checked.
Mr. Whitaker, thank you. Were there only 3 board members in this 501c3?
I believe there were 3 board members.
William Gustav, Neil Corkery, Matthew Whitaker, correct?
Yep.
Okay. So it's also my understanding that you filed numerous FEC complaints while working there?
All of our complaints were posted online. and,
Were they
I
FEC
don't-
complaints, Mr. Whitaker? You filed
We
FEC
filed
complaints?
we filed many different types of complaints. That
Did you file
were very
FEC complaints?
similar to
It's
Peru.
very, you worked as the executive director of this 501c3. Did you file FEC complaints? Very easy.
Yes,
Okay,
we
thank you.
filed
Okay.
FEC complaints in addition to
And,
others.
and who made the decision to file these complaints?
I was the executive director. I believe I signed all, if not all, of those.
Did you
complaints,
make the
so-
sole decision to file these complaints, or were
Yes.
you directed
No,
by
I
any?
was not directed. I was the
You did that on
executive
your
director.
own?
Yes, we were an independent, nonpartisan
501c3, nonpartisan. you
ethics
said.
watchdog.
It's a,
Yes.
it's a nonpartisan. Did you file any FEC complaints against any Republicans?
As I sit here today, I don't recall, but I mean, all of our
Okay,
complaints are posted online.
thank you, Mr. Whitaker. I would like to ask for unanimous consent to make part of the record the restriction of political campaign intervention by Section 501c3 tax-exempt organizations, and it reads, under the Internal Revenue Code, all Section 501c3 organizations are absolutely prohibited from directly or indirectly participating in or intervening in any political campaign on behalf of or in opposition to any candidate or for elective public office.
Without objection.
Thank you. I have some other questions here, if you give me some time. All this time I'm waiting and I can't find the questions. No. Thank you. This pertains to also an issue that's very close and dear to my heart, LGBTQ issues. In October 2017, the Department of Justice withdrew a 2014 memo, which stated that the best reading of the Title VII's prohibition on sex discrimination in the workplace encompasses anti-transgender discrimination. The new memo instructs the Department of Justice attorneys to now argue that federal law does not protect transgender workers from discrimination. Are you familiar with both memos?
Yes, I am familiar with those memos that do not extend Title VII to LGBT.
Thank you. And at the time of the reversal, were you serving as the Chief of Staff for Attorney General Sessions, correct?
I served as Chief of Staff from October 4th of 2017 until I was appointed Acting Attorney General in 2018.
So who ordered the reversal of this policy?
I'm certain it was Attorney General Sessions who sets the entire policy for the Department of Justice.
And who drafted the new memo?
As I sit here today, I don't have any idea. That would be deliberative work done by, I'm sure, many people at the Department of Justice.
Any outside groups that were involved in the process?
Not that I'm aware of, but again, I wasn't
And
directly.
do you stand by the department's decision to reverse its position that Title VII protects transgender people from discrimination?
Congresswoman, I think a plain
Please just
reading-
answer the question. Do you
Congresswoman-
stand by the department's decision to reverse its position that Title VII protects transgender people from discrimination?
If Congress wants Title VII to extend to transgender people, you can change the law. We cannot read into something that is not
Okay,
in
so I
the
take
law.
that, yes, okay. Do you believe that members of the LGBT community should not be protected under federal discrimination laws?
Again, Congresswoman, I personally believe that discrimination
Mr.
of any
Whitaker.
kind shouldn't happen,
Yes
but I will
or
tell
no,
you
please?
that Title
I don't have
VII
much time. Do you believe that members of the LGBT community should not be protected under federal discrimination laws?
the plain
Yes or
reading-
no?
The plain reading
Yes or no?
of Title VII
Yes or no?
does not extend
Okay, thank you.
to transgender, and you uniquely control what is the law. We merely enforce the law.
Do I still have time, Mr. Chairman?
Gentlelady's time has expired. Ms. Escobar.
Thank you, Mr. Chairman. Mr. Whitaker, this hearing began this morning at 9:30. I've been waiting almost 6 hours. It's nearly 3:30 in the afternoon. I've been waiting nearly 6 hours to ask my questions. I'm going to ask you for a favor. Out of respect for this committee, out of respect for me as a member of Congress, I'm going to ask that you try not to run out the clock and that you please answer my questions with a yes or a no. And if I have a follow-up, that you please answer the follow-up as succinctly as possible.
Congresswoman, with all due respect,
I'm sorry, excuse me. If
I'm
I
going
could,
to answer, with
if
all
I
due
could
respect,
please
I'm
get
going to
my
answer your
statement out,
questions.
sir. I've watched you do that to every member on this committee.
Because a
I'm
lot of
asking
questions
that
don't
you
have yes, no
please-
answers.
Time belongs to the member.
Thank you. I represent El Paso, Texas. I live on the safe, secure, vibrant U.S.-Mexico border. Unfortunately, my community, one of tremendous goodwill and generosity, has been ground zero for many of this administration's cruel, anti-immigrant, anti-American policies, including family separation, child detention in tents, the ongoing prevention of asylum seekers from stepping foot on American soil at our ports of entry, and in December, the death of 2 immigrant children in U.S. custody. Earlier, you said you believed every life is valuable, and I would hope and assume that that includes the lives of the most vulnerable among us. There is a new policy that is about to, unfortunately, be rolled out in my community called the Migrant Protection Protocol, which I believe is a misnomer for a dangerous and, in some cases, deadly, and I believe also an illegal policy that allows our government to return migrants and asylum seekers back to Mexico while they await their asylum hearing. Here's my question. Because the Department of Justice oversees the Executive Office for Immigration Review, will the Department of Justice ensure that asylum seekers have access to counsel in Mexico in order to allow them to prepare for their hearings? Yes or no?
We're going to continue to follow the policies at EOR that are currently in place.
Will you facilitate, assist, help ensure that asylum seekers have access to legal counsel in Mexico? Yes or no?
Congresswoman, there is a very well-defined process for asylum seekers to obtain counsel, and we're going to continue to follow that. Of course,
Mr. Whitaker, even while they're in Mexico?
as the acting attorney general, I cannot make an assurance, especially regarding what happens in a foreign country. I mean, I know you understand that.
And this
but-
is part of the reason why this is such a terrible policy. Another question. About a week after the policy was announced, reports surfaced that immigrant rights advocates and attorneys were denied entry into Mexico. The attorneys said their passports had been flagged, and reports also indicated that this was not an issue on the Mexican side, but it was on the U.S. side. Did the Department of Justice have anything to do with flagging these passports?
Congresswoman, I'm not familiar with the situation you're describing, but I'm happy to look into it and get back to you.
Thank you. Another question related to this issue. Does the Department of Justice have an immigrant advocate watch list?
Congresswoman, I'm not aware of the question you're asking me, the answer to it, so I'm happy to look into it and get back to you, but
Thank you.
that's
I
not something
appreciate
that
that.
sounds familiar and that I prepared for today.
I look forward to the answers to those questions. Now, switching gears a little bit. At the President's State of the Union address, he claimed that my community, El Paso, Texas, quote, used to have extremely high rates of violent crime, one of the highest in the entire country, end quote. And he claimed that we became one of the safest communities in America because of a wall. Data from the FBI's Uniform Crime Reporting Program shows that El Paso has historically been one of the safest communities in the nation, and that we were such long before a wall was constructed. Do you have any reason to disagree with the FBI's Uniform Crime Reporting data?
Congresswoman, we use the UCR on a regular and ongoing basis to not only know where our crime hotspots are, but to also put our resources at the Department of Justice.
Sir, that's not my question. Let me repeat my question.
Okay.
Do you have any reason to disagree with the FBI's Uniform Crime Reporting data?
Congresswoman, I think the UCR.
Do you have any reason, sir, to disagree with your FBI's data?
As I sit here today,
Yes or no?
I do not have any reason
Okay,
to disagree
great.
with the FBI's data.
Thank you very much. Switching gears again. Did you ever create?
The gentlelady's time has expired. I'll let her finish this one question and.
Thank you, Chairman. Did you ever direct the creation of, see, or become aware of the existence of any documents relating to pardons of any individual?
I am aware of documents relating to pardons of individuals, yes.
The gentlelady's time has expired. I'm going to ask one question to follow up on the gentlelady's. Sir, since it is, black letter law that someone in the United States may apply for asylum, that any person who applies for asylum and states a reason, therefore, is entitled to have that claim adjudicated, that person is entitled to legal assistance as that claim is adjudicated. Doesn't it strike you that a policy that says that people who set foot on American soil and claim asylum will be sent to a foreign country where they may not have access to legal help, which they are constitutionally guaranteed for their asylum adjudication, may have a constitutional problem?
Congressman, I'm sure you're aware that federal law allows asylum seekers to be returned to a safe third country.
I'm not aware, though, that it allows people not that allows the government to do something that effectively eliminates their right to counsel for their asylum claim. This concludes today's hearing. I want to thank all the members who are still here for their patience and their fortitude. I want to thank Attorney General Whitaker for appearing today.
Mr. Chairman,
Ms. Jackson-Lee.
and thank you. I'm not asking, I'm putting these questions on the record.
Excuse me, submit them for the record.
Yeah, I will set them for a record regarding.
Without objection, the questions are admitted.
And the
Before
article, and three articles for the record, GQ, Washington Post, New York Times, and also an article by Shane Croucher.
Without objection, the articles are admitted. Before we adjourn, I want to note for the record that, Mr. Whitaker, that you owe us responses on a number of issues raised here today, responses that we intend to secure, including but not limited to the times and dates you were briefed on the special counsel's investigation, your communications with the president after you received those briefings, the basis for your statement that the special counsel's investigation is reaching its conclusion, and whether you told the special counsel not to take any specific investigative or prosecutorial steps. I would also note that your testimony was at best inconsistent on the topic of your communications with the White House prior to your tenure at the department. It is not credible that you both interviewed for a job handling the president's response to the special counsel's investigation and never conveyed your opinions about that investigation to the White House. We require answers to these questions. I ask the department to work with the committee to provide them. As part of that work, I fully intend to call you back for an interview under subpoena if necessary, and I expect more fulsome answers at that time. Without objection, all members will have 5 legislative days to submit additional written questions for the witness or additional materials for the record. And with the thanks of the chairman, the hearing is adjourned.
And with
with that, nearly 7 hours after it began, the House Judiciary Committee gavels out this oversight committee into the Justice Department, but more pointedly, hearing from the acting Attorney General, Matthew Whitaker, about his brief time as the acting AG. You've been watching live coverage from the Washington Post. I'm Libby Casey, and I'm joined in our studio by Matt Zapotosky. Let's start at the end, Matt. Okay. Jerry Nadler, the chairman, promising to try to dig deeper, but we do expect Mr. Whitaker to only serve in this job for another week or so more. So how much digging can Chairman Nadler really do?
So he raised some good questions to which I also would be curious to know the answers. I'm not sure how willing, even if he were to stay in the job, Matt Whitaker would be to providing those, particularly on the question of his communications with the White House after his special counsel briefings. I'm not even sure he would really want to get into his particular special counsel briefings. But after he leaves, it's hard for me to envision a world where the Dems really have an appetite to get him before. The person who would then be answering questions about the Mueller investigation would be Bill Barr if he's confirmed next week. So, if he's out, certainly they could keep pursuing this. Congress calls private citizens to testify. That does happen. He could try to subpoena him to force this issue, but I do think politically the appetite might be a little less after he leaves.
You got a lot of frustration from Democrats as they were trying to get answers, and you even saw with the final Democrats who were asking questions, like Veronica Escobar, Congresswoman from Texas, saying, "Please let me ask my questions. Don't interrupt me." And then he still was sort of trying to filibuster a little bit, even as he responded to that request that she made. So they went into it with a lot of heat and energy, but they were also getting frustrated because they just weren't getting answers, and they weren't able to achieve a lot in their 5 minutes of time.
Absolutely, and I think they were getting particularly frustrated because every question he would kind of pause and think, and that's of course what you would want someone to do. You'd want him, and then it would be, "Thank you, Congresswoman, thank you, Congressman," and he would sort of lead into his answer, not saying yes or no, and repeatedly they were saying, "This is a yes or no question, this is a yes or no question." Sometimes maybe not so fair, there's important context, it's not so simple as saying yes or no. You can really try to get a gotcha moment by pinning someone down to a binary yes-no when it's more complicated. But other times it was kind of surprising. It's like, that was a yes-no question, you had a yes-no answer that you eventually got to, and it wasn't that damaging for you. Why didn't you just go to that? That was clearly frustrating the Democrats.
Matt, there was criticism by Republicans that this hearing was not looking at oversight, but was digging into Matthew Whitaker himself. But lo and behold, as it went on, Democrats did talk about a lot of oversight issues. Now, we pointed out earlier that the Mueller investigation is it falls under that umbrella of oversight, so it's absolutely fair game in this hearing. But Democrats pulled at other threads, and they wanted to know about child separations. They wanted to know about other issues of the border, like claims by the Trump administration about the dangers of the border. We saw a number of members of Congress who represent areas along the border talk about how safe their areas are and try to contradict and get Whitaker to be pinned down on some of the lines that have come out of the White House that officials at departments like DOJ or DHS have totally not backed. The White House may say things that their own data doesn't show. Do we get a sense, did we learn anything about some of these issues, these oversight issues the Democrats were bringing up?
Well, one, I was struck that Democrats were doing this. They didn't focus like a laser on the Mueller probe. They focused towards the end. There are a lot on border security, a lot on family separations, and they really held Matt Whitaker's feet to the fire. I was struck by this line of questioning. Did you, the Justice Department, track children who were separated from their families, because that might have been very helpful. Matt Whitaker's response to that was, look, they get separated before they come into our custody, even though it's our policy that kind of affects the separation. But it's a really interesting.
It is a shocking thing, though, to think about not tracking children. Like, where are the children and how can you keep track of them?
And even if it is a different agency's responsibility, just to get a top law enforcement official to be like, well, not my problem, that's a DHS thing or that's an HHS thing. Another thing they were driving at was like the lack of coordination between all of them. They were asking him, hey, there was this leaked memo that said that really critical to instituting this policy is talking to HHS and DHS, and you really didn't do that. And then he starts, talking about this press conference they had unveiling the policy. He was very much saying, this is our lane, this is DHS, this is HHS. But those are legitimate oversight questions. I mean, that's exactly what you would want the Judiciary Committee to be doing. If he were going to stay in the role long term, that could have a lot of impact. I mean, this is kind of the the catch-22, like, you do legitimate oversight functions with him, he's out, so what does it matter? But you don't, and then Republicans say, oh, we're not overseeing the Justice Department.
Another issue that came up from Congresswoman Lucy McBath was about voter suppression. She talked about witnessing what she described as suppression tactics and concerns that she saw during the 2018 election. That's another question of oversight that's absolutely in the purview of the Justice Department and the Acting Attorney General. We didn't get a lot of answers there. We didn't get a lot of depth from him about concerns that she was raising.
Yeah, I mean, this Justice Department, to the extent they've been focused on voting rights, it's been a lot of concern about illegal immigrants voting,
Like
and that
voter
kind of
fraud
thing,
rather than voter suppression.
Like that. Yeah, and I mean, this is an area of great concern to Democrats that this Justice Department hasn't been sort of as keenly focused on. Whitaker did say, I think at one point, look, I'm very aware of what's happening in North Carolina, but you know, this has not been in their wheelhouse because President Trump doesn't really see this as important. He's much more focused on sort of these false claims about millions of illegal immigrants voting.
Did we learn anything new today about the Mueller probe or about the Acting Attorney General's relationship to the White House?
I think so. We didn't learn anything substantively new about the probe itself. I was hoping, and Representative Nadler brought this up at the very end, we would learn more about what led you to say we're close to the end. You know, do you know there are no more indictments? Maybe it was a pipe dream to hope that he would answer specifically. The best he gave on that is, I wasn't speaking necessarily for Bob Mueller, but I was speaking as the Acting Attorney General, and I took that to mean, look, this isn't just me being a pundit. This is me being the Attorney General. I know about this stuff, but he didn't give us any clear sense of the timeline or anything. We learned a little bit about his relationship with the White House, but not a ton. It felt like we learned all the instances where the White House didn't intervene, and then when there maybe was a time that they did, he just said, I'm not talking about it. I was particularly struck when it came to Mueller. He said, I've had no communications with Trump since I've been in office. And then people asked him about SDNY, the Southern District of New York, and the Cohen case. And he disputed a CNN report that said Trump lashed out at him after hearing of some developments in the Cohen case. But he wouldn't say if him and President Trump had ever talked about the Cohen case. That would have been really great to know.
So it's denying the lashing out, which
Right.
of course is subjective.
Right.
But not really getting to the heart of, did you talk about it?
Yeah, absolutely right. I mean, lashing out, what does that mean? That certainly is open to interpretation. And he might say, well, I didn't feel it was lashing out, but was President Trump frustrated? What exactly did President Trump say? You know, I guess it's possible that the report is wrong, but you would think if that were the case, as he did when addressing the Mueller probe, he would have said of SDNY, no, we never talked about that, and he didn't do that.
Reporter Rhonda Colvin is live on Capitol Hill. Let's go to Rhonda. Hi, Rhonda.
Hi, Libby. Yes, as an eyewitness to this hearing, my takeaway today is that this was certainly highly contentious, and I know you all have the same takeaway. If you've watched this throughout the day, the morning, the afternoon, it was very contentious. One of the more memorable moments of contention was a tense exchange between Representative Sheila Jackson Lee and Whitaker, and she talked to us after that exchange and told us her thoughts. Here's what she had to say.
Well, obviously, he came with an agenda to ignore, how should I say it, disrespect, and not take this oversight hearing seriously. That's shameful and somewhat reflective of the Trump administration. Yes, he is the acting Attorney General, but he is the only one that has ascended to that very high office without a Senate confirmation. So he's using smoke and mirrors, but this is not going to be the conclusion of this hearing. If we find that he has perjured himself, he will have to answer to this committee. My point that we did not reach, that I hope to reach, what did he have to do with Jeff Sessions firing? He was the chief of staff. Who was he talking to about Jeff Sessions firing? Why was it so convenient for the administration to choose him, a person that they would not put under or indicate that they did not have to subject him to Senate confirmations, but moved him immediately into the position to the extent in the dark of night we saw him as the former Attorney General left in the dark of night with a great deal of sadness his post as the Attorney General of the United States. To me, that looks like a conspiracy as clear as day. Why was he so involved? Why was he the one present to send Attorney General Sessions off And why was he so well placed to immediately ascend to the position? As far as I'm concerned, it was all planned.
Now, we also talked to her colleague, Democratic colleague, Representative Deutsch from Florida, in the hallways in one of the breaks, and he had similar thoughts as well as how things went today. He said, you know, this kind of invites more questions than it answered today, and again, there was disappointment from Democrats on how this all went, and there was questions on if they learned anything new. Now, on the Republican side, throughout the day, there were many calls, especially by one of the ranking members of the committee. He kept asking, why is Whitaker being subjected to these questions when this is not a confirmation hearing? This is not something to give him the job. He is likely going to be leaving this post in a matter of weeks. So Republicans were very frustrated. If you notice, toward the end of the hearing, some of them weren't in their seats anymore. So on their side as well, they don't know what this accomplished. So that's a wrap from here. Back to you in the studio, Libby.
Rhonda, were Republicans successful playing defense today?
Sort of. I was kind of impressed with Collins sort of stepping in. He had a particularly tense exchange with Swalwell at one point where Swalwell is asking about the funding sources for this nonprofit that Matt Whitaker worked for before, long before he came into the Justice Department and got very wealthy. And Collins steps in to say, well, this doesn't have anything to do with oversight. And there's a testy exchange, and Collins kind of throws up his hands like, I know I'm outvoted, so this doesn't matter. I mean, they did step in, and if nothing else, they accomplished making it a bit of a circus to drive home that point that, hey, is this not really about oversight? Is this about embarrassing Matt Whitaker? The more you get those procedural votes and motions and things, I think that helps their point that this is a bit of a circus, though, they were the ones often driving that, particularly in that instance.
Representative McChrystal Powell, towards the end, was asking about this organization that he worked for, this 501c3 that he was the executive director of, and she asked some very basic questions that he sort of pled ignorance on, which seemed unbelievable because he was the executive director. At one point he said, well, I haven't worked there for 16 months. Like, that's like ancient history or something. And she was trying to get at the point that this was a group that, even though it was billed as a nonpartisan group and it was categorized that way for important tax purposes, it only went after Democrats. It really wasn't critical of Republicans. And that was significant to Democrats on this committee because of the job he was then chosen for.
Absolutely. He made a lot of money working for there. I think he might have been the only employee, and he made $1.2 million. Democrats are still concerned about the funding source. He said it was sort of this broader libertarian group that funds groups like that, but they're saying, well, but who were the donors to that? Where really did this money come from? That's a big concern for Democrats, and it's an interesting question. I mean, the guy made a lot of money before he came into the Justice Department. Might have been his most lucrative job before he came into the Justice Department.
Matt, final thoughts on what we walk away from today with, and on two fronts, learning anything new from the acting Attorney General, but also setting the table for the fights that are to come in the weeks ahead.
Yeah, so I think two avenues. We learned that he really feels like he hasn't done anything wrong, and the sort of trajectory he was trying to set is like, you all were concerned that when I came in, because of what I said about Mueller in the past, I was really going to step in the way of this investigation, and that just didn't come to pass. The president never tried to get a commitment out of me. I never offered one. We didn't even talk about the Mueller case. I'm sort of in the right here, and I'm going to leave the Justice Department next week feeling like I did the right thing. Democrats would certainly probably agree with most every word of that, or at least raise questions about most every word of that. But that was one thing I was struck by. Mm-hmm. And the other thing, I think, is he is trying to set the stage for Barr to have an easier time. One thing I was particularly struck by is when he's talking about his recusal, his non-recusal, I should say, insisting this is my call. I don't really care what career ethics officials said. Their advice was kind of waffly. And you know what? At the end of the day, it's my decision. I'm not stepping aside. And he was sort of pressed on that, like, really? This was a close call and you decided to set the tone for the department? You would stay in charge? And he said yes, because he didn't want to set a precedent for future attorneys general. And I think that's particularly important with Barr coming in, a guy who's written a memo that's critical of one of Mueller's theories in his case, who's been somewhat publicly skeptical of various aspects of the Mueller probe, he can come in now and say, well, this guy didn't recuse, so clearly now I don't have to. Maybe the ethics officials would even advise something different. I think Matt Whitaker sees that as a part of his legacy, and while it doesn't win him Democratic points, him standing up there and saying that might win him Republican points and might win him at least Barr's support.
So if you're Matthew Whitaker, do you leave today's hearing feeling a bit of relief? I mean, the man went through about 10 bottles of water in the course of that hearing, so there was definitely some treading water below the surface there. But do you walk away with a feeling of relief of like, I survived this?
I am
gauntlet?
sure he's glad it's over, and I'm sure, while he said that he has loved serving in this position and it's an honor to serve in this position, I am sure he will be glad next week to be out of this political hot seat. Maybe entirely, but who knows if they are continuing to try to subpoena him, he might not be totally out of the hot seat.
Matt, one question I have is just how Democrats are going to walk away from this feeling. Cable news was all over this as we were broadcasting live. A lot of the cable channels were also monitoring this continuously and showing big extended clips or whole chunks of the hearing. And I wonder how Democrats are going to feel like they came off. What were they able to achieve? What were they not able to achieve? And how is their tone perceived by the American public? Right? Does the public come at this thinking they were hitting this hard and digging into questions, or is there frustration as they watch that Q&A, feeling like the punches weren't landing, or that Democrats weren't using their time in the best way they could have?
Yeah, to my mind, they definitely got some blows in, and he definitely came off as frustrated at times. But Republicans sort of also scored points in making it seem like a circus. We'll see how it plays in the coming days. And another thing that I think we maybe don't think of enough in real time is this creates like a transcript and creates a record and pins Whitaker down to things under oath. You remember when Jeff Sessions went through his confirmation hearing, and this wasn't a confirmation hearing, but when Jeff Sessions went through his confirmation hearing, everybody thought, wow, he did a good job, he said all the right things, and then it turned out he had kind of misled Congress about his contacts with a Russian diplomat. I think there's going to be a great effort now in the coming days to see, are there any sort of provable misstatements in what Whitaker told Congress, and that in some ways is maybe even more important than just sort of how it plays on cable news.
Absolutely, and that may take days, even weeks, to really come to fruition, to see where everything goes. Matt Zapotosky, thank you so much for joining us throughout the day today. National security reporter covering the Justice Department. I'm Libby Casey. Thank you for watching the Washington Post live coverage of this House Judiciary Committee hearing. We'll continue to cover hearings as they roll out here in the 116th Congress. You can subscribe on our various platforms if you'd like to be notified of future programming. Thank you for watching, especially on such a busy news day. Thanks so much. Have a good day.